and good morning. I'm honored to be giving a presentation this morning in front of the experts in ADR, including mediation. On behalf of Korea International Mediation Center, KIMC, I'd like to thank ADB and ADBI for organizing this wonderful gathering. As Professor Sharma gave a wonderful presentation with colorful slides yesterday, I thought that I should follow him as I have done so with studying mediation. Next slide, please. However, I'd just like to share with you only one page slide. This cartoon is hanging on the wall inside a mediation room of KIMC. I purchased it when I was studying in Cambridge, England, some 40 years ago. At that time, I got it just because it looked funny. After I searched it with the help of AI Copilot early this morning, I found that it is jurisprudence drawn by H.M. Bateman, dated in 1924. I did not realize that this print would be related to my mediation working later. At that time, I was studying international economic law. This print literally shows a decision made by a judge who would follow the direction of the feather falling off from his nose. Of course, I do not believe in the existence of such judges or arbitrators who make such win-lose decisions. On the other hand, however, this print importantly implies that those disputes would be better settled by the parties through negotiation or further mediation with the help of mediators. This morning, my theme of presentation is promoting international commercial mediation and institutional cooperation in Asia. Recently, international commercial mediation, which can save time and cost and maintain business relationships, has been gaining attention as a preferred means of resolving international commercial disputes even in Asia. There might be several explanations for this trend. Mediation has been considered inferior to arbitration just because mediated agreements may not be enforced as such, unlike arbitral awards. This conventional wisdom may not be sustained further in that such mediated settlement agreement compliant with the Singapore Mediation Convention may be enforced in a party to the convention. Mediation is also a preferred tool for resolving international commercial disputes, as it is not concerned with the application or interpretation of law, but primarily concerned with the disputing parties' interests and the preservation of their business-friendly relations. Further, Asia has the potential to lead this field as it is an important center of global trade and investment. While actionable strategies to strengthen the mediation system and interinstitutional cooperation in Asia are discussed here, I'd like to suggest some thought to this effect. Before that, I'd like to very briefly introduce KIMC to you. KIMC was established a month later of the entry into force of the Singapore Mediation Convention, and thus it is really a young institution. As Professor Sharma kindly mentioned yesterday, KIMC is registered with the Ministry of Trade, Industry and Energy, as it believes that international commercial mediation serves primarily business users, not legal users. KIMC is also conducting an early dispute resolution program, that is mediation over international or business cases in cooperation with Seoul Central District Court, the biggest court in Korea. Overall, KIMC intends to establish an ecosystem where more businesses and lawyers in Korea understand properly and use eagerly mediation internationally as well as domestically. Now, there are some suggestions on certain actions for international mediation centers in Asia. First, there is a need for an innovative approach that is transition from ADR to NDR. Alternative dispute resolution, ADR, is still a popular term as all of us understand it, though we need to pay more attention to negotiation-based or negotiated dispute resolution, NDR. As some of us may know, NDR was presented in the 2022 United Kingdom Commercial Code Guidelines. NDR encourages disputing parties to reach a solution through direct negotiations without relying on the decision of a court, highlighting the non-adversarial approach to dispute settlement. Mediation, whose core element is negotiation, can have equally tangible and impactful outcomes like arbitration or litigation, as it empowers the parties involved to find solutions together rather than having decisions imposed upon them. There are several advantages of NDR. First, preservation of relationships. It is possible to maintain long-term business relationships, which is important to companies which may prosper with stability and trustworthiness in business. Second, flexible solutions. It is possible to seek creative solutions that consider industry-specific and cultural context without being bound by legal rules. Third, cost and time efficiency. There is no need to go through time-consuming, complex, law-based procedures like arbitration. Second, the credibility of mediators should be strengthened through their diversity. Lawyers are still popular for mediators, though we need to pay more attention to the need to utilize experts from various backgrounds. Mediators may come from not only lawyers but also experts with extensive on-site negotiation experience, such as corporate executives, former government officials, and former trade diplomats. Mediation as an extended negotiation should highly value negotiation between parties aided by mediators. Non-legal mediators often prioritize preserving long-term relationship, which aligns with the cultural preference for harmony in many Asian business contexts over strictly legal win-lose outcomes. This approach will reduce the adversarial tone common in litigation or arbitration. This practical knowledge can help disputing parties craft creative, commercially viable solutions that purely legal mediators might overlook. For example, tech company executives can better understand technical issues involved. Former trade diplomats can resolve misunderstandings that arise from cultural differences in international commercial disputes. It would be possible to pair non-legal mediators with lawyers to ensure settlement, both practical and legally sound for their enforcement. To build the capabilities of mediators, there needs to be practice-oriented education in an international commercial context. Mediators, newly appointed or well experienced, need to be intensively trained in negotiation skills and cross-cultural case studies to help the parties reach a wise and amicable agreement on their own. In this vein, I like to emphasize that youth engagement in negotiation and mediation is particularly important. For example, legal education in Korea was drastically changed to follow the American system 15 years ago, but unlike the US law schools, there are very few law schools that offer the courses on negotiation and mediation in Korea. I guess that is why mediation is not so welcomed and utilized by lawyers in Korea. Third, I'd like to say something on institutional cooperation among Asian international mediation centers. The cooperation among international mediation centers in Asia is not only feasible but also highly desirable. Such collaboration could significantly enhance the effectiveness and reach of international commercial mediation in Asia. A regional network of international mediation centers may be established to share best practices, develop joint training programs, and create a pool of accredited mediators. Under this network of cooperation, leading well-established mediation centers may help other centers establish their expertise through the case studies covering success or failure stories. Each participant should have an equal status in the leadership of the network with respect to each other, whether it is well established or not, whether each country is big or not. This network could encourage or assist countries to ratify the Singapore Mediation Convention and facilitate cross-border enforcement of mediated settlements in the state parties. Business and legal users will be encouraged to utilize mediation for settling their cross-border disputes under the Singapore Mediation Convention. In this vein, for the awareness purposes, there may be a need to translate the convention in local languages other than 6 UN official languages. For example, KMC published the English-Korean version of the convention with an agreement of the UNCTRAL. That is our product. So you see on the left side, the English original version, and on the right side, the Korean translated version. Some centers may be reluctant to cooperate due to perceived competition in taking cases. Constructive competition among international mediation centers, however, is positive and important, at least for the interest of disputing parties who want to have much better service of mediation. Cases can be referred or jointly mediated between participating mediation bodies based on expertise, language, or culture. There may be increased volume and regional influence on international commercial mediation through cooperation under the network. Again, Asia's diverse legal systems and cultural backgrounds require a collaborative approach to develop mediation practices that are universally acceptable and effective. The adoption of the Singapore Mediation Convention may also provide a common legal foundation for enforcing mediated settlement, making cooperation between international mediation bodies more practical and impactful. For businesses and lawyers to utilize international commercial mediation in Asia, the following cooperation may be possible. First, awareness of the usefulness of mediation in settling cross-border disputes should be raised. In this regard, I'd like you to go to the WIPO, World Intellectual Property Organization, WIPO website, and you will see WIPO Mediation Pledge. I think the WIPO Mediation Pledge may be a good model for this purpose, awareness purpose. And KMC has started doing a campaign of mediation pledge, which is voluntarily signed for supporting the use of mediation before moving into arbitration and the insertion of a mediation provision in contracts. Second, a proper legal system where international commercial mediation is properly used should be established. The ratification of the Singapore Mediation Convention may provide a good opportunity for states to establish a unified legal system for international commercial mediation. The enforceability of mediated settlement should be reflected in the law. Third, joint standards for international commercial mediation should be established. Mediation guidelines that can be commonly applied in Asia may be established through developing model mediation rules. Those UNCITRAL rules on mediation, such as model law and UNCITRAL mediation rules, and UNCITRAL notes on mediation should be a common ground for any harmonized rules and practice on mediation. In this way, business and legal users may experience coherent procedures of mediation in any mediation bodies of Asia. Fourth, digital platforms for international commercial mediation should be established in Asia. Online mediation systems, which must be regularly utilized in digital era, can be standardized to streamline the dispute resolution process considering the situations in Asia. The use of artificial intelligence should also be helpful in this respect. Fifth, a talent exchange program for mediators in Asia should be established. Experts from each country may learn from each other's cases and strengthen their collaborative capabilities. Mediation institutions should cooperate to provide practical training for efficient and effective mediation. In this sense, there is a need for common materials for training mediators and educating lawyers and businesses. In conclusion, mediation is not just a tool for resolving disputes, but a means of building trust in the global business ecosystem. International mediation centers in Asia should cooperate to support companies in the region to achieve sustainable growth without creating hostile relations through mediation. A collaborative approach to international commercial mediation will increase the credibility of Asian international mediation centers in the global dispute resolution landscape. The cooperation among international mediation centers will attract more cases through a seamless and efficient dispute resolution process. Cooperation may make the bodies learn from each other's experiences and best practices, leading to continuous improvement in international commercial mediation. Overall, Asia has seen a significant increase in international commercial mediation cases, particularly due to the rise of cross-border trade and investment in the region. This trend will be maintained, although Asia should catch up with the US and Europe in international commercial mediation. The promotion of international commercial mediation and institutional cooperation in Asia requires a concerted effort from international mediation centers, government, businesses, and legal practitioners. By harmonizing rules, fostering collaboration, and raising awareness, Asia can position itself as a key role player, rivaling the US and Europe in international commercial mediation. The ratification by more Asian countries of the Singapore Mediation Convention may strengthen its important status in international commercial mediation. In the end, a more efficient, time and cost-effective, and amicable dispute resolution ecosystem may be created in a way to support the region's growing role in global trade and investment, and to create a unified global framework for international commercial mediation. Finally, ADB and ADBI should continue to play a key role by partnering with international commercial mediation centers in Asia. We have just started a journey for this cooperation. Thank you.
And we are happy to have Mr. Thomas Clark, General Counsel of ADB, as a moderator. Mr. Clark, the floor is yours.
Thank you very much. And I'd like to again extend a warm welcome to all of you here. What a panel. I'm really delighted to be here. It's my great privilege to moderate this session, which is really about the global efforts. And it is, I have to underscore, truly global, not just regional. We focus on the Asia Pacific, but this is part of really a global effort to promote international mediation and the status of uptake of the Singapore Convention. Now, we've heard a lot, I think, about the Singapore Convention yesterday, and we're delighted to have people who are really at the forefront of trying to drive the utilization and the use of the Singapore Convention. Now, as all of you know, and many of you in this room are far more familiar than I am, the Singapore Convention is really aiming to address the issue, and it's a critical issue, of the lack of enforceability in cross-border commercial mediated outcomes. It's to increase the credibility and the use of international commercial mediation. Some of you might remember in my opening remarks yesterday, said as a lawyer, it embarrasses me to say this, but sometimes, you know, having a good law on the books isn't the ultimate answer. It's necessary, but it's not sufficient. And what's needed in addition to that, of course, is the infrastructure, the capacity building, the training that go along with it. So if you just step back and look, indeed, it's true. The Singapore Convention has had a very, very auspicious start. I think initially it was signed by 46 jurisdictions. And if you just stop for a second and compare that, say, to the New York Convention, it initially had 24 signatories. So in some sense, you could say that the Singapore Convention is off to roughly double, you know, as fast a start maybe as the New York Convention. And more, of course, have signed on since 2019. And it now amounts to more than half of the world's GDP if we look at the current signatories to the Singapore Convention. Now, that's the good news. That's the glass half full. Of course, most of the people in this room know whenever there's a glass half full, there's also a glass half empty. And I guess the glass half empty side is that there have been limited ratifications and very limited known explicit use, at least so far, of the convention to enforce mediated agreements. So this session is really going to explore efforts to promote the ratification of the Singapore Convention and of course, given our focus, especially in the Asia Pacific region, including trying to really, analyze and get to the root of the reasons why states, some of them have ratified quickly and why others have not. And perhaps we can attempt with this to conjecture whether the convention will eventually lead to the growth in international commercial mediation, and indeed whether maybe Asia the Pacific region can lead the way on that. So without further ado, our session is going to begin with a presentation followed by a discussion with our very esteemed and distinguished panel, and then we will open it up for audience Q&A. And I will introduce, in the interest of time, our distinguished panel when we get to that point. But first, we have a presentation by Ms. Natalie Morris Sharma. This will help to facilitate and provide some of the background on the Singapore Convention and provide a global picture. So Natalie, the floor is yours. Thank you.
Thank you very much, Thomas. A very good morning, good afternoon, and good evening to everybody. I'm really, I do apologize that I'm not able to be with you in person today. I join you from New York, where I'm currently attending UNCITRAL meetings, but I'm delighted to be able to join by virtual means, and very much thank the organizers for facilitating that possibility. As Thomas has given quite a good introduction to things, my understanding was I was to be introducing the Singapore Convention on Mediation, but I think what I'd like to do is, as I'm going through my slides, touch on a little bit of what Thomas has mentioned in terms of why we've got limited ratifications, limited known use in the course of going through my prepared slides. So I'd like to talk a little bit about the context of the Singapore Convention on Mediation, both when it was developed at the United Nations, as well as its current context, and take us through some of the key provisions in the text of the convention. Hopefully this sets a bit of a stage for our discussions in our time together today. So I'll do context then key provisions, and context now as part of my concluding remarks. Let's begin with my slides. So the Singapore Convention was developed following a proposal from the United States in 2014, and the text was finalized and adopted in 2018. And then we can go straight to the next slide already. It opened for signature on the 7th of August of 2019, and you've already heard about the auspicious start that Thomas has referred to. And though a young treaty, we already have 58 signatories from all regions of the world. The convention entered into force on 12 September 2020. We can go to the next slide. And there are now 15 parties to the Singapore Convention on Mediation. So yes, we have 60, and then I guess a quarter have already ratified. The question that Thomas posed was, why are there limited ratifications? If you look at the timeline that you see here, you would notice that the entry into force was just before the COVID pandemic. And I think where we would normally have seen that steep climb in ratifications in any ordinary course of events, as you know, many other priorities came onto the plates of governments post the pandemic period, or post the onset of the pandemic, and that, as you could call it, as a distraction from the Convention on Mediation take-up rate. Only now we're beginning to see things adjust back to a bit of a normal from the post-COVID-19 pandemic phase, but at the same time, we're seeing other geopolitical priorities and developments coming into the picture. And all of this, I think, needs to form the context for why the ratification process may not be as speedy as we would otherwise have projected in the ordinary course of affairs, seen against the larger context of how governments work and the competing priorities that they have to work with in getting a treaty domestically ratified through their domestic processes onto the books and out into action, as it were. Nevertheless, the Singapore Convention has been hailed as that missing third piece and welcomed in joining the International Enforcement Framework Treaties for arbitral awards and court judgments. Next slide, please. We have in the Singapore Convention on Mediation what the New York Convention is to arbitral awards, responding to the lack of the cross-border mechanism. Essentially, because we didn't have this cross-border mechanism, there was a significant barrier to reaping the benefits of mediation, which I will not go into now, but are reflected broadly on this slide, as I'm sure that we're all very well familiar with them. Next slide, please. I thought it was useful to get into a little bit of what enforcement looks like without the Singapore Convention on Mediation. There are other means by which one can secure cross-border enforcement of mediated settlement agreements without the Singapore Convention: contract action, court procedures, conversion into a consent award. But I think the main thing to underscore underlining all of these options is that the procedures vary across jurisdictions. This brings inherent uncertainties, including with consent awards and the application of the New York Convention. And these uncertainties undermine the ability to rely or the ability or the attractiveness of mediation to disputing parties. Next, please. We know that enforceability of dispute resolution outcomes is a key factor influencing choices of dispute resolution processes. This survey result here, which you can refer to as I speak, was something that was presented to the UNCITRAL working group that negotiated the Singapore Convention on Mediation. We were informed of this survey and how some or a vast number were more likely to mediate, provided with the knowledge that they knew that their country had ratified a United Nations Convention on the Enforcement of Mediated Settlements. Next. And beyond that, diversity of enforcement mechanisms of internationally mediated settlement agreements has been identified as a major obstacle in the development of global mediation practice. This is another survey result that was made available to the negotiators at the time. Next, there was also an EU study that has suggested that the enforcement of settlement agreements would benefit from uniformity in the system, and that would help make mediation more attractive. Next, please. This is where the Singapore Convention comes in. It recognizes that with a mediated process, the settlement agreement is not a mere contract. So long as the requirements of the convention are met, settlement agreements can benefit from the convention's recognition and enforcement framework. So you can enforce or rely on the mediated settlement agreements to have the obligations carried out, or you can invoke it to prove that a matter has already been resolved. Next. The convention applies to international commercial settlement agreements resulting from mediation. And what I want to highlight through this slide and the next slide is how you will see that there are no surprises in the Singapore Convention on Mediation. It is designed to work with and preserve rather than get in the way of flexibilities of mediation and the commercial realities in which the convention needs to operate in the context of. So with international, for example, It is defined using a simple and clear formulation that takes reference from parties' places of business. Commercial is not defined, but it is broadly understood, including its application to investor-state disputes. There's no application to consumer disputes or agreements relating to family inheritance or employment, amongst others, because this raises policy issues and large imbalances of power between the disputing parties. And then resulting from mediation, we see mediation is defined broadly, accommodating mediation as a flexible process without limitation on types of remedies, and reflecting appreciation for our settlement often extends beyond pure monetary relief. Next. As to the form requirements, they're really simple and straightforward, so long as the agreement is writing, signed, evidence that the settlement agreement resulted from mediation. All this is going to show that the Singapore Convention was intentionally designed to be simple and straightforward as far as international treaties go. Next. There's a pro-enforceability approach in the Convention, with the grounds for refusal limited to those set out in the Convention, including those that you see on screen here. And you'll see that the grounds of refusal are tailored to the practice of mediation, retaining the successful elements of the New York Convention while responding to the difficulties posed by seeking to translate the grounds for refusal of the New York Convention to the mediation context. Next, there are also specific grounds for refusal that apply to the context of mediator misconduct as an acknowledgement of the role and the impact of the mediation process or the conduct of a mediator on the validity of a settlement agreement. So with a serious breach of standards that are applicable or a failure to disclose raising justifiable doubts, most importantly here, such breach or failure having a direct impact on the settlement agreement, a causal link between that breach or failure and the decision of a party to enter into the settlement agreement. And next, I have a slide on reservations. This is the final key provision of the Singapore Convention that I will cover today. And it's also related to the question of ratifications. Two reservations are permitted under the Singapore Convention to provide parties to the Singapore Convention with certain flexibilities should they need it. And whilst we've seen a slower ratification rate or some might say we've seen a slower ratification rate that we would like, I think there aren't some of the obstacles that might otherwise have posed in terms of ratification are alleviated by these reservations. First of all, a party may declare that it shall not apply the convention to settlement agreements to which its agencies or agents are a party to the extent specified in the declaration. This reservation was included in the convention as it's recognized that government entities do engage in commercial activities. However, in some jurisdictions, government entities are not authorized to conclude such agreements. So this reservation provides countries with the flexibility to exclude such settlement agreements where government entities are involved if they so need it. The second reservation is where a party may declare that it shall apply the convention only to the extent that the parties to the settlement agreement have agreed to the application of the convention. So to explain a little bit, without the reservation, the Singapore Convention would apply by default, and states can enter a reservation to apply an opposite opt-in rule instead of the default opt-out rule. And this reservation provides flexibility to states which hold the view that having disputing parties expressly consent to an enforcement regime would be a natural follow-through of the consensual nature of mediation and of the disputing parties being fully aware of what they're agreeing to do. But at the same time, by preserving the default opt-out rule, the Singapore Convention's objectives of promoting mediation and enforceability are preserved, recognizing also that in practical terms, disputing parties are quite unlikely to be interested in having a further discussion on enforcement after they reach their settlement, by which point they've really formed the expectation that the other party would comply with the settlement agreement. So here in these reservations, we've removed some of the key obstacles that were identified by some countries in being able to sign on to a convention, a single international enforcement framework that is provided by the Singapore Convention. And I think it's really a useful tool to be able to maintain the integrity of the convention and what it stands for, but also providing flexibility to countries to be able to adjust to some important concerns that they had and may still have. The last part of my presentation in the time that I have left is on context now. The next slide. I've posed 3 questions that I'd like to quickly answer. What does the Singapore Convention mean for users of dispute resolution? I gather this might already have been answered in the course of your deliberations yesterday, but in short, mediation is now more meaningful, effective, viable. We now have a broadened suite of options so that parties can choose based on their circumstances what kind of dispute resolution option they want, and knowing with full certainty that the recognition and enforcement of the outcomes of that method will be pursued, including mediation. And the significance of this certainty cannot be overstated. It's been brought to bear time and time again. And now with the latest global geopolitical developments, we've got new uncertainties and challenges in the rest of the world. I think with dispute resolution, you want to minimize them as far as possible. The second question, what are the impacts of the Singapore Convention on the profile and use of mediation globally? As I've already alluded to a few times, with this harmonized framework, the attractiveness and use of mediation has increased. At the same time, the way in which the convention has been prepared means that there are built-in safeguards against judicialization, against the risks of satellite litigation that international treaties can sometimes bring. And beyond this, the Singapore Convention has been successful in increasing the profile of mediation. With publicity, it's increased profile amongst users, dispute resolution practitioners, amongst governments. Sometimes there's nothing like a UN treaty to put an issue on the agenda. But it's not profile for profile's sake. I would highlight 3 further points. For one, the mere awareness of mediation will increase its chance of being considered and used in the event of dispute. Second, being a UN treaty on the subject, mediation's legitimacy has been bolstered. And third, the Singapore Convention has led and will continue to lead to a strengthening of the supporting structures for mediation. This could be in respect of the support that local legal systems and legal institutions, especially of signatory countries, lend to mediation and mediated settlement agreements. And internationally, we have seen a reinvigoration of efforts to grow the mediation ecosystem through training, accreditation, the establishment of international standards, a code of conduct for mediators. So these developments form a positive feedback loop for the growth and attractiveness of mediation as a form of international dispute resolution. For some countries, before they ratify, they might feel they want to have a few of these things in place before they move forward from being a signatory to a ratifying party of the convention. But for others, they see these benefits already and are already ready to ratify in order to further promote these developments that I am talking about. So a little bit is down to the different priorities and the different perspectives of governments on how these issues relate to each other. Finally, also relevant to the question of ratification is the 2018 UNCITRAL Model Law on International Commercial Mediation. This was developed in parallel with the Singapore Convention on Mediation, partly as a function of the negotiations, but the concurrent development of the two means there's a high level of complementarity between the Singapore Convention on Mediation and the UNCITRAL Model Law. And accordingly, what I would want to highlight is this model law could be the mean by which a party to the Singapore Convention can proceed on their ratification journey and implement a convention domestically. And hopefully it means a smoother path towards ratification. This brings me to the end of my presentation. I said I would talk about limited known use. I'll just say briefly with a kind of couple of sentences that it takes time from the Singapore Convention being referred to in contracts for the dispute to happen and then for the enforcement to kind of kick in through the court process. And so and a lot of the time mediations are also confidential, which I think is why we've contributed to the sense of known use not being so public. But I have full confidence that the Singapore Convention is on the up and up. And I hope that my presentation today will help to inform the exchange. Thank you very much.
Natalie, thank you so much. I don't know about others in the room, but having heard Natalie's remarks, I simply cannot think of a better way to start and to frame this panel discussion than with the really magisterial summary and analysis which you have given, Natalie. And of course, we're particularly, I think, privileged to have it come from you, given your extensive work in the International Law Department at Singapore's Attorney General's Chamber, because after all, it was you and your office who were so instrumental in the development of the Singapore Convention. So it's really like hearing it right from, how shall I say, the framers and sort of the original sort of legislative history and obviously the passion and dynamism that have gone on to that. And I very much like your closing remarks. I think it puts us in the glass half full rather than the glass half empty category, that it's on the up and up very much. And your point about sort of the alignment and complementariness with the UNCITRAL model law is very important. I think it reminds me of some of the remarks yesterday about how even in the work we've done, like on the New York Convention, looking at the UNCITRAL model laws and ensuring that harmonization so this truly can become a global system. All very important points. So really immense thanks to you for that terrific kickoff. It's going to really help us, I think. Now, just moving to our panel discussion, I'd first like to turn to one of our distinguished panelists up on the stage here, Mr. Wee Meng Chuan, who is the CEO of the Singapore International Mediation Center. And Wee Meng has extremely deep regional experience and currently leads Singapore International Mediation Center's efforts to promote mediation to resolve a variety of complex commercial cross-border disputes in the Asia-Pacific region. So again, someone whose expertise is right on point. So if I may, Wee Meng, the floor is yours.
Thank you, Tom. If you would excuse me, I would rather stand because I know I'm in the presence of many senior judges from many parts of the world, and I'm just used to addressing them when I'm standing. So if you would excuse me for doing that. So thank you very much for inviting SIMC, inviting me to today's panel discussion. It's wonderful to be here, and I know I'm on Japan time, so it's like the Shinkansen that arrives. I've got 7 minutes or 8 minutes, and then the train is gone. So I've got to do this within that time period, okay? So I've been asked to talk about the rise of mediation and promoting of the ratification of the Singapore Convention, in particular from SIMC's perspective, all right, from Singapore, as well as my personal experience in reaching out to the different countries. So first, about the rise of mediation. I joined SIMC about 6 years ago, and SIMC is about 10 years old. So within this 10-year period, we've seen really a tremendous growth of mediation. And SIMC, we do almost all our cases are commercial cross-border disputes, right? Commercial cross-border. That's our focus of SIMC. In 2014, when we started, we had 6 cases. Today, we average about 90 or more cases. So you have seen over the last 10 years, it's really a multiple growth of the number of cases that we've seen here in SIMC. And to manage, 90 cases of really significant cross-border dispute of large values as well, the largest, which I think maybe George might talk about in a little while, is an $8 billion dispute, $8 billion US dollar. So those are very, very, very large complex dispute. So we see mediation on the rise, as well as being used in many parts of the world. Our users are from 60 over countries around the world. And you will see that from 60 over countries, some of them, of course, are part of the convention, some of them are not. So although the countries are not within the convention, the parties themselves submit themselves for mediation. And our success rate in SIMC is about 70%. So it's a very high success rate. So a lot of the parties leave the mediation very happy with the results and have a matter resolved. Even for those, the 30% that was not able to resolve the result, they were able to find good discussion and progress in the dispute. So a little bit of data before I move into the promotion of the ratification. Nadia introduced the CEDRA survey yesterday. I'm going to introduce another survey here, which I hope it works. Ah, there you are. Oh, sorry. I did a double click, didn't I? So this survey is, okay, here we are. So this survey is from Queen Mary as well, White & Case. The question is asked in this survey, what is your preferred method of resolving commercial disputes, right? So the survey was done starting with 2015, 2018, 2021. You can see international arbitration, of course, is very popular with 56% wanting international arbitration as a way of resolving commercial disputes. But over the last 8 years or so, from 2015 to 2018 to 2021, you can see that has come down from 56 to 48 to 31%. The converse of it, international arbitration of ADR, in particular mediation, is on the rise. It went from 34 to 49 to 59%. Of course, this does not include the specific mediations that are just done on their own. So we can see that there's really a clear uptake of mediation being part of that process of dispute resolution. And these are from commercial users. Now, when we look at the convention itself, you see a lot of countries that are set out here. The ones in blue are the ones that have signed. Those in the room, if your country is in there, can you put up your hands? Yeah, get a sense of those in the room. If your countries are there, put up your hands. Okay, great, great. I see a couple of hands here, couple of hands. For those of you who are hands are down, you have work to do, okay? You have work to do. Either to talk to your government, get the convention signed, or at the same time, get it ratified, okay? So you can see that for the countries that have signed and ratified, we have been engaged with a lot of them over the years. We have actually engaged with 25 of these countries over the years, during my time as CEO. A large percentage of them are in Asia, from China, India, Japan, Kazakhstan. I know all of you are represented here, all the way to Turkey. But we also go as far as the US. I'm off to the US next week, to New York and to Chicago to talk about the convention, and then to Latin America as well. So as you can see, it's a global outreach by SIMC to promote the mediation. So who do we promote this to? So this is the mediation ecosystem, right? You have the judiciary, you have the government, you have ADR centers here, you have the law firms, the law society, companies, business federations. So there is clearly connected. They're all clearly connected in one way or another. So we have to focus on the mediation ecosystem to promote the convention. And every one of them play a very major role. And as the ADR centers, and we work with ADR centers around the world, JIMC, KCAV, KIMC, etc., CTAC, SCMC, we work with all of you to promote the mediation in all of that, on all these countries. So what do we do? So for government ministries, you can see that we are working with each of the government, talking to them in seminars, in one-on-one meetings, because you need to have the awareness at the base of it. After the awareness, you've got to talk about training. After training, you've got to talk about accreditation. You've got to talk about mediation advocacy. And these are just the governments. And I see that the 2 minutes is up, so the door is open. The Shinkansen door is open. I've got to get into the train soon. And then you have the judiciary. Again, judiciary around the world, we've been actively involved with them in China, Japan, South Korea, India, etc. But what is more important, I think, at the end of the day, is really training. So SIMC has conducted training in over 15 countries. We've trained over 600 professionals in advocacy, mediation training. And all of this is done in collaboration. To take a leaf from Professor Park's earlier speech, we need to collaborate. We collaborate with ADB, we collaborate with JIMC, we collaborate with IMC, etc. So what you can see is that together, we can raise the awareness, we can do the training, and then we can do the accreditation. Because unless you have the awareness of the business federation, of the users, of the law society and the lawyers to support it, and of course the government and the judiciary, you will not be able to introduce and make it effective as far as the convention is concerned. So just a little bit about mediation, the next frontier. You can see the AI there, right in the middle. So we are getting into mediation where AI is being used to support mediation. And just some comments about the mediators who have used mediation, they found it very useful. So we are very happy to collaborate with all of you to see how we can introduce mediation to bring it to the next frontier. So thank you.
Thank you very much, Wee-Myung. That was really a terrific overview, and I think we see, again, some of the reasons you point us to for why we should be more optimistic than pessimistic about the route going forward. Next, we will hear from Mr. Yoshihiro Takatori, a special advisor on ADR and cross-border dispute resolution at the distinguished Tokyo law firm Nagashima Ono and Tsunematsu. Takatori Sensei is also an independent arbitrator and mediator and the leading figure in ADR. And I can't resist taking the opportunity to say that it's a delight, especially for me, to see Takatori Sensei many years ago, more than I'd care to remember when I was based here in Tokyo working with a major US multinational. We had occasion to consult with Takatori Sensei and benefit from his wise legal advice. So great to see you on the same stage today and keen to hear what you have to say. So Takatori Sensei, the floor is yours.
Thank you very much, Tom. It's a very great honor for me to be here with such a distinguished panelist, especially moderated by my old friend, Tom Clark. So my role is to introduce the situation in Japan first regarding the ratification of Singapore Convention in Japan and background, and mediation practice in Japan reflecting the civil law type of a culture and the court litigation, and new law to implement the Singapore Convention of Mediation. And then second, quite a positive impact mainly on the over Singapore Convention, including the ADBI. But some sensitive issues we have on so-called like a double hat issue for the practice, where the arbitrator can be same person can be a mediator or something. So just a touch on base. So first situation on October 2023, the Japan deposited in the instrument of the accession of the Singapore Convention on Mediation with the Secretary General of the United Nations. This convention became actually into effect force for the Japan on the April 1st, 2024. And big point is the opt-in. As Natalie mentioned, we have a kind of reservation under the Singapore Convention. We chose opt-in reservation. So limited to the cases in which both parties only agree on the enforceability based on the Singapore Convention on Mediation of the new law for the implementation thereof. So the quite good time. We are very honored to have the Japan signed quite and ratified so quickly. So one big reason is that we would like to take a lead for this opt-in kind of reservation style for the globally, actually. But then the new law to implement the Singapore Convention on Mediation for settlement agreements in international mediation, which became into effect in Japan from the date on which the Singapore Convention mediation took effect. That's April 2024, and settlement agreement become enforceable upon the enforcement decision by a court. So then some points, the granting enforceability to settlement agreements reached through the certified dispute resolution procedures as specified in the ADR Act. Then on 28 April 2023, the amended ADR Act was promulgated, and amendments became in effect the 2024 April. Then specified settlements, limited to settlements, which have been arranged between the parties in certified dispute resolution procedures, in which the parties have agreed on the enforceability. So again, the opt-in reservation agreement needs to be made in the certified mediation procedures. Then another big point in Japan is the Tokyo District Court and Osaka District Court have a special concurrent jurisdiction over petition for the execution orders. In Nakameguro in Tokyo, we have a business court, and they are having a good experienced and the business knowledge, the lawyers we have, then we can have jurisdiction on that. That's a kind of big, good impact. Then applicant may be allowed to dispense fully or partially with the Japanese translation of the settlement agreement and other requisite documents to be submitted to the court if the court finds it's appropriate. That's another big point, because the Japanese litigation procedures have to be conducted in the Japanese mainly. But for this type of arbitration and the mediation related case, some kind of a skip or no necessity of the translation, depending upon the courts or judges' determination. Then next one, some traditions in Japan, the traditional mediation by judges as a litigation court-linked settlement procedure in the history. Judges taking a role of the very strong evaluative mediator who can decide a case judgment as a decision maker, kind of historically. And actually, my wife is a judge, so I'm litigating every day. But anyway, so around the 250 cases, she or he, the judges, handling simultaneously 250 cases average. Then by which most judges naturally tend to seek for settlement rather than reflecting judgment. And big kind of a civil law type of uniqueness from the common law jurisdiction So we have no kind of for the court procedure, kind of no without prejudice concept and the civil law legal culture, where the decision maker can be a mediator who is to be involved in the expulsive personal communication with each party. That's may trigger some sensitive issues for the scope of Singapore Convention. And kind of uniqueness of the combination of the legal professionals and experts, such as construction engineers or something. That's a quite nice combination. Then, so maybe I shall touch on this JIMC's promotion maybe later at the session 8. I'm not going to go through everything, but we have quite good facility and the operation in Kyoto in Nohyoung University's facility. And we have a joint protocol of the online mediation for COVID-19 with the SIMC, and I was actually the first co-mediator for that case. So then a little bit introduce this co-mediation online protocol for the COVID-19 pandemic, facilitating cross-border commercial. Okay, 2 minutes remaining. So reflecting cross-cultural difference, including common law versus civil law. And co-mediators to be appointed respectively by SIMC and the JIMC, agreed by the parties. I was appointed by the JIMC side, and then the Gregory Vijayendran, the former president of the Law Society in Singapore, was appointed. So we did the nice combination as a unified co-mediator. Then virtual online platform efficiently functioning under the pandemic situation. Actually, I was not even step out from my house for that case. I was kind of in my house under the basement with the jacket upper side, and then pajama the lower side, and then quite nicely efficiently resolved. So and overcome language obstacles and the culture difference, including the negotiation style and the stance. Although we did not take a role as a translator, so we can be we could be a bridge. Then reasonable cost, fee schedule, something. So just for your information, the first co-mediation case mediated by Greg and myself, and we utilized kind of so-called Greg Yoshi schedule for proceeding with the actual mediation, like as the Red Fan schedule, but we are promoting the Greg Yoshi schedule. It's not yet common so far, but meet the mediators who overcome cultural odds in JIMC, SIMC COVID-19 joint protocol. This SIMC homepage is available. That's moderated by the women here, and we are interviewed. So if you are interested, please visit that page. Then lastly, are made up for harmonization. So again, the double hat issue is a little bit sensitive. So we maybe think about the actual scope of the Singapore Convention, and if it's necessary from Japan side or civil culture side, some possibility of the amendment of the Singapore Convention scope could be considered, because double hat is some kind of hated by the common law culture practitioner, but that works sometimes, especially for the civil law type of thinking way. So we should think about such scope of a Singapore Convention maybe for the future. Thank you very much.
Thank you. Thank you very much, Takatoshi-san. It was really a pleasure. A lot of learnings coming out of there. Two that stick in my mind, of course, are the Greg Yoshi schedule, which is important, and that if anyone is married to a judge, every day is like a litigation. So you better be on your toes. But thank you. Thank you very much. With that, I'd like to turn the floor next to Dr. David Chen, Vice Chairman of the Shanghai Commercial Mediation Center, as well as the President of the Shanghai Kaisheng Mediator Academy. Dr. Chen is a certified mediator of the World Intellectual Property Organization and Judicial Arbitration and Mediation Services, and of course is also an arbitrator of several other major arbitral institutions in the region. Let me turn the floor over to you, sir. Thank you.
Thank you, Thomas. Good morning, ladies and gentlemen. I'm honored to be invited to the conference and engage in discussion with you on behalf of Shanghai Commercial Mediation Center. I would like to share China's practical experience in commercial mediation from 4 key perspectives and explore with you how we can better promote the ratification and implementation of Singapore Convention. China has consistently maintained a positive yet prudent attitude towards the Singapore Convention. Since China became one of the first signatories to the Singapore Convention in 2019, the commercial mediation sector in China has experienced remarkable growth. Currently, China is accelerating efforts to align its existing legal framework with the Singapore Convention. International conventions serve as the framework of law followed by the global community, playing a crucial role in maintaining international order and promoting cooperation and development. When participating in the international convention, each country considers its own national condition, legal system, and national interests, resulting in unique models tailored to their specific context. The general procedure for China to ratify an international convention is as follows. First, China needs to further assess the impact of the Singapore Convention on its domestic commercial mediation system. Second, China should further clarify the legal status and implementation mechanism of commercial mediation at a legislative level. Third, the Ministry of Foreign Affairs will submit the proposal to the State Council for the review. Fourth, the State Council submits the proposal to the Standing Committee of the National People's Congress for approval. Fifth, China President approves the ratification based on the decision of the Standing Committee of the National People's Congress. Sixth, upon approval, the treaty will be promulgated in the bulletin of the Standing Committee of the National People's Congress. China has also taken many initiatives to promote the ratification of the Singapore Convention. At the national level, Xi Jinping, President of the People's Republic of China, pointed out, put the non-litigation dispute resolution mechanism at the forefront. Commercial mediation is an important judicial policy in China, ensuring the implementation of ADR system. In addition, The regulations on commercial mediation were officially included in the State Council's 2024 Legislative Work Plan as an important legislative project. At the same time, Ministry of Commerce has supported the multilateral cooperation on international commercial mediation by incorporating mediation in non-lawful multilateral cooperation agreements, for instance, RCEP. The term of the local legislation, legislative initiatives have been actively pursued in various parts of China. For example, Shanghai, Shenzhen, Canton Province, Heilongjiang Province have adopted the regulation on commercial mediation. Now, I would like to introduce the current status of the commercial mediation development in China. In July 2025, there were 586 mediation organizations in China with title Commercial Mediation Center, which reflects that China's commercial disputes resolution mechanism is constantly being enhanced and modernized. The cooperation, let me see the time, okay. Since established in 2011, to the end of the January 2025, Shanghai Commercial Mediation Center formally accepted 3,149 cases. The total disputes value is about 76 billion RMB. Among these, 2,015 cases were successfully mediated, and mediation success rate is about 64%. Commercial mediation needs to expand awareness and influence through the continuous accumulated and publicity. SCMC has done the following important work. We have held Shanghai Commercial Mediation Promotion Week for 6 years. We have also held Shanghai Hong Kong Commercial Mediation Forum for 6 sections since 2012. Moreover, SCMC actively explores the commercial mediation markets through the collaboration with the Chinese Chamber of the Commerce in Spain, European Union, and another country. SCMC adhere to the international orientation of commercial mediation as required by the Singapore Convention. SCMC has established an international mediator team. Now we have more than 100 professional mediators, include 7 following mediators from the United States, United Kingdom, Germany, Spain, Israel, and 8 mediators from Hong Kong. SCMC continually exchange commercial mediation institutions in Japan, Vietnam, Korea, Israel, and other countries. Under the support of the Ministry of the Commerce, under the National Intellectual Property Administration, SCMC has established the Overseas Legal Services Station in Munich, Tokyo, and Madrid. After more than 2 years of communication and exchange with the EU IPO, SCMC jointly launched the Intellectual Property Core Mediation Rulers concerning trademark and industrial design in China and the EU, which came in effect on July 1st, 2020. This marks a milestone for cross-border disputes resolution in the field of the intellectual property. SCMC has carried out cooperation with GEMS in commercial mediation and became its 7th international member in the world. SCMC and GEMS jointly formed an 11+11 Sino-US International Commercial Co-Mediation Panel. SCMC mainly improved the professionalization level of the institution from the following 2 aspects. Based on the initial cooperation in 2012, SCMC has upgraded its strategic cooperation relationship with CETA. pioneering the exploration of the Sino-UK international commercial core mediation mechanism, jointly offering the mediate training courses. We also, together with the Shanghai Jiao Tong University, established the mediation academy. We have designed the different course and for the different trainee. So because the time limited, I stop here. Thank you. Thank you, everybody.
Thank you. Thank you very much, Dr. Chen. I mean, that was really a very passionate and energetic, I think, summary but very important, of China's attitude toward the convention, the development of commercial mediation, and particularly, I think, SCMC's own very valiant efforts to drive it forward. So thank you very much. Thank you very much. And we are constrained by time. I'm sorry to be so, strict here, but we have a lot still to get to. So I'd now next like to give the floor to Dr. Hyun Suk Oh. Dr. Oh, a professor at the Economics and International Department at Nohyoung University in South Korea, and he's on the board of directors of the Korea International Mediation Center, and is working really quite centrally with the Ministry of Justice Task Force to enact the Singapore Convention Implementing Act. So again, I think really in a great position to give us an update of where things stand in South Korea. So the floor is yours.
Thank you, Mr. Thomas. I'm very. It's a great honor to me to be here, and I would like to thank to all the person who organized this excellent conference. I'll give a presentation in three topics. The first is First is the reason for the supporting international mediation. As we know, in international trade and commerce, arbitration has widely accepted as the main method of resolving dispute. In recent Cum Merit survey, 97% of respondents expressed that international arbitration is their most preferred method. Why the arbitration is preferred mostly? Because the possibility of awards. In other words, it can be said that the New York Convention contribute to the use and spread of international arbitration mostly. But the survey also shown that arbitration users are most discontent with the cost and the lack of speed. Although the arbitration system has long been used mainly to resolve international commercial dispute, some critical views have been raised due to the delay in the procedures and the excessive cost of arbitration. Now, mediation is emerging as a major method to resolve international commercial dispute in place of arbitration. As many panelists have already mentioned in this conference, mediation has many significant advantages of arbitration, such as low cost, speed, flexibility of procedure. In addition, those advantages, I would like to also one more added that maintaining the relationship between the parties is the most important strength of mediation. In mediation, cooperative relationship can be maintained even after the dispute is over. Those advantages are the vast strengths that only mediation can have. But on the other hand, international litigation or arbitration can put the parties in hostile relationship. So the parties have no choice but to stop their business relationship. I move to the second topic, how it will fit within suite of dispute resolution options. The advantages of such international mediation are particularly suitable for dispute resolution within global supply chains, where long-term business partnership is essential. For example, Hyundai Motor Company in Korea are importing various kinds of parts from suppliers in Thailand, Indonesia, and Vietnam. In the process, various disputes also arise, such as non-payment, defects, and the delay in shipment. There are so many contract-related disputes within the global supply chain. But most of suppliers are small and medium-sized enterprises. So it is quite difficult for them to file international litigation or arbitration against the manufacturer that require a lot of legal cost and time. In addition, relationship between the parties can become hostile, and such a bad relationship can destroy the entire global supply chain. On the other hand, the mediation process can maintain a friendly relationship between the parties, and therefore we can say that mediation is the best method to resolve dispute in global supply chain. Meanwhile, in this end, global company regard friendly relations with suppliers as a very important element of ESG management. In terms of that side, companies are starting to think of mediation as a means of realizing ESG management. Why? Because mediation can resolve dispute while maintaining a good relationship with their suppliers. In fact, Fair Trade Law of Korea has posed mediation in supply chain contract dispute from long time ago in domestic. Under the law, if the manufacturer does not participate in the mediation procedure, the administrative sanctions are imposed to them by the government. As a result, manufacturers have a lot of pressure with this compulsory mediation. And the manufacturer have two choices, go to the compulsory mediation and go to the voluntary mediation. So to avoid this compulsory mediation, some Korean companies have recently established dispute mediation committee in their company. In addition, companies have begun to promote this mediation committee as a means of ESG management. For example, Hyundai Transit has established its own dispute mediation council, and many Korean companies established same as committee. And their sustainability reports promote this as ESG management in a social field. This mediation process is a very unique system that exists only in Korea, as I know. It can be said that resolving disputes through mediation in the global supply chain is the best thing for ESG management. And if this part is emphasized, the use of international mediation can be greatly increased with the global companies. And the third topic is South Korea's ratification of Singapore Convention, current status of implementation and promotion. But the status of Singapore Convention in Korea will be mentioned in detail by the Deputy Director Gina Park of Ministry of Korea, Justice of Korea, in the following session. I'll briefly mention about the promotion of international mediation Korea, but also the promotion of international mediation in Korea also mentioned in the keynote speech by the Nohyoung. So for the time saving, I would like to finish my presentation. Thank you.
Thank you. Thank you very much, Dr. O. Now, I'm delighted to say that, I guess because of the great discipline of our panel and maybe my dictatorial timekeeping here, I don't know which, but we're actually a minute early. And so we're now going to launch for the final 10 minutes here into what I'd like to call a lightning round. And what that means is I'm going to ask a set of questions and give you each 2 minutes. Really 2 minutes. I mean, this is like, you know, you've heard of Chatham rules where you don't say what someone said, and then there's enhanced Chatham rules. What's that? That's where you actually don't say what people said. So this is going to be actually like, please try to keep it to 2 minutes. But here are my questions, and maybe we'll reverse the order just you know, to be fair here. Maybe you'll pick up some ideas from what other people say. But I'd like to ask you, number one, you know, if I put a gun to your head, that's a bad, I guess. If I asked you very strongly, please, what are your recommendations to help increase adoption of the Singapore Convention? What would your very concise recommendations be? Second, related question, but I think a different question is, what would your recommendations be to increase uptake of international mediation. Remember, yesterday we talked a little bit about there are two different things here. There's adoption of the laws, getting it, signed, ratified, maybe even implementing laws in. But then the real rubber meets the road question is, when does the business community, when do users adopt it? So with those two things in mind, number one, what are your recommendations to spur adoption? And what are your recommendations to spur uptake? And then if you have any time left, which I hope you might have 30 seconds left, bonus question, do you see a real possibility that this region, the Asia Pacific region, can lead the way on this globally? So let me turn first to you, Dr. O.
In Asia, companies from Korea and Japan, China constitute global supply chain with companies from developing countries such as Vietnam and Indonesia. As mentioned earlier, it is best to resolve various contractual disputes within the global supply chain through international mediation. However, even if a settlement agreement is reached, if one party does not voluntarily implement it, the effectiveness of international mediation will be greatly reduced. Therefore, it is essential to join the Singapore Convention, which guarantees the enforcement settlement agreement. Japan has already ratified, and if other countries such as Korea and China, Vietnam, Indonesia, India, where its company constitute global supply chain in Asia, ratify the Singapore Convention, their company can efficiently resolve supply chain disputes through mediation at a low cost and speed. As a result, international mediation in Asia could increase significantly. Just as the New York Convention greatly contributed to the increase in international trade and investment, the Singapore Convention will also play an important role in international trade and foreign investment in Asia also. If so, the Singapore Convention can be said that the most successful convention adopted by UNSTRAL, like the New York Convention. Thank you.
Thank you, very good. And on time, I appreciate it. Good comments. Dr. Chen, the floor is yours for 2 minutes.
Thank you. I think this is very good questions. My recommendation, how to emphasize two parts. First is legislative is very important. I think Singapore Convention gave us very useful legal framework. We can promote the domestic legislative on regulation, promotion is a match with the Singapore Convention. It's necessary, it's a guarantee by the Commission how to do it. And secondly, I think the training is very important because, mediator not like a lawyer pass the examination, bar examination. It's get the qualification is easier. So we must training for them. At least 40 hours, I think, is necessary. So we cooperate with the British Kingdom. CEDAR is a very famous training organizations. Because, Asia region develop economic develop quickly and international trade. So resolving the commercial disputes is involving the changes. So Singapore Convention gave us a very, very useful. So China and another country is very important in our countries. So we will exchange each other, share the information and discuss like ADBI. So more and more discuss what's the issues promote the ratification and the implementation Singapore Convention. This is my idea. Thank you. Thank you very much.
Thank you. Thank you very much, Dr. Chen. So again, more discussion, more, I would say, capacity building, engaging in dialogue is a way to do it. Very, very, very helpful. Let's move to you, Takatori Sensei, please. 2 minutes, the floor is yours.
First, how to increase the ratification? Definitely the cooperation with the judicial platform, like courts, because we by the interpretation of the Singapore Convention and good platform. That's first. And then second question, training. I completely agree with David Chen, and especially to the users side. including the in-house side. As a little bit, I jumped in for the yesterday session, especially in-house counsels who are very familiar with the business interest and the legal interest. And with that understanding and cooperation, the mediation could be increased. The third, from an agent side, including Japan, a combination of ARB-Med-ARB type of options, including like such kind of a double hat operation, if the parties can agree upon, that could be functioning. So for example, like UNSTRAL commissions the activities, including the committee 2, did the good works for the high technology dispute resolution, for example. And then currently, like a digital economy dispute resolution is kind of under discussion. So through those kind of how to harmonize the ARB-Med-ARB type of combination, not stuck to the stereotype between the common law or civil law or something. So we can do kind of harmonize and the good options we can have. That's my comment.
Peg, I just wonder, do you want to take a quick stab at the bonus question of, do you see Asia Pacific potentially leading the way on this? Or?
Definitely so. And then together with working with the Ministry of Justice here. And so especially for the human resource training side is a kind of a goal for our side recently. Yes.
Terrific, thank you. That's very encouraging. And then let me go to you, Mr. Nohyoung. The floor is yours. 2 minutes.
Thank you. I shared the chart where we see the mediation ecosystem, the government, agencies, the courts, the businesses, and the lawyers, the law firms. And for the in-house, I consider them under the lawyers as well. You need all of them to work together. So we need to address this issue on a complete total front, in a sense. And the ADR centers play a very important role to connect each one of them. And how we can do so, in addition to training, is really success stories. We need more success stories, and I know many of them are confidential, but to the extent that you could make that known, whether it's data, whether it's percentages of success, whether it's the savings, whether it's particular cases that see really wonderful resolution, win-win on all sides, I think that will drive the users, because at the end of the day, you want the Singapore Convention to be useful. And if the users see that it is useful, you can be sure that they would definitely take advantage of it. And as to your second question about Asia, I think Asia should definitely play a leading role. I mean, you look at the growth of business in Asia, you look at the number of cross-border disputes that's happening in Asia, and that's where I think the group here is a very good starting point. ADBI and ADB taking the lead, we can work together to collaborate, right? To ensure that this message, this movement, I would say, not just a message, this movement goes out to the businesses, the governments, the courts, as well as to the law firms. Thank you.
Thank you very much, Mr. Well, I have to say, speaking for myself, and I'm sure for Dean Sonobe being with the Asian Development Bank and the Asian Development Bank Institute, hearing the very positive things you have to say about the likelihood that this region can be a leader is terrific. And I think that since our goal at ADB is to help, mobilize private sector capital, mobilize development for our developing member countries, so many of which, we're honored with their presence here. It's a great message to take away. I'm conscious that we have just a couple of minutes left before we're going to go to Q&A for the audience. And I see, Natalie, you've been watching intently and listening very patiently. Of course, you set us off the path to this very good discussion with your excellent summary. I just wonder, I think it would be appropriate to give you just a couple of minutes to come in with any of your thoughts, either on these questions or anything you heard. So the floor is yours. Thank you.
Thank you very much, Thomas. I thought I'd come in on the questions that you raised. Asia Pacific leading the way, I think definitely that's something that we can look forward to with a pivot to Asia, but also Asia in its experience has a very positive story to tell. There is diversity across Asia economically, culturally, legal tradition-wise, but yet we're all able to come around and use mediation as a positive tool in dispute resolution. And I think that's a very powerful story for the rest of the world. world. In terms of recommending for what I would recommend for the uptake of mediation, fully agree on training. Mediation in a lot of jurisdictions is a very nascent practice. And so training to also for their familiarity, I think, would be it. In terms of recommendations to increase adoption of the Singapore Convention, I'd say go ahead and write it in your settlement agreements already. Refer to the Singapore Convention on Mediation. There's no need to hold your hand while governments are taking their steps to sign and ratify, because by the time you want to rely on that clause, you want to be ready to have that clause on hand, which will be many years down the road. And by that point in time, I think we can have the confidence that governments would have caught up with the rest of the commercial and business world. My last point is on hybrid modes of dispute resolution. Just wanted to put a note that actually the Singapore Convention on Mediation does accommodate this happening. And with the definition of mediation, the negotiators considered hybrid modes of dispute resolution, and the way the definition is framed deliberately leaves the door open to that possibility. So med up, and so on. The settlement agreements that arise from such processes can also be enforced under the Singapore Convention on Mediation. Happy to, put that positive note in as well. Thank you.
Wow, Natalie, I'm so happy that we got your last interventions there. So much, many rich recommendations in what you said. And I think the point particularly about sort of almost proactively anticipating the eventual ratification by getting the language in there. Don't wait, be proactive, do it now so that you're ready when those ratifications come and are able to sort of, start using it right away. Absolutely terrific thoughts. So thank you very much for that, Natalie. Let me now move to Q&A with the audience. I don't know if we have a way of getting some people online with questions, but in the meanwhile, I see two hands in the room. Let me first, sir, you, may I recognize you for your brief question, please?
Thank you. I'm from Cambodia. My question goes to Mr. Taka Turi. You mentioned about the difference between a common law and civil law system in terms of international mediation. In practice, do you see big gap between the two systems?
A good question. Although that's getting more hybrid and harmonizing, because for example, like we have no more purely Japanese companies like like a Toyota or Nissan or something, which has the American facility relative affiliated or something, and they are retaining the U.S. common law in-houses or whatever something. But anyhow, although there is some kind of a conceptual difference between those two cultures, like common law style prefers like a facilitative methods for mediation, and then the civil law type of culture prefers like more evaluative type of mediation. But even for the such common law practice, we have many mediators who can utilize nicely the evaluative side. And like for example, like Tony Piazza, very famous Maui Island, California mediator. He is doing like an evaluation on the through the those facilitation. So and also, for example, like a Japanese corporation, like some evaluation to persuade the management, but still they would like to take into their business interests by facilitation. So such kind of combination would be a better function. So I think the more hybrid and harmonizing is going to be a future.
Thank you, Takutori Sensei, very much. Was there a question, I think, over here? Yes, the lady down the end, please.
Yeah.
Oh, who you'd like to direct the question to? Thank
you. Good morning. I'm Lilith Petrosian from the Arbitration and Mediation Center of Armenia. My question is presented to our lady who introduced the Singapore Convention. So the question is the following. Armenia is a signatory to the Singapore Convention, but I believe that in Armenia and also maybe in other countries, the ratification delay is related to the regional differences. The context of mediation is quite different. For example, we have our accreditation requirement for the mediators, and only the settlement agreements which are signed by the licensed mediators will be enforced in our country. So my question is that compared to the New York Convention, which has a refusal ground where the arbitration proceeding or the composition of arbitral tribunal is on the contrary to the law of the place where the arbitration happened. What happens if in mediation, for example, we receive a settlement agreement which is signed by a mediator who is not licensed, but that country requires a license, and then that settlement agreement comes to the enforcement? What do we do? Because this ground is absent from the convention. Can this be interpreted as...
Thank you, Natalie. I think the question is for you.
Thank you very much, Thomas. I think at the outset, I would say that in terms of whether or not you need to consider the characteristics of mediators and their professional qualifications is something that I remember we considered when we were preparing the convention. It was deliberately left out as a prerequisite in order to have enforcement of a mediated settlement agreement pursuant to the Singapore Convention framework. For Armenia, per se, if they receive such settlement agreements where there is a mediator involved who's not been professionally qualified, I would say to be in keeping with the intent of the Singapore Convention, there's no need to apply that qualification requirement. But it might be that in certain situations, it could rise perhaps to a level of public policy, or maybe there's a question of standards, then you would utilize the grounds of refusal on those points. The public policy standard, however, is a very high one that would need to be crossed. So so it does sound like there's a need to have some kind of rationalization there between the domestic regime and what the Singapore Convention envisions. These are my own views only. I think this point in particular, that you will find that there are differing views on it. But I hope that's helpful.
Thanks, Natalie. Very good. I hope that's helpful as well. I'm just going to go to the first question from online participants, just to be fair and equitable to those who can't be here in the room. It's, I think, a somewhat related question to the last one, but I'll let whoever feels they wish to answer it raise their hand and answer it. Where can we contest when the mediation award gets refused to be enforced on the grounds of refusal or state sovereignty prevails? So a little different context than the last question, but generally, anyone want to take a crack at that? And if not, Natalie, your thoughts as well might be welcome here. May have lost Natalie. I don't know. Would anyone like to take a crack? Sure, go ahead, Dr.
Yeah, we may have lost Natalie. I do note that it's almost midnight there in New York. I think the contest will be at the local courts itself, because the enforcement is at the local courts. And so the local courts will decide whether there are specific grounds, and within the convention itself, there are specific grounds which you can refuse enforcement, but those the bars are pretty high. And the reason for that is you want to try to give parties the autonomy, because they decided to do the mediation. They have come to the settlement agreement itself, and therefore under the convention, unless there are very good exceptional reasons, these mediated settlements should be enforced.
Just hypothetically, if the target assets are located in multiple locations and jurisdictions, then the result could be differing, depending upon the local state sovereign's judgment or something. But that's okay, I think.
Oh, very good clarifications. I think we have time for one more question. I think I saw one over here. Yes, please, go ahead.
Thank you very much. I'm from France. I'm one of the interns working here at ADBI right now, and I wanted to direct my question to Mr. Chen in relation to the regional disparities in accession to the Singapore Convention. Coming from a European Union, looking at the map presented earlier, it was a little bit shocking to me to see that no member countries have joined it. So I wanted to ask about your insights and your opinions to why that is the case. Thank you very much.
Thank you for the question. It means that France and other places will have a lot of work to do. But really, what happened was that when it was gathered at UNCITRAL to try to resolve this and have it signed, the European Union, of course, has 20 over member countries. So some of them wants to sign, some of them say they need more time. and they wanted to sign as a block. And as you know, when you want to do things as a block, it will take time, it will take more deliberation. And of course, war then happened in Europe, and there are other things that overcame that. What is very interesting is that UK is the exception. UK didn't sign until they left with Brexit. So maybe that's one positive thing about Brexit. But the UK has also committed to ratify. So I think we are working with different parties in Europe to try to either consider signing as a bloc or even for individual countries to sign. I think the important thing is this, is that whether they sign as a bloc or as individual countries, that we do continue to reach out to the European countries because they are so important to the global economy, and we want them to be part of this. And maybe this is something that Asia can perhaps be an example because Europe is also very diverse if you think about the different countries, but Asia maybe is one area that we can take the lead. Thank you.
So thank you. Thank you for wrapping up on that note of maybe Asia can play a leading role. I think that's a good way to wrap it up. With that, our time is exactly up. And I'd like to take this opportunity to really thank Miss Natalie Morris Sharma. Terrific beginning and terrific ending questions. Thank you so much. And of course, Professor Oh and Dr. David Chen and Takatori Sensei and Mr. Chuan Wee Meng, you've given us a terrific session here, a lot of information and a lot of hope. So thank you all very much. It's been a pleasure.
I will go over Japan's approach to invigorating arbitration and mediation. And I hope my presentation will also be a follow-up to the previous panel discussion. Before moving on to the slide, I'd like to reflect on yesterday's discussion and the points raised by the distinguished professor of Korean University during the keynote speech this morning. What are the advantages of arbitration and mediation? Cost efficiency, time saving, the ability to choose an arbitrator or mediators, creative solutions, and if the parties reach a settlement, they can preserve relationships. Yes, all of these are true. Then what are the disadvantages in arbitration or mediation? Both arbitration and mediation are obviously party-driven dispute resolution mechanisms. Unlike civil court proceedings, which is a default mechanism that are automatically applied to disputes, the arbitration and mediation do not apply unless the parties agree to use them in their contract. This is why raising awareness among users is so important. We need to make arbitration and mediation more familiar to the public. Otherwise, they may never even know these tools. Actually, it is said that some medium and small-sized companies in Japan opt for court proceedings simply because they are unaware of arbitration or mediation. So we recognize that the government's role is to fill in this gap so that parties can make informed choices, informed decisions on their contract to prevent potential disputes and to achieve most efficient dispute resolution. With this in mind, let's begin with the current progress of our initiatives. Okay, right. And let's begin with jumping to page 4, which is the latest development of the government policy. In May of 2024, after long discussions among various stakeholders, the Japanese government established a new policy, which is called the 2024 policy. This 2024 policy emphasizes the promotion of the rule of law through widespread use of arbitration and mediation clauses in contracts. And in the pursuit of this goal, the government shall maintain trust in ADR mechanisms and enhance human resources in this field. Since the establishment of this new policy, we have entered into the new phase, which is implementing the initiatives according to this new policy. Oops. First, Japan has been engaged in raising awareness about the effective use of international ADR mechanisms, targeting businesses, particularly small and medium-sized enterprises, and contract lawyers involved in international transactions. As part of this initiative, we held an important event, the Japan International Arbitration Week, in November 2024 in Tokyo. This event has become a meaningful platform for discussing the future of arbitration and mediation in Japan and beyond, providing a valuable opportunity for networking and knowledge exchange among professionals and businesses in the field. Also, I'm happy to inform you that we will hold the Japan International Arbitration Week 2025 in Tokyo from the 25th to the 28th of November 2025. We are still at the planning stage, so everything else is up in the air, but we'd be very pleased if you could save the date. So from the 25th to the 28th of November 2025. And secondly, to build trust in Japan's arbitration institutions, the focus should be on improving the global standing of organizations such as the Japan Commercial Arbitration Association or JCAA. Also, we are engaged in rulemaking activities with international organizations such as UNCITRAL. As part of these activities, the government of Japan, together with Germany, Israel, Republic of Korea, and Spain, put forward a proposal that the Working Group 2 of UNCITRAL should work on developments of international legal frameworks for electronic arbitral awards. Because currently in practice, the rendering and the delivering of the awards are being done in paper-based, which causes a huge waste of time and cost. With overwhelming majority support, the commission session of UNCITRAL approved our proposal in July of this year, of 2024, and currently we are discussing the future instruments that could be used for the efficient and streamlined procedure for electronic arbitral awards. On top of that, a crucial part of Japan's strategy involves the cultivation of human resources skilled in international arbitration and mediation. This includes providing educational opportunities for university and law school students, legal apprentices, and young practitioners. In the middle of the photo above is Takatori Sensei, who has kindly participated in the legal apprentices program as a lecturer for the future arbitration and arbitrators and mediators. Furthermore, recognizing that international ADR is primarily driven by the private sector, the Japanese government is committed to supporting closer cooperation between public and private entities. Japan aims to play a leadership role in strengthening ties with the legal profession, business community, international organizations, and foreign governments. In doing so, Japan seeks to act as a bridge between civil law and common law countries, facilitating smoother dispute resolution across different legal systems. These photos are taken during the Singapore Convention Week 2024, where Mr. George Lim and Mr. Chuan Wei-man kindly invited us to give a speech during the SIMC 10th anniversary event. In the final part of my presentation, I'd like to briefly touch on the legislative development in mediation. Mediation has a huge potential in providing swift and less costly dispute resolution. But the downside was the lack of enforcement mechanisms, because mediation is obviously out of the scope of the New York Convention. Now that enforceability has been added to the mediation due to the Singapore Convention on Mediation in 2018, I think it will become much more useful as the number of contracting states grows. Japan is the 12th party to the convention. And in accordance to the Singapore Convention, Japan declared the reservation in accordance with Article A1B, but I'm aware I'm running out of time, so I will leave the details of this reservation to the Q&A session. And yeah, And I hope that Japan's accession to the Singapore Convention will encourage other states to consider joining this convention. And as the number of contracting parties to the convention grows, the use of mediation for settling commercial disputes will be further promoted globally, thereby promoting the rule of law. This is the conclusion of my presentation. Thank you very much for your attention.
Thank you very much, Miyazaki-san, for sharing many concrete examples of the actions your country is implementing to support international mediation. I will keep in mind raising awareness events, upskilling professionals, also this collaboration with international organizations. And rest assured that during the Q&A session, we can ask you more detailed about some points. So now turning to our representative from Papua New Guinea, Mr. Derek Wood, you are the judge of the National Court and Supreme Court of Papua New Guinea. So could you share with us your approach to support international mediation?
Right. Thank you, Agnes. Can everyone hear me? Good morning. And yes, my name is Derek Wood, and I'm from Australia, but I work in Papua New Guinea. And for those who have not been there, Papua New Guinea is just north of Australia, and over the years has had long historical ties with Australia. And it's a long story, but I've started my professional life midway through 2004 working in Papua New Guinea. So I've been working there for 21 years. I'd like to acknowledge the efforts of the organisers of this workshop in bringing everyone together. Not only is it worthwhile in meeting others, but these sort of workshops give you a real sense of how your judicial system is tracking against other jurisdictions. And it's been very worthwhile for me over the last day and a half, listening to others talking about mediation and arbitration. In terms of answering this session's questions, it's very necessary, I think, to give a very brief overview of the legal system in PNG. I've worked there for 21 years, as I said, initially in private practice as a lawyer and partner at a law firm, Ashurst, and then over the last year and a half as a judge of the National Court and the Supreme Court. For those who don't know much about PNG, population of about 10 million people, and contrasted to that, 42 judges. So 10 million people, 42 judges. And so you can imagine that we have got our work cut out for us. One of the biggest issues that we have is dealing with not only new cases, but the backlog of some 20,000 cases. So in the context of 42 judges, you have to consider how we're going to deal with that. So there are obviously a number of strategies, including that there's going to be the appointment of more judges up to a ceiling currently of 60 judges, and with an end view of 200 judges. 42 judges, including of us, are 8 expatriate judges, mainly from Australia. But also other ways to resolve the backlog of cases, of course, are the use of arbitration and mediation. In terms of arbitration, PNG ratified the New York Convention in 2009 and subsequently led to the repeal of the 1951 Arbitration Act, and of course the enactment last year of 2 pieces of legislation, the Arbitration Act of both domestic and international. And with that, of course, you need, as we know, we've been talking about awareness and training. So, for example, we've got ADB sponsored training for judges and lawyers in May of this year, which is very important. In terms of mediation, much of this is being led by the ADR Centre, which is part of the National Court. The chair of our ADR committee is the Deputy Chief Justice, Ambeng Kandakazi, who I think quite a number of you here know, and as you know, he's a very passionate advocate of ADR. There are 8 of us on this ADR committee, and we introduced ADR rules in 2010. So relatively speaking, PNG in terms of court annex and mediation, 15 years, but we've got a long way to go. Our system of mediation may be common law country, but it may be different to some jurisdictions where at the first return date, a judge has to make a decision about whether or not to refer a matter to mediation. And if that does happen, then mediation is compulsory, and there's a good faith requirement. And so, for example, if you don't mediate in good faith, for example, if you're the plaintiff, your claim may be dismissed, or if you're a defendant, your defence may be struck out. There are those sort of implications. In terms of our success rate, the success rate of mediations in PNG court annexed is about 50%, which is good, because you not only do you have to convince the lawyers, but particularly judges, that mediation is a good thing. In terms of one of the key questions about why are we here today talking about in this session, the Singapore Convention. Yes, the ADR committee, which I said is one of the largest drivers of ADR in the country, is on board with PNG ratifying the convention. But as you can appreciate, that is a long process. And so that requires more discussion at the ADR committee level, but that will occur very quickly because we've already been in discussions about it. And then if all goes well, then it will lead to a resolution to go to the next level, which is to engage with the State Solicitor's Office and take it there. But with that, of course, and as I was speaking to Thomas Clark and others this morning, training and awareness is vital to that process. And that's why, if we can, we'll be looking to ADB and others to assist in that process, including that, as I said, ADB is assisting with training on arbitration, which is coming up in May. The second question, of course, and I realise I've got 1 minute left, of course, is the second question about other measures to divide the space between traditional methods of dispute resolution, such as litigation, and new ADR methods. Just very quickly, we introduced into the National Court last year a REC track, RECC, Resources, Environment, Climate Change, and I'm now the track leader of that track, where we've done it probably around the wrong way, but we've actually got an established track, but we're now developing REC track rules, and that's very much largely focused on ADR and ADR techniques to resolve resource and climate change driven matters. But that's essentially an overview of the system in PNG. I'm happy to, when we go to Q&A, to talk more about it, conscious of the time. But in terms of the bottom line, yes, ultimately PNG is very much behind the idea of ratifying the Singapore Convention. And thank you.
Thank you very much, Mr. Derek Wood. So I will keep in mind the importance of training of professionals, and also raising awareness on the importance of this tool. So now turning to our representative from Mongolia. So I'm very happy to welcome Mr. Ogerel Solomon, who is the head of the International Arbitration Division of the Ministry of Justice and Home Affairs of Mongolia. The floor is yours.
Good afternoon, ladies and gentlemen. My name is Solomon, and I'm the head of the International Legislation Division at the Ministry of Justice and Home Affairs of Mongolia. Foremost, I would like to thank the ADB, the ADBI, and the government of Japan for co-hosting this event. I would like to state that the insights and engagements have made this event truly valuable, and I'm grateful for the opportunity to share and learn together. Today, my presentation will focus on Mongolia's experience with ADR and our current policy direction towards incorporating international good practices. Which way do I point? Thank you. So the first arbitration institution in Mongolia, specifically the Foreign Trade Arbitration Court, was established on July 2nd of 1960. Which was to oversee resolving foreign trade disputes. However, some of you might be familiar that at that time, Mongolia's trade was done with a sole and only one partner. Thus, there was a limited possibility for it to strengthen institution-wise. In a more modern sense, Mongolia became a contracting state to the ICSID Convention in 1991, and the state party to the New York Convention in 1994, with common declarations in respect to reciprocity and international commercial and resolving international commercial disputes. However, it is only in the past 2 decades that commercial arbitration and mediation has seen development as a modern alternative form of dispute resolution in Mongolia. Next slide, please. No problem. In particular, the revised Arbitration Act was passed by the Parliament on January 26th of 2017. And the text of this act is substantially based on the UNCITRAL model law. It is also important to note that the Arbitration Act applies to both international and domestic dispute resolution. For example, a specific article within the Arbitration Act states that an arbitration award, irrespective of the country in which it was made, shall be recognized as binding, and upon application in written form to the competent court, the award shall be enforced subject to provisions of articles of this law and the basic arbitration award in accordance with the procedures set forth in the New York Convention. This article basically declares that irrespective of the place of the award, Mongolia recognizes that it is to be enforced. However, if the disputing parties is to file an application to a domestic court for it to be enforceable. Next slide, please. As for mediation, Mongolia first adopted the Mediation Act in 2012 as part of the judicial reform process and to reduce the burden on domestic courts and offer alternative dispute resolution options. This law establishes the legal basis for resolving disputes through non-judicial mediation with the support of an accredited mediator, regulates the enforcement of settlement agreements. The scope of the act is primarily focused on civil law disputes, labor disputes, and family disputes, and its aim is to create favorable conditions for citizens to resolve their issues in a more cost and time-efficient manner. In addition, I would like to state that Mongolia, upon adopting the Mediation Act in 2012, its text was heavily influenced by the UNCITRAL model law on international commercial conciliation. Next slide, please. This table shows the statistics from 2019 to 2023, in which you can see that out of a total of 231,000 civil cases, 45,000 of which, an average of around 20%, were successfully resolved through mediation, which is a significant number, showing reduction on the burden of civil courts by that percentage. However, the core reason for using mediation, which is to aim at strengthening and increasing the preference of our citizens to use this practice in disputes other than family and labor disputes, are still persistent. According to the evaluation report done by the Ministry of Justice, Mongolia's reluctance to incorporate a provision with regards to the enforcement of settlement agreements is serving as a caveat in its development and making mediation a less favorable choice for dispute resolution domestically. Even if mediators in state and non-governmental organizations and professional associations successfully resolve certain disputes, the settlement agreement by law is required to be confirmed by a judge's order for it to become enforceable, which often leads to additional costs and time wasted in going through litigation process for the same dispute again and again. Last slide, please. In conclusion, although Article 8 of the Mediation Act states that state and non-state organizations and professional associations can provide mediation services, results show that its implementation has been limited. As mentioned above, the reason for the lack of preference for choosing mediation as a alternative form of dispute resolution is because of the settlement agreements being required to be approved by a separate judge's order. Therefore, in accordance, the Ministry of Justice and Home Affairs has begun work on drafting a revised version of the Arbitration and Mediation Acts with plans for it to be passed by late this year or early next year. Thank you.
Thank you very much for sharing perspective from Mongolia. I guess once the new text will be approved, you will need some resources to train relevant people and make sure this new text is well understood. Happy to further discuss this during the Q&A session. So now I'm happy to give the floor to Mrs. Gina Park, who is the Deputy Director of the newly launched International Legal Affairs Department of the Ministry of Justice of the Republic of Korea. The floor is yours.
Thank you, Ms. Suri, for the introduction. Good morning, distinguished representatives, ladies and gentlemen. My name is Gina Park. I'm a Deputy Director of the International Legal Policy Division of the Ministry of Justice of the Republic of Korea. I would first like to express my sincere gratitude to the ADB, the ADBI, the UNCITRAL, and the Japanese Ministry of Justice for organizing this dialogue. Next slide, please. Republic of Korea has acceded to the New York Convention, adopted the UNCITRAL model law on commercial arbitration, and makes multifaceted efforts to create a ADR-friendly environment, including hosting the annual ADR festival. Out of all these efforts, I would like to focus on the implementation of the Singapore Convention. Today, due to the time constraints, I kindly ask for your understanding, as I will only be able to cover the brief overview. Next slide, please. And the next slide, please. The Republic of Korea signed the Singapore Convention in August 2019. As the authority responsible for adopting and implementing international norms, the Ministry of Justice launched a task force in March 2021. The task force, composed of the mediation experts, both from academia and the field, aims to develop the necessary implementation legislation. The task force held its first meeting in March 2021 and its second meeting in December 2022. However, further discussions were put on hold due to the outbreak of the pandemic and the establishment of the International Legal Affairs Department as a separate authority, which required related personnel to adjust to their newly appointed positions, and of course, the disagreements on the legislative methods. Recently, the Ministry of Justice has resumed the operation of the task force starting last September to continue the discussions on forming the implementation legislation. Next slide, please. The task force aims to formulate implementation legislation that is tailored to the current state of affairs in Korea, taking into careful consideration the domestic legal systems. Mediation in Korea could be divided into three categories. First is court-annexed mediation, which involves court intervention. The second is administrative mediation, where mediation services are provided by various administrative agencies. And the third is private mediation, which encompasses all kinds of mediation aside from the aforementioned two. As you all know, under Article 1, Paragraph 3A of the Singapore Convention, the Convention does not apply to the court-annexed mediation. In Korea, administrative mediation pertains to the resolution of conflicts among private individuals through mediation provided by administrative agencies. Typically, Disputes in specific fields are handled by relevant administrative agencies. For example, the Korea Creative Content Agency's Content Dispute Resolution Committee mediates disputes in the content industry, while the Housing and Commercial Lease Dispute Conciliation Committee addresses lease disputes. Administrative mediation often carries the same effect as the final judgment of the court under relevant laws. Therefore, the convention specifically applies to the private mediation, particularly in a commercial context. Regarding the scope of mediation to be covered in the implementative legislation, the task force considered various options. The first one is to create an implementation legislation that applies only to the specific types of mediation encompassed by the convention. The other option was to legislate a civil mediation law that encompasses all types of private mediation, thereby reforming the overall mediation system in Korea. Next slide, please. If the civil mediation law is legislated, it is expected to enhance the systemic consistency by overhauling the overall process of mediation in Korea. However, this broader approach may prolong the legislative process and increase the likeliness of objections from various sectors due to its scope. Next slide, please. Considering these various factors, the task force has reached a consensus that a phased approach to legislation would be more effective. Specifically, we plan to first enact an implementation law that solely applies to the types of mediation covered by the convention. Following that, we will focus on the overall organization of our mediation system, including the enactment of the civil mediation law in the future. As we have in mind the legislation of the civil mediation law in the near future, we are debating the qualifications and the duties of mediators, mediation procedures, and so on as well. The next slide, please. The International Legal Policy Division of the Ministry of Justice is intensifying its efforts to draft the bill for the implementation legislation by holding monthly meetings of the task force. We plan to conduct approximately 10 meetings by June this year. We also plan to host a seminar inviting experts from both academia and private practices to incorporate their feedbacks to the final version of the bill this fall. We aim to submit the bill to the National Assembly at the last quarter this year. The members of the task force agreed on the importance of the systemic coherence, emphasizing that the implementation legislation must be aligned with other similar systems to be practically useful for the parties involved in the international commercial disputes. Therefore, in addition to deliberating on the legislative method, the task force is exploring ways to achieve a balance between the implementation legislation and related systems such as the order for payment, arbitration, deed of execution, and so more. Through ongoing discussions on these issues, the task force aims to finalize the draft for the bill, which will come into effect following the National Assembly's deliberation. And that would be the wrap up of my presentation. I genuinely hope that it has contributed to your understanding of the adoption and implementation of the Singapore Convention in Republic of Korea. Thank you for your time and attention.
Thank you very much, Mrs. Gina Park. Just a follow-up question. You mentioned the task force. Who are the members of this task force?
Would you want me to name names?
No, more like functions. Where do they come from? Are there officials? Are there representatives from the civil society or the private sector?
The task force is aimed to develop the enactment law. As I've mentioned in the presentation, it composes of both the representatives from academia, the professors are in related fields such as the international laws and civil procedure law, and of course we have representatives from the private sector as well, the ADR organizations such as KCB, and of course judiciaries and the legal practitioners who are currently working as mediators, so that we could get various inputs into the bill.
Very much for sharing this. I think it's a very important point to understand this composition, because this task force is critical to also build consensus around this project and make sure the final output is useful for all stakeholders. So thank you for sharing that. So now I'm happy to give the floor to our representative from India, Mr. Arora. Welcome to this session. You are the Joint Secretary of the Ministry of Law and Justice in India. The floor is yours.
Hello, am I audible? Namaste to all of you present here and online as well. I'm very thankful to ADBI, United Nations Government of Japan, to provide us this wonderful platform where we can share our views, our perspective from the country's point of view. So far as India is concerned, the Indian government is so much concerned and worried and focused on the ADR. As a result, the apex position has been created in the government of India at the joint secretary level, so that I am here to represent India as a joint secretary, arbitration and conciliation. So we are very, very much concerned about the ADR, and now we are introducing ADR in many forms. Already the concept of ADR, so far as is concerned, is nothing new to India. Since thousands years ago, when I don't know whether you're aware or not, but as per the Indian methodology, Mahabharata happened in India. It was a big, great war in between Kauravas and Pandavas, and Lord Krishna, who we deem to be our God, they went to the Kaurava to have just 5 villages for the Pandavas, but the Kaurava refused, as a result of which lakhs of people died. So just imagine, had they given the 5 villages at the time of Mahabharata to the Pandava, the battle would have never happened. Lakhs of lives could have been saved. So the importance of mediation is this. Again, I would reiterate that an ounce of mediation is worth a pound of arbitration and tons of litigation. So mediation is so much important right now that we have to understand. Being a ADB, it's a bank, we are mainly concerned with the commercial disputes, and the commercial disputes, the focus is on money, the flow of money. Just imagine the flow of money, if it hampers due to litigation, whether from the point of the A party or from the point of B party. Ultimately, both the parties have to suffer in litigation. If today you need something to eat right now, you are in starvation or in hungry, and if I give you the food after 10 days of litigation, just imagine what would be your status at that point of time. So this is, in my view, is the importance of mediation right now. Anyway, I would like to now go to my slide, please. So vision, to promote institutional arbitration in the country, to make India a hub of commercial arbitration, to develop a class of professional arbitrators and a dedicated arbitration bar. And now the arbitration bar has come into being in India. Then to prevent arbitration matters and forex reserves from going abroad, to facilitate ease of doing business in the country, to reduce the burden on judiciary. Before we go to the other slide, I would like to apprise all of you that now we are carrying out certain amendments in the Arbitration and Conciliation Act, which are underway. Maybe in the coming budget session, which is now going on, in the coming budget session in the Parliament, we are likely to introduce the same amendments. The major portion of the amendment is to have special dedicated arbitral courts in each state of the country. So all arbitration matters, which say that that it takes long the matter, long litigation. So drastically, we are going to reduce the time. The cost effectiveness of the parties is to be seen. So we are having now a dedicated arbitral courts in India, which would exclusively adjudicate upon the arbitration matters. Now I'll come back to my slide. Now, modes of dispute resolution mechanism. It's a conciliation. Now, the name of the Arbitration Act in India is Arbitration and Conciliation Act so far, but in coming just few days, now the Arbitration Act would be, as amended, would be Arbitration Act, and the Mediation Act in 23 has come into being. Of course, yet the Mediation Council of India is yet to be established, but I hope that it is expected to come up within few months. So now another mode of ADR is, negotiation, mediation, arbitration. Then of course, the most important part is the confidence of the parties that they have to resort for the mediation. That is the most important part. The person, mediation gets successful only when both the parties have trust in a person. I have heard so many times that you need trained mediators, you need training programs, you need lot of classes for the mediations. It's all right. It's one of the part, because yesterday itself a doctor to ADR, it's a good concept. But I personally feel that the parties have to be encouraged that they should opt for such a mediator in whom they can completely repose trust, that whatever be the outcome of the mediations, at least the person would be fair to both the parties. Then again, now ADR mechanism currently prevalent in India, arbitration already pointed out, then conciliation, now it's going to mediation, then Lok Adalat. Yesterday, I think an advocate from our side, Ma'am Reema, had already discussed about the Lok Adalats. This is basically court annexed mediation in one way. Next. Then legislations promoting for mechanisms in India. Now we have certain legislations in India which are promoting mediation in their own way. Like we have CPC, where Section 89 provides that the courts would encourage the ADR. Then we have industrial disputes for the disputes between the laborers and the employers. That Section 4 provides for mediation of industrial disputes by officers appointed by the government. Then we have, certain provisions of the domestic personal laws like Hindu Marriage Act, Special Marriage Act, Family Courts Act, where required the court to first instance to make a mediation between the parties. Then Section 19 of the Legal Services or Lok Adalats again. Then we have Arbitration and Conciliation Act again. The Part 3 of the ANC Act deals with the conciliation, now subsumed with the mediation part. Next. Then we have Companies Act again. Company law, National Company Law Tribunal, Appellate Tribunal, read with companies, rules, etc. All now, promote mediation in one way or another. Then Section 12A, it is a mandatory provision under the Commercial Courts Act. I am the custodian of 3 acts in India. One is the Arbitration and Conciliation Act, another is the Mediation Act, and the third one is the Commercial Courts Act. And the focus of all these acts are to promote ADR by one way or the other. Now, Section 12A is the PIMC, pre-institution mediation commercial courts. It's a mandatory for the parties to go for the mediation before the regular trial begins. Then we have real estate business there. Again, the real estate RERA, there is an authority, statutory authority, which has to see that the first and foremost step is taken to, in case it is possible, amicable solution of the dispute between the parties. Then we have the Consumer Protection Act for the protection of the consumers. Again, we have the ADR mechanism in place. Next. Then again, Arbitration Conciliation Act has been continuously amending since 1996 till now. Again, the amendment is to take place very soon in the coming budget session. I already pointed out that certain significant changes are being done. The time caps are being, the limitations everywhere. The time slot is being plugged. That wherever there is a scope for the discretion of the courts to have the adjudication, prolonging the time by the parties or otherwise, then now we are plugging all those, putting some time constraints for the disposal of the applications or petitions. Then again, commercial courts already there. I told you that yes, now pre-institution mediation settlement is there. It is once settlement is arrived at, it is as good as decree of the court. Next slide, please. The India International Arbitration Center Act 2019. This is, basically the object of and the aim of India to make India as a hub of the arbitration. A step towards this direction, we have come with the India International Arbitration Center. They are collaborating with the other countries also, with other institutions also, to have a common platform for training, for conducting arbitrations, for empanelment of the arbitrators at the national and the international level as well. Then we have Mediation Act, of course. That is the major act right now in focus. So that has already come into being in 23. Now, under the Mediation Act, the Metal Mediation Settlement Agreement, MSA, would be there. once the MSA is arrived at, it is as good as the decree of the court. It would be enforceable in the courts of law. Then we will be having the service providers as well under the Act, which will be accredited and graded by the Mediation Council of India, which has yet to come. And I'm hopeful that in coming months, we'll be having the Mediation Council very soon in India to take care. Although it's all right, the mediation is still taking place in various forms, I already pointed out, but in full form, we just want in full pace. Once the Mediation Council of India comes into being, the provisions of the Mediation Act would be enforced in toto. Next slide, please. Then Arbitration and Conciliation Act, basically part one deals with the arbitrations where the seat is India, has no application to a foreign seated arbitration. So it is a complete code in dealing with the appointment of arbitrators, commencement of arbitration, making of an award, challenges to the aforesaid award, as well as execution of such awards. Now, Part 1A provides for the establishment of Arbitration Council of India, already told, a national level body for grading of arbitral institutions with a view to promote institutional arbitration in the country and to develop India as a hub of the international arbitration. Then Part 2 deals with the enforcement of foreign awards as defined in India. Part 3 deals with the conciliation. Now it is now in future it would no more be part of the arbitration and conciliation. It would be subsumed with the Mediation Act. Then Part 4 deals with the miscellaneous provision. Please. International commercial arbitration. The provision makes the application of Part 1 to the arbitration taking place in India. Section so-and-so lays down that an arbitral award made in Part 1 shall be considered as domestic award. Thus, an award in international commercial arbitration as well as local domestic arbitration results in domestic awards. Now, international commercial arbitration with a seat in a foreign country, in a case seat of arbitration is a foreign country, then Part 2 of the Arbitration and Constitution Act 96 will apply. Next slide, please. Foreign award when binding. According to Section 46 and 55 of the ANC Act, any foreign award that is a New York or Geneva Convention award, which would be enforceable under the Act, shall be treated as binding for all purposes on the persons as between whom it was made, and may accordingly be relied on by any of those persons by of defense, set off or otherwise in any illegal proceedings in India. Yes. Next. No, next slide, please. It takes some time. Next slide, please. Now, Mediation Act. Go back. This is the Mediation Act. The parties are free to agree upon the name of the mediator and the procedure for the appointment of mediator. The role of mediator is to attempt to facilitate voluntary resolution of the disputes between the parties. The option of voluntary pre-litigation mediation has been statutorily enabled for civil and commercial disputes before parties approach a court or tribunal for adjudication. The process of mediation is to be completed within a period of 120 days from the date fixed for the first appearance before the mediator. However, the parties may agree for further period of 60 days. Matters which are not fit for mediation have been enumerated in the list under schedule to the bill. Mediation settlement agreement resulting from mediation is final and binding as enforceable in terms of the provisions of CPC, Civil Procedure Code, the same manner if they were a judgment of the court. Now, just few minutes ago, number of speakers have already, spoken on UNISA, United Nations, Settlement Convention of Singapore. So we are signatory to that. Of course, we have already carried forward the 3 basic points, which are the core center of the Singapore Convention, to have mediation laws in your country, that we already, have a Mediation Act in place. Then to promote mediation in our country by institutions or otherwise, that we already, moving ahead in that direction. And of course, the enforcement of the mediation settlement, that is already, we are taking care of, that any settlement arrived in terms of the provisions of the Mediation Act, it is as good as the decree of the court, enforceable. And already pointed out that we are really working very hard that the, wherever possible, the litigation process, the timing, involved in the litigation be reduced to the maximum. Now the judges are being trained. The lawyers are being trained. Lot of institutions have already come into being. Even the court annexed mediation centers and arbitration centers, they are working very hard upon the lawyers, upon the judges. Whether national, we have a NALSA, which is already in place. The people are, already working very hard to train the judges to promote ADR. Now the ADR is not an issue of one nation, it is an issue of the world. Globally, it's the requirement. because if you want to grow, you have to avoid the litigation. Why? At any cost. Because litigation ultimately would lead you nowhere. It is only the solution of the litigation why you should have dispute. Let's dispute this, resolve the dispute at the first instance itself. So even if there is a dispute, sometimes my observation is practically, since I have been a lawyer for some time in the High Court, that what happens, suppose there are 5 to 7 to 10 points are there involved in the mediation, in the litigation process. So what happens that only 1 or 2 main disputes are the core disputes which require adjudication. The rest points are ancillary to the main dispute. So if possible, the focus should be to resolve all the disputes to mediation, or if somehow, somewhere we just couldn't make it, to at least we can sever those parts which can be mediated, which can be resolved, at least so that the minimum bare litigation we should have before the courts. Although the litigation, I already, number of times insisted at various platforms that it's not the solution at all. Ultimately, the time goes, the money goes, the age of the party goes, the age of the company goes. So ultimately, nobody gets benefit. So thank you very much with this. I'm very, very thankful again to ADB, ADBI, and all of you that you patiently heard me. Thanks a lot. Thank you.
Thank you very much, Mr. Aurora. You clearly shared that India is using several kinds of tools to promote mediation, and we can clearly feel your leadership also to support this agenda. So thanks for sharing this. So now turning to our last speaker. So I'm very happy to welcome the Joint Secretary of the Ministry of Law, Justice and Parliamentary Affairs of Nepal, Mr. Khatri. The floor is yours.
Distinguished all, thank you very much for inviting us in this program. Please accept my greeting of Namaste and warm good afternoon to everyone. I am indeed honored to be present before such learned panel of experts and discuss the environment of ADR process in my country, Nepal, with specific reference to mediation and prevailing laws and practice thereof. Let me start with a brief introduction to myself with reference to my professional capacity. I am Komal Bahadur Khatri, and I work in the capacity of Joint Secretary in the Government of Nepal, Ministry of Law, Justice and Parliamentary Affairs. My office specially deals with government legislation, law reform, judicial administration, parliamentary affairs, along with ratification, acceptance, approval, accession to international agreements, and ascertaining the government position on question of international law. Along with me is my colleague, Under Secretary Mr. Subhakar Ragmi, who is in the experienced bureaucrat. He is currently working at the Government of Nepal, Ministry of Forest and Environment. Now, please allow me to start my presentation. Alternative disputes resolution with special reference to mediation. Nepal has been using alternative disputes resolution, ADR, as a mechanism for resolving disputes since ancient times. ADR has today developed as a legal mechanism used to resolve disputes outside the regular courts. Mediation and arbitration as ADR process have gotten a statutory recognition today. ADR measures like mediation and arbitration is increasingly popular due to its efficiency, cost effectiveness, ability to provide amicable solution, and also for finally of settlement of disputes. Prevailing laws in Nepal provide for provisions where legal disputes resolved through ADR process is barred from being recreated into a lawsuit at the regular courts afterwards. Legislation that provides for framework for ADR in Nepal. 1. Constitution of Nepal 2015 encouraged the use of ADR to promote justice. 2. Arbitration Act 1999 regulates arbitration proceeding. The legislation is based on UNCITRAL model law on arbitration and thereby a certain board applicable of arbitration in contractual and commercial disputes, autonomy of parties with regards to the arbitration procedures, limited intervention of regular courts in arbitration proceeding. The Act also
provides for provision wherein recognition of agreement between parties pertaining to arbitration has been ensured, be it an arbitration clause in primary contract or an agreement reached separately between the parties. Provision regulating the recognition and enforcement of foreign arbitral award has also been given space into the Act. Recent amendment to the Arbitration Act, introduced from an ordinance issued by the government of January 2025, has made provision for fast-track arbitration procedure. Among other things, this provision has ascertained speedy execution of arbitral award through concerned district courts in case fast-track procedure has been applied for the given arbitration. The amendments have also introduced provisions for ensuring finality of the arbitral award by limiting scope of judicial review of the legality of arbitral award. The courts have been prevented from repeating the examination of evidence resorted to the tribunal when reviewing the award. The very instance shows that the government has prioritized legal reform in the ADR sector. 3. Mediation Act 2011 governs mediation process in Nepal. The Act provides for a comprehensive provision relating to application of mediation process and ADR measures in resolving disputes. Provisions for initiation of mediation between parties for resolving dispute, which are either sub judice at a court or which have not been taken in the court, either through agreement between themselves or when resolution through mediation process is referred by an order of the court. 4. National Civil Procedure Code 2017 promotes ADR before court proceeding. 5. Local Government Operation Act 2017 grants local governments the authority to settle selected disputes through mediation. These include petty cases such as small wages, dispute arising from mishandling of chattels, petty spousal disputes, house rent, etc. With reference to the topics, key feature of the Mediation Act. Number 1, scope of mediation. The Act allows for the mediation of disputes that are either pending in adjudicating bodies such as courts or have not yet been filed, provided these disputes are eligible for settlement agreement under prevailing laws. 2. Initiation of mediation. Parties can, through agreement between themselves, choose mediation at any stage of their disputes. For sub judice case at the court, parties may submit a joint application to the concerned court to refer the matter to mediation. Appointment of mediators. Mediators can be appointed based on mutual agreement of the parties involved. The Act provides for the formation of panel of mediators. Special reference has been made to provision regarding mediation referred in the concerned agreement of the parties. Mediation Council. We have also Mediation Council. A Mediation Council is established under the Act as governing authority of regulation of mediation activity. The Council is responsible for approving training curricula, specifying agents to conduct training, monitoring mediator activities, and enforcing code of conduct. A provision of fund has been made for operation and business of the Council. Community-based mediation. The Act recognizes and promotes community-based mediation along local communities to prepare panel of respective individuals to act as mediators. The Act also provides especially provision for whereby local level has been enriched with operating mediation process at the local level. The provision of the Act ought to be read with provisions regarding local level operation. Act as the said Act provides for specific provision regarding how local levels can apply mediation in resolving disputes locally. Legal recognition. Or agreement reached through mediation are legally binding and can be enforced as per the provision outlined in the Act. The parties may take legal recourse in case where the opposing party refrains from executing the agreement. 7. Special reference to mediation process in dispute with international element. The Act provides for specific provisions whereby measures regulating the appointment of mediators in dispute with international element has been made. United Nations Convention on International Settlement Agreements resulting from mediation, Singapore Convention on Mediation, and Nepal. Nepal is neither a party nor a signatory to the convention. Necessary steps are being taken by the government of Nepal to assess if Nepal should be essayed to the convention. The preparation regarding the foreign going is being done by the Ministry of Law, Justice and Parliament. In 2024, Nepal hosted a significant conference focusing on arbitration related to industrial, commercial contracts, and civil disputes. Our Prime Minister inaugurated this conference. Honorable Prime Minister highlighted the ADR. Thus, Ministry of Law, Justice, and Parliamentary Affairs is studying on the subject. If Nepal becomes party of Singapore Convention, what are the take advantage and implication, impact, and liability? In this concept, we're deeply studying of that subject. Thank you very much.
Thank you very much, Mr. Khatri, for sharing your experience. Thank you, everyone. You all share where your countries are in terms of supporting mediation, signing and ratifying the Singapore Convention. So now I would like to turn to our audience to see if there are any questions. I can see there is one question over there. Yes, please introduce yourself and also please share with us who you would like to ask the question. Thank you.
Thank you very much. My name is Guru. I'm Director for Legal and Economic Treaty Negotiations Affairs of Ministry of Foreign Affairs. Very interesting presentation from all panelists, but I have a question on, for example, it seems that from the presentation, there are two distinctions, whether the mediations become mandatory and whether the mediation is become optional. Just would like to know more, for example, India is actually more institutionalized mediation, and it seems it's more compulsory, while others, like maybe the last speakers from Nepal, it seems optional. For India, maybe the question is, what would be the challenges that you face when enacting the compulsory sense or mandatory sense of the mediation? And for the Nepal or maybe other countries that has more optional, what strategies any of you can share in encouraging business and investors to opt in or genuinely use for mediations instead of resorting directly into arbitration? Thank you.
Thank you very much. Mr. Arora, would you like to respond? Thank you.
Thank you, sir. Thank you, ma'am. Look, basically, it is the autonomy of the parties. The mediation, this is, what you can't inject in somebody's mind or somebody's, body. It has to come, you have to be convinced from your own self or by the mediators, by their efforts. So ultimately, whether it is mandatory, ultimately you can't compel the parties to arrive at a particular settlement by adjudication or just, on the keeping a stick on his head or, what you call a gun on his head, that you please arrive at this particular settlement. So basically it is an inner instincts. But first of all, we have to make ourselves understand. Only then we'll be able to convince others that why mediation. I already explained that in our methodology way back thousands of years ago. Now we realize that a big battle of Mahabharata could have been avoided. Just because Lord Krishna asked 5 villages, but the inner instinct was not there with the Kaurava. So same is the case with the parties. So by imparting trainings, like you may be having, we are the stakeholders. We are one of the stakeholders. There are other stakeholders involved in this process, like lawyers, like judiciary, like mediators, like arbitrators. So all these stakeholders have to understand that it is the instinct which have to be created. It is the confidence which has to be built up between the parties. This would result to, a win-win game for both of you, whether it is this side or the other side. So ultimately, you say that it is mandatory, although we have a mandatory provisions under the law. I told that under Section 12A of the Commercial Courts Act, the mediation is compulsory. But the question is whether that provision is yielding any fruitful results. That is the main thing to know. So of course, in certain parts we are getting success, but on certain fronts we have yet to work hard. So we all have to work hard, whether it is the investor. Yes, to build confidence in the investors, I already explained that we are having now, we'll be having commercial divisions in the high courts to deal with commercial courts to expeditiously dispose of the commercial matters. Now we'll be having the special arbitral courts exclusively dedicated to adjudicate upon the arbitral matters in each state. So the object is that so far as now our country is concerned, we want to build up confidence among the investors. Please do come. Whatever possible steps we can take for the expeditious disposal of the commercial matters, of the commercial disputes, or wherever it is possible, we'll put all of us through ADR, through setup of the mediation process, arbitration process, so that they get the relief, they get the their whatever remedy at the earliest. So that is what I have to say. Thank you.
Mr. Khatri, would you like to share? Nepal seems to be more prudent in implementing the legislative framework to support mediation, although it's still an option for resolving dispute. Would you like to share your perspective on this specific point?
Thank you very much. Little bit more difficult to settle the mediation. I'm telling one subject, which is locally, it's very difficult. Our local service act we have that manage the one judicial committee. There is the three persons involved there. One is the political elected persons, but there is some small cases comes there to settle this difficulty, because in developing countries, they are political biasness. People goes there to settle these disputes, but who is he? First of all, the judicial committee is political. So who is he? In this context, it's a little bit difficult to well justice. It's my experience on that. Thank you very much.
Thank you, Mr. Khatri. Any other questions from the audience? Yes, I saw a hand raised. Over to you.
Thank you, moderator. My question goes to Ms. China from Korea. What was the mediation situation like in Korea before joining the convention, Singapore Convention, in terms of human resource, mediation institution, and legislation? Thank you.
Thank you. Well, before joining the question is about the mediation situation in Korea before joining the Singapore Convention. Well, the landscape of the mediation industry in Korea hasn't changed much since then, in the context that the court annexed mediation plays the biggest role in the mediation industry in Korea. So the court-centered mediation, the mediation center, especially by the Seoul Central Court, the mediation industry heavily relies on that administration in mediation department. And as for the personnel, the KCAB, and there are many agencies, administrations that educate and qualify mediators in Korea, such as the most well-known KCAB, and of course the KIMC, founded by our keynote speaker, Professor Nohyoung Park, today. And and the Ministry of Justice has also had a multifaceted efforts to promote the profession of the mediators in that matter. But I guess that's more of a recent upturns of the events, and we're still trying to promote mediation as a industry and the profession as well in Korea in general. Yeah.
Thank you very much for sharing this. Before we close this session, I just wanted to ask a follow-up question to Miyazaki-san. As Japan is quite advanced on the promotion of mediation, I wanted to ask you what kind of challenges did Japan face to eventually implement the Singapore Convention? Could you share more details with us?
Of course, thank you very much for your question. It's a very good question. And one of the challenges we have faced is that this mechanism introducing enforceability to international mediation was a novel mechanism for us. And so during the legislative consideration of the domestic law to implement the Singapore Convention, we had to consider how we can strike a balance between this legally binding nature and the ensuring due process and party autonomy. It was considered that it would be appropriate to give the parties the opportunities to contemplate whether or not to subject their settlement agreement to the convention. For this reason, we declared the reservation in accordance with Article A1B of the Singapore Convention, and the Implementation Act provides that the act shall apply only when parties have agreed that it can be enforced through civil enforcement procedures based on their settlement agreement. So the reservation allows a certain degree of flexibility to the parties resolving their cases through mediation, and this has functioned as one of the determining factors enabling Japan to accede to the Singapore Convention on Mediation at the earlier stage.
Thank you very much for sharing this. So I think it's now time to close this session. So I want to sincerely thank all the panelists. Thank you for your time. Thank you for sharing your experience and the situation of your countries, which are different stage to promote mediation. I'm sure the audience appreciated it. So thank you. And thank you also for the questions. So this is the end of session 5. And I think it's time for us to break for lunch, but I will hand over the floor to the MC. Thank you.
Let's start the session 6. The mediation ecosystems and disputes particularly suitable for international mediation with Ms. Christina Park and with distinguished panelists who are all leading figures in ADR field. I'd like to invite Ms. Christina Park as a moderator, who is Principal Counsel and Team Leader, Law and Policy Reform in ADB, and who made a great contribution to this conference. The floor is yours.
Thank you, Njay. Good afternoon. Welcome back, colleagues. So, we've heard throughout this policy dialogue that mediation operates as an ecosystem. And, it's clear from this room that there are many stakeholders, many different actors that make up the ecosystem. Also, this panel is also representative of the mediation ecosystem. In addition to delving deeper into the different facets of the mediation ecosystem, we will also explore the types of disputes that the ecosystem supports and whether the ecosystem should be, adapted or enhanced to prepare for new types of disputes, such as environment and climate disputes. So we have 6 excellent speakers, 4 of them who are here on stage. And then we have 2 speakers that have linked in virtually. We have Rima Chatterjee, who you have heard before online. And then we have Sally, who is kindly linked in from California late night. So we really appreciate it, Sally. So we will have 2 rounds of discussions. with 5 minutes per speaker, except 2 speakers will be given additional time because of the depth of their experience, as well as other things that they'll share. So if you could allow more time for them. So we will kick off with our first speaker. I'd like to introduce Mr. George Lim. He's the chairman of the Singapore International Mediation Center. George has, extensive experience in the dispute realm, including mediation, having mediated over 850 disputes. So he's got a wealth of experience to share. He was instrumental in contributing to the Singapore Convention, as well as the further development of mediation regionally and globally. So I'd like to invite George to really share his perspectives on the mediation ecosystem, starting with the Singapore experience, and really, what is the drivers, the impetus, and the actors, the champions that really help create this incredible ecosystem in Singapore. George.
Hello, everyone. Hello, everyone. This is the graveyard shift. And thank you for coming back. I hope you won't regret this, though. Okay. All right. So I've been asked to share about the Singapore experience. I feel very old because I've been mediating for 28 years now. I'm a grandfather. I have 3 grandchildren. I can tell you that. My granddaughter can say mediation. She said it at 2 years old. But let me share with you a bit about the Singapore experience. And after that, my last 2 minutes, I will try and touch on my thoughts on the mediation and dispute resolution ecosystem. Okay. All right. Rewind. Mediation was formally introduced in Singapore in the 1990s, mid-1990s, and it was through the courts. The courts had a backlog of cases and they wanted to clear it. And so they started introducing in the courts. In 1996, there was a call to set up the Singapore Mediation Center. I was then the vice president of the bar. And in Singapore, we say, when you're delegated something, we say you're arrowed. Do you all use that term? Okay. I was asked to sit on the pro tem committee. Didn't know anything about mediation. I went to do my training in London myself. And then, actually Edinburgh, Robin. And then I went on to Harvard, trained under Frank Sander, Professor Frank Sander. So I caught the mediation bug, came back, we set up the center. It was not easy, all right, because it was new to us. Even lawyers, all of us we had our doubts, our reservations. But the courts played an instrumental role. So my Chief Justice then, to kick it off, he wrote to all the senior partners of law firms, the big law firms, and he said, I'm inviting you to attend a mediation course. And if your Chief Justice asks you to attend a course, you attend, right? So that was the first batch of mediators. He said, this is a grandfathering scheme. You come in, train you guys. And we started mediating. One of the things I will tell you, and some of you, it will be familiar to you, where the courts support mediation, it's half the battle won. Because the courts, the lawyers can be the gatekeepers, but the courts have the cases. Okay. And 2 practice directions which the courts introduced, I think were instrumental in pushing mediation off in Singapore. One practice direction was lawyers had a duty to explain mediation to their clients. So it became a duty, and that changed the narrative. Okay. The other change, which is a bit heavier, was cost sanctions. So in other words, if you win your case, but you didn't mediate and no good reason, you might not get your costs, even if you win the case. So these 2 factors, I think, changed the scene a bit. And lawyers who were skeptical came on board. To be fair to our Singapore lawyers, I think today they all accept that it's now part of the process. When ADR was introduced, you know what ADR stood for? Anyone? Not you. Anybody? What did ADR stand for? Miyazaki-san. Alternative dispute? No. Alarming drop in revenue. But that has been proven wrong in Singapore. When I was president of the bar in 1998, we had 3,500 lawyers. mediation came in. Today, we've got 6,000 lawyers. Okay, and today, almost every case in court goes through mediation. It's not mandatory, but it's strongly encouraged. So it's become part of the process, like in Australia, right? You know it's part of the process, and the lawyers accept this now. When lawyers, before they get called to the bar in Singapore, you have to do a module on mediation. That's to prepare you. My son is a young lawyer, and I tell him, he tells me what's the future, and I say, be a dispute resolution specialist. Don't be just a litigator, arbitrator, or mediator. Know all the skills so that you can serve your clients. So that has been part of the Singapore experience. Fast forward 2013, I was asked by the Chief Justice and our Ministry of Law to set up a working group to look into turning Singapore into an international commercial mediation center. Nadia Alexander was part of my working group. Edwin Glasgow Casey chaired it, co-chaired it with me. We came up with a report 2014. We set up the Singapore International Mediation Center. So SMC, the original SMC, focuses on domestic cases, and we focus on cross-border disputes. Wee Ming has shown you the statistics. It's not been easy to get cross-border disputes, but we are doing, I think, credibly. Okay, we've got 80 to 100 cases a year now, and many of the cases are huge cases. Okay, I just got back from Dubai. I did a case between a Russian party and an Asian party. 2 days. I co-mediated with the English KC. 2 days plus 1 month. They signed it. They signed the settlement agreement a week or two ago. Okay, I'm now doing the largest case that we've got, 8 billion US. We are doing a lot of energy cases, state-related cases, claims against states, crypto cases. So we've seen the road, and there's a lot more to do, but I think we all now understand how important mediation has been, and it's now part of the dispute resolution scene in Singapore. How many more minutes do I have? 1, okay. Just some thoughts on the ecosystem. 1, throughout the years, I think we now appreciate courts do their best, Robin's a judge, but courts cannot take the load. There are just too many disputes. Second, arbitration, Wee Ming has shown you the statistics. It's important, but it's become expensive and long drawn in many cases. Okay. The third thing I think, which is very important, governments today are talking about mediation. 10 years ago, no. But I was involved in the drafting of the text of the Singapore Convention, 4 years with Natalie Morris Sharma at the UN. 4 years of negotiations, we came up with that text. Governments started talking about mediation. Frauke, investor-state dispute reform, Answer Tower Working Group 3. 120 countries were represented. We are talking about mediation. That's how they came up with a model clause. Today, for me, this is so important to see all of you here. There's hope, because all of you are much younger than me, I think. There is hope for the future because governments are now interested, and you know that it is good for you all. Okay, 1 last minute, Ken. Can I have the slide, please? I just show you one last thing. The first slide. Okay. In 2023, can we have the slide, please? Yep. We did something different. We've forgotten the users, the people, the companies who are meant to benefit this. All right. So in 2023, Christina, sorry, Singapore, we had a session. We invited some associations and 42 global companies to sign a declaration that they would support mediation. And if you look at this list closely, you will see big companies, all right? I see number 6, Aditya Birla, big group in India. You see Huawei, number 16. You see IBM, number 17. You see 25, Mahindra Group, Meta, Microsoft, Samsung, Siemens, Sojitz, Tata Sons. These are huge companies, and they signed a declaration, okay? Can we show them the picture of the group? The one before. The slide before this. Yeah, saw that? Okay, so remember in your journey, don't forget the users. They are part of that conversation. Okay, thank you. I've taken more of my time.
Many thanks, George. I think it's really, thanks for that, walking us through the journey of the development of mediation generally, but I think each country, it's really important to share the journey of their own journey, their unique journey in developing the mediation ecosystem. So now we will, many thanks, George, we will move to Sally. So Sally is based in California. She's done, even though she's based in California, she's done many Asia-related complex commercial litigation during her career. So she's seen a full spectrum of different types of disputes. So I thought it might be helpful to get from Sally the different types of disputes that she's seeing that's using mediation, and also give us further insight into what are the types of disputes that could benefit from mediation. So Sally?
Thank you very much for the privilege of joining this panel with esteemed
Sally,
professional
you're on
colleagues. Oh, excuse me. You know, my audio shows that I am, is there a problem?
Now we can hear you. Thanks,
Okay.
Sally.
All right, perhaps a systemic problem. I wanted to extend, first of all, warm greetings from the other side of the Pacific. I lived in Asia for 36 years, and so Asia is also my home. We've heard from previous speakers that mediation is a versatile conflict resolution method that can be adopted for a broad scope of matters. Look at the examples which George just provided from Singapore. Just as one example. There is universality in mediation's effectiveness in different cultures and in different legal systems, and this is why mediation is appropriate for cross-border conflict resolution, in my opinion. Civil and commercial disputes are generally suitable for mediation. I will say from my experience as an arbitrator for cross-border commercial arbitration matters, over the past 3 decades, I've seen numerous arbitration cases which would have been appropriate for mediation, where the parties could have enjoyed greater control over the dispute resolution process, probably with lower procedural costs and perhaps less time, if they had adopted mediation rather than arbitration. And based on this observation from my practical experience, I would like to say this. In order to strengthen the mediation ecosystem, we must understand why parties agree to adopt one dispute method over another. We must also understand how do parties reach agreement regarding the dispute resolution method that they will use. I was interested to hear Dr. Alexander's presentation yesterday on the CEDRA survey results, which showed nearly 3 times as many respondents chose commercial arbitration rather than mediation. For commercial disputes, there's no question that the success of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards was essential to the growth of international commercial arbitration over recent decades. I am optimistic that the Singapore Convention has the potential to strengthen the future perception of parties and their lawyers regarding international commercial mediation and whether it can be an effective means of dispute resolution. As we continue to look at ways to strengthen the ecosystem for mediation, I'd also like to focus on education. Is my time up? I don't know if I have more time.
Yes, please, Sally, you could finish your thought.
Okay,
there.
thank you. I wanted to note that yesterday, the distinguished speaker from China, Lu Fei of CTAC, mentioned that over 70% of Chinese companies include dispute resolution clauses in their contracts. The path towards wider adoption of mediation for cross-border commercial matters begins with how the parties structure their dispute resolution procedures contractually and in practice. I think this is an area that requires examination if we are to strengthen the use of mediation for commercial disputes. There are many other areas. I think my time is up. But there are many other areas that are interesting for the use of mediation, and perhaps as time permits, we might get into that later.
Many thanks, Sally. You were allowed a minute because of the kindness of Mr. Yun-Jae Beck, our next speaker. He's the chair of the International Dispute Resolution Team. He's basically gave me a heads up that he's only going to be 4 minutes. So basically, I'd like to invite, if I may, YJ to talk about the important role of mediators and lawyers and what can be done to increase standards and the professionalism in the mediation field, and where developing countries can look to in developing their standards.
Thank you, Christina. I think we have to mediate first because I told you that I'm going to use only 4 minutes, but you have raised so many questions. So
Could be an impossibility.
Yeah.
Apologies.
You know, I'm a practicing lawyer doing arbitration and mediation as well. So this morning, Yoshi mentioned the double hatting, but actually I'm using 3 hats. So practicing lawyers, arbitrators, and mediators. There are many types of mediations, for example, facilitative mediation and also evaluative mediation cases. So let me talk about typical mediation. In typical mediation, the mediator is a kind of very neutral third party who facilitate the communications and dialogues between the disputing parties. So his role is just to assist the parties to open their dialogues and to find out mutually acceptable solutions to resolve their disputes. So mediator is not giving legal advice, or he does not give any decision at all. But in contrast, lawyers, their first job is not to defend their clients during the mediation case. Their first job is to bring their clients to the mediation table. Frankly speaking, when I'm working with the Korean clients, it's very tough to bring them to mediation phase. When I mentioned mediation, then they are a little bit skeptical because by attending mediation, that means he acknowledges his weakness of his position. So I try to persuade my client to take part in mediation cases. So that is lawyer's job, dealing with mediation. But when the outcome of mediation is not successful, then the client always came to me and they blame me. Hey, YJ, because of you, I wasted my time and cost. So as a lawyer doing mediation cases, must bear that in his mind. And your second question is how we can. I'm sorry, I'm getting old. So
No problem. Because we talked a lot about standards and, where can countries look for in terms of, standards for mediators?
So there are so many mediation institutions, but actually mediation institutions does not provide any standards or ethics or the the conflicts of interest. But if you get some institutions like IMI, which is the International Mediation Institute, or IBA, or the ABA, they have some mediation-related code of ethics or conflict of interest. So the developing countries, they may rely on those institutions, and I think they can find a good text to adopt. And the third question is how the developing countries can provide. Mediation is kind of, let me first start with the Korean situation first. In the morning session, we heard from the lady lawyer from Ministry of Justice. But frankly speaking, Korea is very good at mediation environment. So we have court-annexed mediation, and those mediations are handled by judge itself, or sometimes the third party who was designated by court. And also the KIMC or KCAB, they are designated by Korean court to handle mediation cases. That's domestic cases. Also, we have administrative mediation, such as the contents-related dispute, medical malpractice disputes. So there are many areas of mediation in Korea. Because of those background and underground work, Korean people are very familiar with mediation, but nonetheless, they are still very reluctant to take international commercial mediation. So the developing country, the mediation institutions and developed countries, they have to provide this kind of framework to the developing countries. Otherwise, even if we talk about international commercial mediation, it's meaningless. So build up their underground work for mediation first, and then look for international commercial mediation. That is my desire and proposal. Thank you.
Many thanks, YJ. But standards are definitely important, and developing the professional of mediation is critical in building the mediation ecosystem. So now it's my distinct honor to introduce the Honorable Mr. Justice Robin Knowles from the UK court, but he's here in his capacity as the judge with the day-to-day responsibility of the Standing International Forum of Commercial Courts. It's a forum for commercial courts around the globe. And we've heard many, speakers, many discussions really focused on, and including George, on the critical role of courts and judiciary in building the mediation ecosystem. So I'd like to hand the floor to you, Justice Robin.
Christina, thank you very much. And thanks to ADB, ADBI, UNCTRAL, and the Ministry of Justice for these last 2 days. I thank everyone here for the warmth of engagement. I think we're going to remember this event, including who we have met. The focus, of course, has been on arbitration and mediation. I am in wholehearted support. But I know we all agree that those two components are components of an ecosystem, and the courts are an essential third component. Some countries have found that the courts were not working or working well enough, with backlogs and delays, lack of expertise, and the like. And that is what turned them towards arbitration and mediation. Today, if we look around the world, we are also experiencing some instances of arbitration not working or working as well as it could. And that also causes us to look to mediation. But it's crucial to keep in mind that arbitration and mediation will ultimately fail without courts. They both need courts. So if your courts were not working well, and that's why you turned to arbitration and mediation, now's the time to work just as hard on getting the courts to work well. To achieve courts with expertise, both in subject area and in arbitration law and mediation. It's the whole ecosystem that is crucial to the investor, to business, and to public confidence. My focus will be on commercial disputes and international disputes, but the principles apply more generally. Just a few words about myself so that you can assess the messages that I would like to convey. I offer these few words with deference because I've learned a very great deal from others over these last 2 days. I do nonetheless want to be transparent. I was a barrister in practice, then a QC, an accredited mediator and an arbitrator, the chair of the Commercial Bar Association of England and Wales, and I led work in England and Wales on access to justice. Now I'm a High Court judge of the Commercial Court in London. In that court, 70% of disputes involve foreign parties from all parts of the world. Disputes are decided under English law or under any other law. 25% of my caseload is arbitration law, where England is the seat.
I also, as Christina has kindly mentioned, have the privilege of day-to-day responsibility for the Global Forum of the World's Commercial and Appellate Courts, which goes by the short term CIFOC. Let me tell you about CIFOC, and I do so because it is there to help all of us, and it is what we will all make of it. So far, the judiciaries of 58 countries are now members of CIFOC. That number will shortly exceed 60. 70% of the G20 nations are within that number, but so too are many developing or emerging market jurisdictions, common law and civil law alike. Within those in this room, the membership includes the judiciaries of Australia, China, India, Indonesia, Japan, Kazakhstan, the Philippines, PNG, South Korea, Malaysia, Singapore, the USA, and the UK, and now Cambodia. But others in this room, in this really important room and assembly, are welcome. CIFOC's Secretariat is based in London, but it's guided by a steering group which is truly international and includes the Chief Justices or former Chief Justices from Australia, Hong Kong, New York, Qatar, Singapore, and Uganda, together with senior judges from England, France, and Malaysia. The purposes are to share best practice and assist those who are developing their commercial dispute resolution capability. Together, the aim is to promote stability, trust, predictability, as the Japan Assistant Vice Minister of Justice correctly identified as vital components in his remarks yesterday. CIFOC has agreed and published international principles on case management. 2 of those 18 principles directly address mediation and arbitration. It's also published a multilateral judicial memorandum on enforcement of the judgments of one country by others worldwide. It convenes international roundtable discussion on key issues, litigation related to climate change and AI, the relationship between courts and mediation and arbitration. The high point every 18 months is to sit, similarly to this room, 50 delegations from 50 jurisdictions for a continuing discussion of these issues. Many delegations led at Chief Justice level, a different host country for each such meeting. Intensive peer-to-peer judicial study and internships are also offered. And very importantly, the presence of CIFOC allows another channel through which the world's courts this time can work in partnership with other global institutions, including ADB, the World Bank, the Hague Conference, and others. Now let me turn to the part that courts play in the ecosystem. I briefly reference 6 parts. Number 1, tackling disputes where the parties have not agreed to a mediated outcome or to arbitration. Not all commercial cases are contract cases. Not all parties are parties to a case that may have a contract in it. Multi-party cases are being seen more and more in the commercial sphere, and it's difficult to achieve a mediation, especially if we're in the world of opt-out multi-party cases. Secondly, courts are critical to get parties to the point where mediation can succeed. If courts take on the job of making sure there is a continuing dialogue as to when and whether mediation has a chance, they play a second important part. The Joint Secretary of India, I thought, underlined that point exceptionally well today. The third part of the court's role, ensuring that there is an alternative of litigation, yes, if the parties cannot resolve by negotiation or mediation. They've tried mediation and it hasn't worked. The fourth part is, of course, the court's role. I double underline this in enforcing mediation outcomes and arbitration awards, including processes like compelling information that will be vital to the success of enforcement efforts. The New York Convention and the Singapore Mediation Convention, of course, provide for enforcement, but it is the courts that will deliver that. This is another example of Thomas Clark's point, that passing laws is necessary, but not sufficient. That's the fourth part that the courts play. The fifth part, of course, is their supervisory role in arbitration and indeed in mediation. I had the privilege, some in this room know, of dealing with the challenge brought by Nigeria to an arbitration award in the very high amount of 10 billion. And that exercise brought home where the courts are vital and where without the courts, the result would be hard to contemplate. Whole economies can be affected. The last of the 6 points I wish to raise in terms of the role of the court is this. The court is there for those cases where we need to develop our understanding of law, especially in new areas, and especially where the result from a court, perhaps on appeal, will give an answer that is of wider application across a market. Litigation should not always be the last resort. Sometimes business will say they need the court's answer as the first thing because it will make business work. And if we look ahead to some of the questions that are coming into the system, board directors' duties in the context of climate change. Can boards leave decisions to AI? What happens to long-term contracts where it's now realized performance will contribute unacceptably to climate change? What happens to legal rights and obligations if the world does not succeed in tackling climate change? Some of those disputes will need the direct attention from the courts, and that too will assist arbitration and mediation. Those are the 6 points. There'll be others which show that the courts are a third component of the ecosystem. Thank you.
Many thanks for your intervention, Justice Knowles, and many thanks for you to being here, as well as the other judges from PNG and Indonesia. And I think you've already sort of opened the discussions to invite our next speaker, Rima, to talk about really what are the emerging needs to support this mediation ecosystem. So Rima, may I invite you?
Yes, yes, for sure. I'm waiting. So good afternoon, everyone. I would just like to start because we are short of time. So I would like to talk about 3 important trends, which is, very important if you want to strengthen the mediation ecosystem. The 3 topics I want to just quickly touch upon is the role of AI, third-party funding, and apology legislation in mediation. First of all, with regard to the role of AI, we all know that it has gained immense popularity. For example, the eBay, we all know it is using this automated resolution system, and the disputants are not even stepping to the courts. Further, the UNCITRAL has also recognized the potential of these tools many times. So no doubt we say that there are benefits of its usage that such as the lower cost and time saving and the predictive analysis which can help the disputants to understand the strength and weaknesses of their cases. But AI is also able to process colossal amount of data and documentation provided that data privacy is ensured and granted. So I just want to say that because that can be a big lacuna. But and then also I want to say that, but a well-trained mediator, he uses empathy, active listening skills, rapport building to unearth deeper interest of the parties, the qualities that algorithms alone cannot replicate. So some AI algorithms, they operate, I would say, rather as black boxes, making it difficult to understand how they are able to arrive at these conclusions, which this lacks, I would say, transparency and can erode the trust in the process. Coming to India, I would like to say that as our Mediation Act already demonstrate the government intent to modernize the dispute resolution, the pilot programs, they are already there in certain high courts, which has introduced AODR platforms to reduce backlogs in commercial disputes. Yet, but we Indian mediators often rely, especially if there are personal disputes, on personal communication and cultural sensitivity. Our Honorable Supreme Court of India is actively also implementing AI-generated tools like SUAS to improve access to justice by translating, legal documents into regional languages. So in the end, we can say though AI can be a facilitative tool to mediator and arbitrator, but a replacement for them is not possible. As human ability not only to perceive multiple dimensions to a problem is there, some of which I would say cannot be evaluated by AI. Coming to the second important social development which is coming up, I would say, is the third party funding. We all know that there's an external financier who is going to finance the disputants who are not able to afford the the process of mediation or arbitration. But in the, they also look forward to get some kind of cut or commission or a share, I would say, from the settlement agreement. So the critics, I would say, they worry about the funders pressurizing the parties to, settle for something which is, less favorable to them. And secondly, the confidentiality can also be a tricky if, the parties are not even to disclose some confidential information about their businesses or commercial things to that particular funder. But in India, definitely there is no explicit prohibition about third-party funding, but we are still awaiting a legislation on this. However, for example, in certain commercial cases recently in Mumbai, external financiers, they have stepped into the mediation process, giving undercapitalized claimants the chance to pursue fair settlements. I think we have time. I just want to touch the third last important topic or important trend for mediation is the apology legislation, the role of apology. We all know that apology in mediation, it plays a very, very crucial role in facilitating not only communication, de-escalating disputes, the tension, acknowledge the harm done, provides an opportunity to express remorse. But apology legislation, we all know, it aims to protect the statements of regret so that they cannot be used as admission of liability. By removing the fear of such admissions, apology laws encourage parties to express genuine remorse, often diffusing tension and fostering mutual understanding. Well, in Hong Kong and British Columbia, apology laws protect remorse from being used as liability, encouraging open dialogue. The US and Scotland follow similar paths with varying degrees of legal protection. In India, I would like to say, though there is currently no specific legislation on apologies as per se, but nevertheless, it plays an enormous role in Indian culture, particularly in family and community disputes, where apology can be more powerful than any financial remedy. Mediators in India actually are very careful to ensure that apologies are not documented in the settlement agreement. We are only talking about apology verbally. Why? One, it is a standard practice to maintain confidentiality, and secondly, this is a precaution to help prevent future disputes if we take apology in writing and if there is no legislation to protect the person who is apologizing. So this precaution helps to prevent settlement from being used as a ground for future litigation. In the end, I would like to say that AI-driven mediation, third-party funding, the apology legislation, they are reshaping dispute resolution, making it more efficient and accessible. I think I'm within my time.
Many thanks, Rima. That was very interesting. The three trends that you shared. We'd love to be in touch to get more information on that. Next, we'll move to Ms. Annette Magnuson. She's the co-founder of Climate Change Council, and she works at the intersection of investment policy and climate change. And she also has deep dispute resolution experience, being the former Secretary General at the Stockholm Arbitration Center. And Justice Knowles basically mentioned the issue of climate change. Mediation, there's been a lot of emphasis on the suitability of mediation for commercial disputes. But now there's emerging view of the suitability, of could mediation be used to facilitate good outcomes for climate and environmental disputes? Annette?
Thank you, Christina. So as you will hear, when we talk about the ecosystem of mediation, it's a very wide range of topics. And I will add to the sort of the breadth of the topic. And as Christina pointed out, at Climate Change Council, we work in the intersection between the climate transition and law. And really with the objective of making law work more efficiently in the climate transition, but also to have lawyers to work leaning in more efficiently where it's possible in the climate transition. And talking about mediation in that particular context is very, very suitable. So, and I'll explain why. Because I think that climate change and mediation go very, very well hand in hand. And I think mediation has an extremely important role to play in the climate transition that we are currently experiencing at different levels in different societies. But when we talk about climate change disputes, of course, that could mean a wide variety of things. So just to narrow it down a little bit, climate change disputes, of course, to a large extent includes litigation. And we are familiar with the cases where you would have NGOs filing strategic cases against governments, or you will have NGOs filing strategic cases against multinationals, all with the ambition to maybe stop harmful behavior or prompting the government to start doing mitigation and adaptation measures in their respective jurisdictions. So these are sort of one category of cases when we talk about climate change disputes. But where I think mediation can play a very important role is in all of the commercial cases that we see coming as a result of the climate transition. And these are commercial cases, purely commercial cases, business to business, but also cases that are investor-state disputes that have a climate change element to them. When we're looking at the climate transition, societies needs to have a massive transformation on many levels. We're talking about large infrastructure investments. We're talking about energy transition, but also will require large investments, change in entire energy systems, investments for new types of energy. We're talking about adaptation of societies that need to adapt to the changes that we are already seeing because of climate change. Different ways of land use, rising sea levels, extreme weather events we need to protect and also pick up the pieces after we have experienced the extreme weather events. All of this, again, will require large investments and the contribution by private players. And to add to these massive challenges in society, all of these sort of adaptation and mitigation efforts have to happen in a very fast pace. A few years ago, the International Energy Agency published a report on the energy transition, and basically for the global community to reach net zero by 2050, which is the target we need to reach to be able to meet the Paris Agreement target of 1.5 degrees. Massive investments needs to be made or needed to be made already 4 years ago when this report was first published. But what was most interesting in this report from the International Energy Agency was that they were looking at the new technologies needed for this energy transformation to reach net zero by 2050. And the International Energy Agency noted that most of the technologies needed for this transformation were at that time, when we're talking 3 years ago, were still in their prototype or development phase. So here you have a lot of new technology by a lot of new actors deployed at large scale under very high time constraints. So anyone that has been involved in international disputes will know that the list that I just gave you will be a list for disputes, right? New technology, new actors at a high speed. And you could add that change in regulations to that. So we will see a lot of disputes as a result of the climate transition, and we are already seeing it. Now, to resolve these disputes, we cannot use the practice of yesterday or that we are business as usual. It is not business as usual. We need to resolve these disputes faster. And this is why mediation is so valuable in these cases relating to the climate transition. For this one element of mediation which makes it so attractive in the climate transition, and that is the speed. We simply do not have time to wait for full-fledged arbitration or litigation to take place if we are going to aim for reducing the emissions by 50% by 2030 or reaching net zero by 2050. Look at these large energy investments. Look at these large infrastructure investments. Where the disputes arise, get the mediators in, resolve the disputes, and get going with this transition. So this is why I think anyone that sits in commercial cases that has any alignment with the climate transition, they should always include mediation in their strategy for the case in their conversations with their client.
Many thanks, Annette, for highlighting that mediation could be, could help tackle climate change. So next we're moving to our second round of questions, and we'll now circle back to George. So SIMC has been a leader in fostering cross-institutional collaboration with other institutions in Singapore and with international institutions from other countries. So what role can more established institutions such as SIMC play in supporting the development of mediation institutions in developing countries?
Thank you. Can I have my slides, please? Yeah. So the second round. This morning, I think we heard the word collaboration quite a bit. And in mediation, we actually preach and practice collaboration. So one of the things we've done at SIMC is to work with other institutions. And for us, it's important because you want to demonstrate that you're not just competing, but you're working together and you're being creative about things. Okay, so one good example is this protocol that we have with the Japanese International Mediation Center. Yoshi Takatori here, Takatori-san, that's him, with a mask. So we started this protocol during COVID-19. We had a case between a Japanese party and an Indian party. And, it's always difficult to find the perfect mediator, right? And I think for the Japanese party, they were more comfortable with someone who could speak Japanese. And of course, the Indian party, you can't leave that party out. So we found a Singaporean of Indian descent, all right? That was creative. And I think that was Greg Vijendran. And Yoshi-san and Greg worked together. The key is to work together before the mediation, a lot of preparation. And within 2 days, online, they resolved this case. So this is a new way of resolving cases. We can think out of the box. Okay, I'm going to be quick. You've heard about our protocol with the Singapore International Arbitration Center. We are sister companies next door. All right. But this was devised in 2014 before the convention. What it does is, if parties are concerned about enforceability, file your papers with SIAC. Okay, once the initial documents are filed, the arbitration is stayed. You appoint the tribunal by state. The file comes to us, all done, one stop, back room, sorry. Wrong use of the word. And there is an 8-week window where we will mediate the matter. Separate, the mediator is separate from the tribunal because we believe they have different skill sets. If it is settled, goes back to the tribunal, recorded as an arbitral award enforceable around the world under the New York Convention. If it's not settled, you carry on with the arbitration. Businesses love that because they get an outcome. And we say this is arbitration with a mediation flavor, the best of both worlds. Okay, we've done this with the Singapore International Commercial Court, Robin, something you might introduce around your courts. So we call this lit, met, lit. Same process, but it's with the International Commercial Court. Okay, so this is how we work together. This is special. So we have a special arrangement with the Shenzhen Court of International Arbitration. If the case is successfully mediated at the SIMC, the settlement agreement, and if you want to enforce it in China, we have an arrangement with SCIA where that settlement agreement can be converted into an arbitral award, enforceable in China. Okay, so that's a special arrangement. So parties who are concerned about enforceability can do that in Singapore with us. And the last one, you see this picture, this is an example of collaboration. We had signing of MOUs with different institutions from Asia, Turkey, Japan, Indonesia, Vietnam, India. So this is what we will promote, and we tell people we work together. So like with the JIMC, that case we co-administered. Each center counts it as one case. Win-win. Thank you.
Thanks, George. So we'll circle back to the mediation profession with Rima. So now that with the growth of the mediation, there's going to be like need for more mediators, and we were just wondering if you could share with us, how can more mediators be, produced, and how do new mediators obtain like the practical experience?
Well, thank you. I would say it's a lovely question because as a mediator and a trainer, I'm keenly, involved in this area also. And as we all know that, in mediation in India is doing great, as mentioned, I think by George, twice in the morning. I'm very happy to hear that how a dispute between India and Japanese companies, it was resolved. And secondly, how the big companies of India like Aditya Birla and Tata Sons, they are getting involved, and they are also because they are the big people, or where the commercial disputes can generate from. So this is I'm good that India is doing great. Now coming to the the two, I would like to say, so there are two primary things I want to talk about from Indian perspective. One is the Mediation and Conciliation Project Committee. Now, this Mediation and Conciliation Project Committee is established by the Honorable Supreme Court of our country. I think I mentioned it yesterday also. It is basically, as of now, today, is overseeing all the court annexed mediation programs and lays down broader guidelines for mediation training, accreditation, and certification. So MCPC, I would call it in short now, MCPC has introduced a 40 hours module of mediation training, which refers to comprehensive training programs. It covers all theoretical concepts of mediation process, which includes ethics, communication techniques, includes questioning skills, active listening skills, body language, facilitation techniques to be adapted by the mediator. It also trains them about various negotiation and bargaining techniques and how to encounter if there are barriers. Apart from this, in this 40 hours training program, we are also doing various quizzes, videos, which are trained to assist the parties in how to do the conflict analysis, how to do this, Batna, Vatna, and Malatna. We mediators, we know about these terms. So that parties, because it's parties' decision, so that they can take informed choices. So this all is part of the mediation training. A mediator is basically now the trainee, I would say, is medically there's a mental transformation, how to take a person or a party from a position to interest And these are skills are taught in this 40 hours program conducted in mediation in India. Like also important, I want to say is that during this training, we are doing a lot of role plays where the trainees, they employ their skill, which they have learned during the training itself, and they get an hands-on experience as to what will happen when they will actually do it. So this all is the part of curriculum. Then further, after the completion of 40 hours training, the rules requires the training to absorb various skills from a senior mediator. So it is not just by, doing the training, you have become a mediator. So after the completion of 40 hours, the rules of MCPC, it requires the trainee to absorb various skills from a senior mediator. The trainee accompanies the senior mediator and observes minimum 10 mediation settlements happening actually in the mediations, as well as non-settlements, to gain knowledge on the various practical aspects of mediation. Post, they are certified as mediators and conduct mediations on their own. There are also refresher courses happening after this 40 hours training, maybe after 6 months or so. These 40 hours training, they can not only exchange their ideas, they can learn new things like the role of emotional intelligence, how to handle power imbalances, the new judgments which are coming by the different parts of different courts of our country, and they can exchange their ideas during these refresher courses are normally for 2 to 3 days. So there are also observation programs, in which the mediation centers allow them to, see, but we'd also take care of the confidentiality because a part is very important. So we take the permission from the parties if they allow us that the third mediator who is learning process, at times some students also come, we take the permission from the parties, only then they will be able to join and watch the mediation exactly happening. Coming to the second thing, that is the Mediation Act from the Mediation Council of India, which is established under the Mediation Act, about which our Honorable Joint Secretary, Law and Justice, Mr. Ajay Kumar Arora, has already, I think, spoken in the morning session. Well, it is actually going to be responsible for setting down all the rules as well as the procedure in mediation in India. It will oversee the mediator accreditation and training standards and ethical compliances. Further, I would say the Act refers to institutional mediation, commercial mediation, pre-litigation mediation, to conduct mediation, and it also established mediation service providers. So in a way, it is not only institutionalizing mediation, there will be these mediation service providers, which are entities authorized to conduct mediation, support the process, as well as provide the necessary infrastructure. Apart from these two, there are other several institutions. These are the two major ones. They are under the aegis of our government, under the aegis of our court. There are other institutions like IAAM, CADR, Center of Alternative Dispute Resolution, DDRS, Delhi Dispute Resolution, various societies which are conducting a lot of mediation trainings, where not only the trainers from India, but trainers from all over a country, like for example, I would like to say from 3rd to 5th, I am also getting a chance to, attend a training for 3 days on commercial mediator, so that I can learn more skill on commercial mediator, and then I can use it when I'm, provided for. So it's an ongoing process. We keep on doing. So 40 hours training, which is the basic one, which is they are only getting to know what is mediation and how to conduct it. Apart from that, we are conducting a lot of awareness programs so that, we are supporting and strengthening the mediation ecosystem in our country. Thank you so much. I think I've touched all the points now within time limit.
And thanks, Rima. It sounds like a lot to become a mediator, and it's good to hear that India has a very robust training program for mediators. Now we will turn to Justice Knowles. The issue of standards is critical to the further development and uptake of international mediation. And we're curious to know how courts work with mediation organizations to raise standards.
Again, thanks, Christina. 6 suggestions. First, by courts helping enable us all to listen to the users. The courts these days sensibly have court user committees. The courts use their convening power to achieve that, and those committees should always include around the table the arbitration and mediation community. Secondly, for the courts to discuss standards with the professionals. Now, I agree with Dr. Sharma and others that mediators don't need to be lawyers, and therefore the professional group we're talking about are lawyers, non-lawyers, those who provide expert evidence, and even new players like third-party funders. It will be harder to develop standards where we're dealing not just with the lawyer community, and therefore not just with a shared baseline of standards that the legal profession has developed. And thus, it's really central that the courts are involved in the discussion. One needs as much power to the effort as possible in the interests of the rule of law. Thirdly, for the courts to support institutional cooperation. It is organizationally impressive that we have institutions across the fields of arbitration and mediation. Professor Park was right to call for collaboration between institutions because that makes the most of an advantage we're very lucky to have. Encouragement from the court for that collaboration is, in my suggestion, important. The example given by Mr. Chen from the Shanghai Mediation Center of how collaboration works in the context of IP was inspiring. Fourthly, for the courts to play their part in reviewing standards when there are challenges to the court under its supervisory jurisdiction or in the course of a challenge to enforcement of arbitration awards or mediation results. The IBA arbitration conflict guidelines, for example, have come before the Commercial Court in London on several occasions. But there's also the court's power here to expose poor standards where it sees them. That's a good discipline. My fifth and sixth points shortly. The fifth is for the courts to set an example. To set an example of standards when they are engaged with enforcement of arbitration or mediation awards. For the courts to show that they will themselves apply high standards to that part of their work. Expertise, rigor, courage, independence, the rule of law. And then the sixth is about supporting the courts joining in the effort to support the next generation. For the judges to be there when the universities and the law schools undertake educational activities, as Mr. Miyazaki of Japan's Ministry of Justice emphasized was desirable this morning. If I had a footnote before I finish, there's one other thing where the court and we all could help. And that is about standards in the very drafting of contracts, including the dispute resolution clause, but I mean the whole contract. If we carry through our work on standards so that it does include contract drafting, then we will find we're not only helping in the resolution of disputes, but we're helping in the prevention of disputes, an objective that Mr. Shin of SIAC rightly encouraged yesterday. Thank you very much.
Thank you, Justice Knowles. And footnotes are critical to read for everyone. So now we'll move to Sally Sally, the topic of mixed mode dispute resolution processes came up several times during this policy dialogue. In what types of disputes would mixed mode dispute resolution be suitable? And I guess also, what are some words of caution, some issues with these types of mixed mode dispute resolution processes? Thanks.
Thank you. As I realize time is precious, I'll take a galloping approach to your questions. We can see mixed mode with mediation playing a significant role in each of the mixed mode packages, whether it appears in commercial arbitration or in the case of court litigation, the court annexed mediation, which was mentioned earlier in this session. No matter at what point in the sequence of procedures mediation appears, whether it's med-arb or concurrent mediation and arbitration or arb-med or med-arb-med, however it appears, in all cases, parties do tend to turn to mediation in the mixed mode framework with an eye towards expediting settlement and enjoying the other benefits that one can have from mediation, which include saving time and cost and possibly also saving relationships and allowing for a better continuity if there is a long-term relationship to preserve. I would mention that commercial parties can stipulate a mixed mode approach in their contracts, as the Justice has just mentioned. They would be well advised to have professional counsel and advice when they do that. It can be complex to do it right. And in addition to procedures allowed by the courts for annexing mediation, I think it's also very important to mention the procedural rules of arbitration institutions that offer a convenient path to using mediation even after parties initiate an arbitral procedure. CTAC, the Chinese arbitral institution, is a pioneer in allowing the adoption of settlement-oriented procedures, including conciliation and mediation after an arbitration begins. The ICDR, the international arm of the American Arbitration Association, incorporates a vigorous approach towards adopting concurrent mediation with arbitration by presuming that parties will try to mediate even after they initiate the international arbitration, if they so agree. Arbitral institutions in Asia, just to mention a few, HKIC, SIC, and of course JCAA, offer paths in their procedural rules towards allowing a mixed mode approach when parties agree. The UNCITRAL model law is less explicit by comparison, but the principle of party autonomy in relation to arbitral proceedings could potentially allow for something similar. So what are the issues? The parties' inclination to agree or disagree with using mediation is the first issue. We need to understand why parties do or do not choose to mediate. And as one of the prior speakers in our session mentioned, it's not always easy to get parties interested in the mediation mode. In addition, there are cases where parties' respective positions simply are not close enough that it would be difficult to counterbalance in a fair and just way. I was interested to hear about the potential role of third-party funding. There may be other solutions to deal with this, but it is always important that parties be able to function in a mutually respectable, mutually acceptable way so that truly a win-win result might be a realistic goal. And if that's not the case in the relationship between the parties or because of the nature of their dispute, then the appropriateness of using mediation, the appropriateness of a mixed mode approach would have to be considered very carefully. I would mention criminal matters is one area where we don't see mediation very often, although California has successfully used mediation in juvenile criminal cases in some cases, which is an interesting, rather proactive way to adopt arbitration, the mediation, even where there is a criminal element.
Thank you, Sally. So now we'll move to Annette. I'm just wondering, is there one change that may be needed in the mediation field to better support climate change related disputes?
Thank you, Christina. I would say that, to be very brief, when we are talking about climate change disputes, we are, and climate change at the larger scale, we are very much moving into uncharted territory when it comes to substantive rules and how they could apply in this sort of changing world. So maybe not a change, but focus on a continued curiosity and openness for the mediators acting in this space, and to pay attention to what we refer to sometimes as the best available science, and how that is actually shifting, and that has real consequences on the ground, but also how we understand the application of law, for example. So I think just awareness of that climate change brings with it the volatility and very, very fast change. Having that awareness, I think, will be an important element for any mediator in climate change disputes.
Thank you, Annette. And certainly this is an element that we're building into other types of training programs. So the last question, and it goes to YJ. This is a big question. So what are some of the ways that the international mediation community can support the further development? Thank you.
Thank you, Kristen. It's a very big question, but I'm going to answer in a minute, okay? I mean, the reason why we are here is to discuss about the development of international commercial arbitration in each and every jurisdiction. We are not here to discuss about Singapore Convention or some other aspects. So I would like to add just one thing. For 2 days, we heard very good suggestions and proposals, but what I tried to say is that the international institutions and the developing countries, they have to focus to establish and build the very conducive environment locally basis. So those systems must be driven by local person and also culturally suitable and culturally sustainable and acceptable to their legal systems. And also international institutions and the developing countries, they have to support the local jurisdictions to educate and to build their own mediation expert and leaders. By doing so, I think we can sustain the international commercial mediation all around the world. That's what I'm to say.
Thank you, YJ. I think the sustainability element is hugely important, so many thanks for pointing that out. And now we've come to the end of the session, and many thanks to our excellent panel. So we could just give them a round of applause. I'd be grateful. Thank you, Sally. Thank you, Rima. Appreciate it.
Everyone, it's good to see that people have so much to talk about in the breaks that it's difficult to getting people back in the room. So that's a good sign of the event. Just before we sat down, my panel threw our manuscript out the window. So just to let you know, anything could happen here on this panel. But we will have a conversation about mediation in investor-state disputes. And we have a fantastic panel that will help us share this topic and share their experience and their perspectives on the topics, represented by a very sort of complete, almost a range of different perspectives. So first, we have Professor Florian Grissel from Oxford University. He will kick us off with an overview presentation of the topic from his view. you could say the academic view, but I think you will also have some more some practical views in his presentation. Then we have the government perspective from Mr. Sayada Guru Samudera, who is the Director for Legal and Economic Treaties at the Ministry of Foreign Affairs in Indonesia. Second, Miss Frauke Nitschke, who is the team leader and senior legal counsel at the International Center for the Settlement of Investment Disputes, ICSID, in Washington, D.C. She will talk to us about from the institutional perspective. And last, but certainly not least, we have Miss Liz Johnson, who is a partner with Curtis, Mallet, Prevost, Colt, and Mosul law firm in London. And I understand Curtis is primarily representing government, so she will have the private practitioner's perspective from representing government. So these are the 4 different perspectives that we will hear from in the next hour and 15 minutes. And like I said, we will discuss a number of issues throughout the panel, and we hope also to be able to engage you in the audience, both here in the room and online in the conversation. But first, let's hear from Professor Gristle. So Florian, the floor is yours.
Thank you very much for the introduction. Let me share my slides. Here we go. All right, here you should be able to see my slides on the screen in front of you. I'm delighted to be here, at least online, and I do apologize for not being able to attend in Tokyo in person. I have commitments in continental Europe this week. So I've been asked to talk about mediation in disputes involving states and state entities. And I added the title, which is a question rather than an answer, a fantasy of viable option. And I should say from the outset that I will concentrate on investor-state disputes. I will proceed in 3 steps. I will first describe a legal momentum that has been developing over the past decade or so in the field of mediation, before presenting some traditional hurdles that have limited the use of mediation in those type of disputes. And finally, I will draw from the past to imagine what could be the future in that field of mediation. So let me start very briefly by describing this very important legal momentum that has been developing over the past decade or so. I will be very brief because this is something that some of you at least might be aware already. And I will start with the ICC mediation rules in 2014, the ICC being this major arbitral institution. So it is quite noteworthy that such an arbitral institution has been developing mediation rules. It already had in the past conciliation rules, but these mediation rules were really meant to develop what the ICC saw as an area for potential development. And then, of course, there's this major treaty, the Singapore Convention, UN Convention on International Settlement Agreements resulting from mediation, or the Singapore Convention, signed in 2018, which could be the equivalent of the New York Convention of 1958, which has been arguably one of the key elements of legal architecture explaining the success of international arbitration. So now we have some kind of equivalent in the field of mediation, which of course could lead to the development of mediation around the world. It was followed by a model law from UNCITRAL, and then mediation rules from UNCITRAL in 2021. And last but not least, the ICSID mediation rules and regulations adopted in 2022, which are also a major development in providing a solid process for mediation involving states and states entities, especially in the field of investment disputes. So this is a very important legal architecture that is being built, that has been built over the past decade. But of course, so the argument goes at least, there are traditional hurdles that have been limiting the development of mediation. And here I really mean mediation involving state or state entities, particularly in large investment disputes. I mean, there are several arguments that are used to explain these limitations, and I will simply focus here on two arguments. One is that states are complex machineries with authority that is dispersed among multiple departments, which makes it more challenging for them to settle disputes. I mean, the same could be said to a certain extent of multinational companies, but states can be very complex, bureaucratic entities. And of course, the interests of these different bureaucratic entities are not always aligned. So some use this argument to explain why states are less likely than other entities to settle their disputes. Another argument would be that the trend towards transparency could make settlement agreements looking more suspicious, or at least challenging for both investors and states. Agreeing on a settlement agreement, which often is left confidential, could raise suspicions in the eyes of the wider public. So these are traditional hurdles. And of course, when we look at available figures, and of course, these available figures are incomplete because it's very hard to assess the extent to which investors and states are in fact mediating disputes and concluding settlement agreements. But I will rely here on a very good source, and Frauke from ICSID will be able to complement or correct me if these figures are not up to date. But these are the last statistics of ICSID of 2024. And we see an overview of all ICSID cases registered by applicable rules. And here I will focus on ICSID convention conciliation cases, which is virtually the same as mediation with a few nuances, and ICSID additional facility conciliation cases. So in green, we see 12 cases, and in gray, we see 2 cases, so a total of 14 cases that have been submitted to conciliation over the past few decades of existence of ICSID. We do not see mediation cases yet, but the mediation rules having been adopted only a few years ago, I think we ought to give these rules some time to gain traction. But we still see that these conciliation cases are a negligible part, a negligible share of all the cases submitted to ICSID. We see over 900 cases submitted to arbitration. So out of these 14 cases submitted to conciliation, 12 have been concluded, and from what I could gather on the ICSID website, 3 were followed by settlement agreements. So 3 out of 12 of these conciliation led to a settlement between investors and states. So really, we can see here that the field has been dominated by arbitration, and that mediation or conciliation has been negligible to a certain extent. But of course, the landscape of arbitration has been changing a lot. I argue in a book co-written with my colleague from the University of Hong Kong, Alex Stone-Sweet, that international arbitration has been judicialized over the past decades, which means it is costlier, lengthier, more complex procedurally than it was meant to be. And this could, of course, be a significant driver pushing cases towards mediation or conciliation. And here I would like to draw from the past to see that, in fact, mediation has been used in the past as a successful dispute settlement method in major investor-state cases. And I will bring you back to the 1950s very briefly and give 4 examples of mediations that have been successful. One involved the city of Tokyo, which is quite interesting because we're here in Tokyo talking about mediation. It was a mediation and dispute between French bondholders and the city of Tokyo, settled in 1952. Another famous mediation was a mediation in a dispute between Iran and the Anglo-Iranian oil company following the nationalization of the Abadan oil refinery, which was at the time the largest oil refinery in the world. The mediation initially failed in 1951, but the dispute was settled in 1954. For those of you who are interested in international law, there was also a case before the International Court of Justice, a case of diplomatic protection. The third example is a mediation in the dispute between Egypt and Franco-British investors after the nationalization of the Suez Canal that was settled in 1958. And finally, a state-to-state dispute, a mediation in the Indus Waters dispute between India and Pakistan, which led to the signature of the Indus Waters Treaty in 1960. So you may have noticed that all of these mediations involve disputes taking place either in the Middle East or in Asia. And there has been an argument in the literature, which has often been made, but rarely been tested empirically, that these cultures would provide a more conducive ground to mediated solutions to disputes. But this is something that I will leave here without taking a position in this debate. In fact, those mediation that I mentioned earlier, this mediation involved the president of the World Bank and the legal vice president of the World Bank. And they led these people at the World Bank to think about establishing a machinery for the settlement of investment disputes, which led to the establishment of ICSID in the late 1960s and 1970s. So here we see an address by President Black, the president of the World Bank, in Vienna in 1961, who is basically saying this in his own terms. The bank as an institution and the president of the bank in his personal capacity have on several occasions been approached by member governments to assist in the settlement of financial disputes involving private parties. We have indeed succeeded in facilitating settlements in some issues of this kind, but the bank is not really equipped to handle this sort of business in the course of its regular routine. The fact that governments and private interests have turned to the bank to provide this assistance indicates the lack of any other specific machinery for conciliation and arbitration, which is regarded as adequate by investors and governments alike. I therefore intend to explore with other institutions and with our member governments whether something might not be done to promote the establishment of machinery of this kind. This is an important citation because it shows something that most commentators of investor-state arbitration have forgotten, which is the DNA of most arbitral institutions lies in mediation and conciliation, not in arbitration. And this is very clearly the case for ICSID, which in its early stages really put the emphasis on conciliation. It hasn't been successful, but it's still important to know that this was very much on the top of their minds. The same can be said of the International Chamber of Commerce in Paris, whose founders really wanted to promote mediation and conciliation. So we're really here back to the roots of what constituted these very successful enterprises in international dispute settlement. So these examples also suggest two things concerning the two traditional hurdles that I presented a bit earlier. It seems like even complex machineries like states in complex disputes such as the Suez Canal dispute or the Abadan disputes, these are very major disputes in the 1950s. Even these complex machineries seem well equipped to settle disputes when the proper mediation mechanism is offered. So what does it mean? You know, the proper mediation mechanism. This is something that I will leave as a question, but I think it really suggests that there is room for successful mediation mechanisms in this field. Then the argument of confidentiality is not, in my eyes at least, necessarily something that goes against the development of mediation. It could be, in fact, an additional argument in favor of mediation in the context of investor-state disputes at a time when some argue that too much transparency might be a problem. And if states and investors want to make their settlement agreement public, they can very simply do that by providing so in their settlement agreement. So really, I think there is, again, a way to look at it which is more hopeful than what the traditional argument provides. So I will stop here, and I thank you very much for your attention. I will stop sharing my slides, and I will give back the floor to Annette. Thank you.
Thank you very much for kicking us off, Florian. That was very, very insightful, and you covered a lot of topics. I like your description of the legal momentum that we are currently in. I liked sort of that description. And you also pointed out some of the traditional hurdles. And I think throughout the conversation over the next hour, we will have an opportunity to hear more and dive a little bit deeper in that specific topic of the hurdles to the use of mediation and investor-state disputes. I also find it very encouraging to look at the historical examples. So we have talked over these 2 days about the necessity of having success stories to share when it comes to mediation, and you have just added to that list. And that is very, very helpful. So we will now engage in a discussion, and we will talk a little bit about sort of the use of mediation so far by states. What do we know about that in investor-state disputes? And we will ask the question, do we think that mediation perhaps should be used more? You may guess what we want to answer that question with. And if so, how do we support a development in that direction, that we can see an increased use of mediation in investor-state disputes? But first, I thought it would be good to kick off maybe to talk about the basics, because we use the term mediation, and it would be good to really set the scene. What exactly, when we in this particular setting, investor-state disputes, and we talk about mediation, what does that mean? What do we mean, and what are the key characteristics of mediation in this setting? And also, when is it best used? So this is the perspective or the question we will start out with. And Liz, I think I give the floor to you to start out with that.
Better? Okay. Thank you very much. And before I begin, I also wanted to thank the organizers, the government of Japan, the ADB, ADBI, UNCITRAL, and everybody who has been here. I have to say, participating and listening to everybody over the past 2 days, I've learned a lot and have been amazed by kind of the wealth of knowledge in this room. So I love these initiatives where you bring people together from different governments with different experiences. Now, on this first question, I think of mediation as having two main elements, right? And credit to Frauke for this too, because you have your settlement, which I had kind of often lump in together with mediation, that your voluntarily agreed settlement agreement. And then the mediation part is that the agreement is formed with the assistance of a third party. So kind of not a legal definition, but kind of an imprecise definition of those two elements. And I have to say, with the first part, the settlement agreement, we're actually seeing a lot of settlements in investor-state dispute settlement. And when I talk about investor-state dispute settlement, I really mean treaty-based investor-state dispute settlement. And according to statistics that I've seen, we have about 30% of the cases are actually settled. And I think in a way, those do raise concerns, and Florian's presentation highlighted them nicely. One, I would say, is I think some of the settlements might be arising from fear. As we've seen from data regarding ISDS in the first, I've got some of the numbers here because I wouldn't remember them, but from 1994 to 2003, the average size of an award was 25 million. The next decade, 2004 to 2013, average size of an award was 98 million. 2014 to 2023, the average size of an award was 256 million. And in that same decade, the average claim was $1 billion. This is data from UNCTAD. So you think if you're a government and you're faced with a claim for over $1 billion, the impulse to settle is really strong because it's a very uncertain area of law. So it's also very difficult to predict the outcome. So in some sense, I worry that the settlement is not so much of consensual agreement as opposed to one arise of duress or maybe even extortion. So I think that that's one concern. Another is it raises all kinds of tricky governance issues, which Florian highlighted, that who has the authority to settle, on what terms, with what level of public participation. And the settlement agreements, and we've seen this in other ISDS cases, can themselves give rise to ISDS claims. So it's very important to make sure that you're getting them right so that the next step doesn't actually become even worse. So I think it's important to consider in this panel and discussion, those are the issues with settlements. Now, by having a mediated settlement, the involvement of a third party, does that help us avoid some of those issues? Will that be a better outcome if we can involve a mediator as opposed to just the negotiated settlement between the parties?
Thank you, Lisa. And I think for answering the question, but also asking a number of new questions. So I think that would really help the discussion. Frauke, I think you can add a little bit to when settlement or sort of when mediation is used and when will be throughout the process.
Yeah, thank you. Can you hear me? Yeah. First of all, also from my end, thank you to the organizing institutions. I have attended a similar event in 2017 with so much energy, so much discussion during lunch and during coffee that was catalytic for mediation. I can say that, and I do have no small hope that this event will contribute to it similarly. Let me go back to your first question on the definition, right? In the ICSID convention, you have conciliation, and then we have the mediation rules. Why do we have that? Why do we have two sets? And under Singapore Convention and in UNCITRAL, it's interchangeably. Isn't that confusing? So in the ICSID setting, you have a very clear scope for convention conciliation, the information that Florian shared. And then we have the mediation that has a different scope. You don't need to be a foreign national. You don't need to have a membership link to ICSID. The mediator has a slightly different role from a conciliator. And so that is sort of from the perception, for the conceptual view, the starting point. I would like to pick up the slide that on the statistics. Florian pointed out one thing that we have been discussing at ICSID. How can we publish information about mediation while keeping in mind our institutional obligation to keep it confidential unless we have the agreement of the party? So you will see changes there because we are nearing a critical mass, and then we can share that information also in beautiful pies. Last thing, conciliation was long misunderstood as an evaluative process. This came out from the first conciliation report where a judge was appointed as conciliator and understood his role to be to write an evaluation how this would have played out in court. I can tell you I spent months of my life to research this, and I came to the conclusion that this was a misunderstanding. You look at the ICSID convention text, you look at the ICSID convention rules, you look at the preparatory framework and the history of the ICSID convention. There was no intent whatsoever to have that. And so once the process is misunderstood, you have treaty clauses that say arbitration or conciliation. So underneath, there are reasons perhaps why conciliation hasn't been so much used. Because in the empirical data that we will get to, I will show you that there has been quite a few. But now to your question that you actually asked me right now, and that is, when can mediation be used? And there is a conceptual view oftentimes that mediation is only available in the investment disputes context in the cooling off period. And what we try to visualize on the slide is, if you take the understanding that mediation is negotiation between the parties facilitated by a mediator, mediation is possible whenever negotiation is possible. So you could have conceptually a mediation at the beginning of an investment relationship. When you negotiate a contract, you could have a mediator. For that matter, even if you negotiate treaty provisions, you could have a mediator. And one state came to me and said, Frauke, we're really stuck. We could really use a mediator in our treaty negotiations. Then mediation is available throughout the operations. And then, of course, in the context of cooling off period and in parallel to an arbitration. And we have seen that And George mentioned it earlier. You can suspend the arbitration, you can mediate. This is possible in the exit context as well. And in practice, we see that mediation also happens after an award has been rendered. And so this offers for a wide spectrum of opportunities when to mediate. Okay, I can take it further because what we are discussing is policy decisions. And we will touch upon later, maybe institutional readiness is one point we can pick up later, but what does this mean for policy? And we have done an analysis of mediation provisions in investment treaties that we are currently updating. So if you look at investment treaties and dispute settlement and mediation, over the last decades, considerable increase in provisions providing for amicable dispute settlement in that context, and specifically for mediation. We have tried to group them in 5 categories: a bare direction to seek amicable settlement, then the next category, expressly permitting mediation or other forms, putting it on a different footing, or including additional language to in fact encourage mediation, or even mandating mediation prior to the institution of other dispute settlement options. And a last category, stipulating that mediation is available at any point, picking up from what we have seen on the prior slide. You don't have to mediate before arbitration, but if you start an arbitration and you think mediation is actually better, you can still do that. And I think Guru has an example for us from that on a provision.
All right.
Go ahead.
Right. Thank you very much. First of all, I would like to thanks also to ADB, ADBI, UNCITRAL, and Government of Japan for holding this event. And this is I'm very pleased to join the discussion, of course, and hopefully can contribute to the discussion. Okay. On the question that you mentioned, I don't know whether you asking me on the previous question or you're furthering this.
So I was thinking about, I understand that Indonesia, you have included language that includes mediation in a recent treaty. And so
yes,
I understand you will be able to share from that.
Okay. For the mediation, we had at least 3 treaties, the new treaty that include mediations with, if I'm not mistaken, with not UA, with Canada, yeah, also with maybe Australia, but on the banner of conciliations, and also with the Switzerland. And if we compare between 3 of them, the use of mediation in the context of Indonesia, Australia, SEPA, using conciliation. I understand that sometimes in that context, in our side, there is a mixed understanding about these 2 mechanisms, because both of them actually assisted, right? But one of them, like conciliation, there is an active role by the conciliator to offer a kind of solution. For the Indonesia-Australia conciliation, it's actually compulsory and can only be initiated by the state. But other thing with the Switzerland is an optional, whereas it should be initiated by, of course, by the disputing investors, and that's not compulsory. It is optional. And the other part of the story is we actually trying to pursue more in other negotiation for having a mandatory, because we understand that without having a mandatory, there is no chance for the investor will pursue the solution through mediation, because they only want to go to arbitration. I think that's at least what I can say in response to your question.
So thank you. And just to say that, Lisa, I have not forgot your bringing up the topic of the numbers that you mentioned. I think we'll come back to that a little bit later on in the conversation, because I would like to hear the panel's views on that, how sort of to avoid the, so just to prepare the panel, that I will ask you this, so how can we mitigate this sort of negative pressure that Lisa described, just looking at the numbers of the sheer magnitude of some of these awards being awarded and how that is sort of increasing over time. But before we get into that, so we have heard now about the language in treaties, potential language in treaties for the use of mediation, and how that can support the use of mediation and maybe lower the hurdles to step into the mediation from the parties. But one thing that I think we are all interested in is to learn a little bit more of actual experiences of mediation and what this looks like. If we could delve a little bit deeper into that topic. So Guru, may I turn to you again and see if you have something to share from Indonesia?
Thank you for that. From the experience of Indonesia, we had already like 8 cases so far on the ISDS. But if I'm not mistaken, so far those 8 cases goes through to the arbitration. So that when we're talking about mediation itself, I think it's never applied in the context of those 8. But the mediations has a legal momentum in Indonesia treaty law practice. This is because of there's one cases in between 2012 and 2014, whereas the Churchill Mining make a complaint to the government of Indonesia in the issues of the ISDS, and the claims is amount like 1.3 billion US dollars. Numbers that will make the countries maybe a bit mad to that, yeah. And after that, there is an effort to review, because we think that the problem must be in the bilateral investment treaty. And then we found out from the review, we're going at the time, the decision was to terminate certain BIT, which is an old BIT. We're doing making a new template of BIT, and then negotiating a new BIT. And in terms of negotiating new BIT, there are 2 grand strategy. The grand strategy is how to direct that within the multilateral and bilateral, which is how we can put or avoid arbitrations before put procedures before the arbitrations, which is mediations became a prominent, and we put also and introduce that in our paper when we're negotiating or taking part in the discussion of ISDS reform in ancestral. And we put also in the bilateral. As I mentioned, we try to introduce that in our BIT with Singapore, UAE, Switzerland, Indonesia, Australia SIPA investment chapter, and also Indonesia, Canada. But the result was different. As I said before, there is a conciliation, which is AK at the time we would think it's similar with mediations. And there is also one which is maybe prospective, whereas as intermediate process, other than mediation, we're setting up like a joint committee. This is with the UAE, joint committee between which consists of senior officials of both countries, Indonesia and UAE, and then there will be a meeting, kind of mediating between, let's say, if Indonesia have a case with the UAE investors, the investor will present in this joint committee meeting, and we will talk together. Even though it's not really clear whether the UAE representation became mediator in that case, or is actually not mediating. But at least in our side, there is an intermediate process, which is not directly come into the arbitration, which we expect it will reduce the possibility of a costly a process and long process. I think that's my response to that. Thank you.
So would it be fair to say that you don't have sort of mediation in all of these instruments, but there are different examples of mechanisms that will help the parties get off the train, so to speak, towards a full-fledged arbitration somewhere along the line before you reach that station, right?
Yeah, I can say like that, but the procedures will kick in. It's not like Ms. Frauke mentioned that it can be everywhere. I mean, every stage of the ISDS. It should be like a staging. For example, the consultation, it could take like 6 months, and after that there will be additional either mediation, conciliation, or whatsoever, 6 months, and after that, if the solution could not be reached, of course the investor could go through the arbitration. Thank you.
I think what Guru was just sharing is incredibly important. It's incredibly important for states to set up mechanisms that work within your jurisdiction for whether you want to call it early warning mechanism or dispute management or grievance mechanism to catch it. I sometimes use the example of I have 2 children and I hope that they will not come in conflict with the law. But as Florian already shared, you have states are not monolithic structures. You have many agencies and ministries that apply international or domestic law for that matter, where maybe there is an unawareness of what is going on. And it is important for states to catch this earlier. And there are different models, one by the World Bank that's now called the Investor Grievance Mechanism, and before it had the abbreviation of CERM or Merci in French. And there's another model of the Energy Charter Treaty, which is the model instrument. And if you haven't seen that, I can only recommend having a look. Because what they did is they put together a legislative instrument, whatever this may be in your jurisdiction, and identifying what are aspects that a state may wish to look into to regulate, to assist with investment conflict management early, whether you call this dispute avoidance or dispute prevention, whatever, but it is this management aspect. And countries have adopted that in different ways, depending on their jurisdictions. Interministerial commission in Vietnam, or in Peru, you have a separate agencies that deals with the defense. They call it defense, but they do actually management. Or you don't have a standing body. There are states that say it works much better because I know my counterpart in the different ministries and they know that I have the convening power and the direct access to the prime minister. So there are many different models, but the gist of it is it's really important to set that up to catch it.
So I will turn to Lisa now with a question, but after that, Florian, I will give you the floor and give you an opportunity to share any reflections that you have having listened to the conversation so far. But Lisa, you work with a lot of clients, state clients. So I would be curious to hear what are the kind of conversations you are having with your clients when it comes to sort of the use of mediation. What is their appetite for mediation, and you have given us some indication of what could be some of the hurdles, but sort of, or do you see any practical use of mediation in your practice?
Yeah, great, thanks. So, and as you mentioned earlier, at the firm that I work at, in the area of investor-state dispute settlement, Curtis Millay only represents states. So we don't represent investors suing states, we only represent governments. So my comments are from the perspective of representing states. Now, as Frauke highlighted, we've seen, and you can have mediation arise at any time prior to the notice of dispute, after the notice of dispute, but before commencement of arbitration, during the arbitration, or even after issuance of the award. So I'll just give a couple of examples of that from recent cases. Now they're confidential, so it will be kind of very high level remarks. But one example is with conciliation. Now, when I speak about conciliation, it's conciliation under the ICSID rules. So that's a kind of a specific form maybe of conciliation with particular understanding. Now here, I think that the satisfaction was not very high with the process for a couple of reasons. One is that it felt similar to an arbitration in terms of some of the rigidity and the evaluation of the case. So it seemed similar without the flexibility that the parties might have wanted. But then in the sense it was too rigid, it was also too flexible. And that when it became apparent that it was not going to result in an outcome, a mediated agreement, a settlement agreement, it still kept going. And it was hard to end it. So I think that it was felt that there was a lot of resources, energy, and time put into this process when it really kind of should have and could have stopped sooner. There were also concerns that the state felt that there was undue pressure to settle, and the state had important reasons why it did not feel like settlement was appropriate in this case, but felt like it was feeling pressure to settle this dispute. So it was not resolved, and it's possible now that the state will be taken to arbitration. We're not sure what the next step will be in that. Now with mediation, there was another recent dispute where this was post-award. So an award had been rendered against the state, and we didn't work on the underlying arbitration, but then the amount had been awarded that the state had to pay. So here you had already the determination of liability and then the award that would kind of crystallize the amount. So that helped the state avoid some of the concerns around mediation, where there is this concern that a state doesn't want to agree to pay an amount before it has been deemed liable to pay that amount, especially when we're talking about these sums. So the mediation was related to the amount that actually would be paid out of the award, because as you might know, after an award is rendered, there can still be a lot of costly litigation around the world as the investor seeks to enforce the award and the state exercises its rights under the ICSID Convention or the New York Convention as it may be to defend against enforcement, whether based on sovereign immunity or other defenses that are available. So rather than go through that process and have each side litigate enforcement of the award or resistance of enforcement, they mediated to agree to a payment amount and timing. So that was an example of kind of a post-award mediation. So those are two examples, but there are some more that we can discuss further.
Thank you so much. That's super interesting. And like we have come back to over and over again these 2 days, it's, we need the examples. So this is very helpful. So Florian, you have now listened to our conversation here on sort of the use of mediation and different aspects of that. What are your thoughts, having listened to the conversation?
Well, I don't know where to start. I mean, that's very interesting to hear, the views of panelists coming from very different perspectives, but I can see some level of alignment between these different views. So I would simply start by picking on the comment that I thought was interesting on the pressure concerning numbers, and then maybe say a few words about the rigidity of some mediation or conciliation practices. I can see, I mean, that's an interesting argument, that because the numbers and the stakes are higher, there's additional incentive for states to settle or to settle via mediation. But I could also see a disincentive on the side of investors to settle because the stakes are higher. So of course, I mean, we have to look at both sides to be able to reach a settlement. You need an agreement on both sides. There is an additional pressure point, and Lisa might, and all of you, in fact, have experience with that, which is the pressure point of from the perspective of the lawyers representing the parties. I mean, most of the law practices involved in this business come mostly from the arbitration world. What is their incentive to trust, the settlement of a dispute or the resolution of a dispute by, advising their client to go to a mediation process. And of course, I'm also thinking about the question of fees, which have become enormous in the field of investor-state dispute settlement. And of course, going through a mediation leading to a settlement might affect significantly those fees. So perhaps there is a education to be made, and I know some of you have been already deeply involved in that process. But not only education of states, but also education of those representing the investors and the states to be able to reach those agreements. And then there is a very interesting aspect of the discussion concerning the way in which mediation or conciliation might look like. And I've had a bit of experience with those processes, with at least one conciliation case and one mediation case. And my experience was rather similar to what Liz mentioned. Either the mediation process was mandated by agreement, and basically the goal was simply to comply with a certain contractual obligation. And for that reason, it was extremely brief and superficial. Or the mediator or the mediators came themselves from the world of arbitration. And I think coming from the world of arbitration, they might not have been so well equipped to handle a mediation case because these are different skills. In the examples I brought earlier, you will have noticed that these cases were mediated by high officials of the World Bank, people who had absolutely zero experience in arbitration, I mean, for good reasons. At the time, it was not so developed, but had a certain level of authority that could be considered and heard by the disputing parties. I mean, this is only food for thought, but I'm thinking that mediators should be in charge of mediation and mediators who have some level of authority over the parties involved in those cases.
Thank you so much for that. So many questions, so little time. Frauke wanted to comment on your remarks, Florian, so I will let her do that before I come back with the next question to you guys.
I just want to underline what Florian was just saying, is that, you know, if you have a process that you choose, and we had good discussions over the last 2 days, you want the person in charge who knows the process. And if you go to arbitration, you want an arbitrator. And when you go to mediation, I encourage you to go to a professional, experienced mediator who has practical experience with the skill set, because it's very different. And I know the mediators in the room can support that. But if you have an arbitrator running a conciliation or a mediation, it will look different. And Nadia had really interesting statistics yesterday about client satisfaction. And the client satisfaction goes down if you don't have the right person in the driver's seat. So just to underline that.
And maybe this goes back to the point of education, right? Understanding the difference between an arbitrator and a mediator, and really, you know, getting that message out there. So we have been talking about the use of mediation, and I sort of get the, and maybe I could be wrong, so then you can tell me I'm wrong, but the sense that there is potential to maybe use mediation more. We talked about the advantages of mediation throughout these 2 days and how that could be to the benefit of all parties involved. To save costs and to save time used in the right way. So my question then, do we want to see more mediation in investor-state disputes? And for that to happen, what would be required? I'm looking at you, Guru, if you want to take a first stab at that set of questions.
Right. I think as negotiators and also officially setting up a kind of position in the negotiation, is not actually specifically for mediation itself, but how to build a consensus before the arbitration. That's the most important thing. That's why even though the main feature of the, let's say, reform that we would like to have is mandatory mediation. We call it mandatory mediations, but we always open to have other mechanism that can facilitate early solution for the parties. Because at the end, what we think is investors need to have a good relation with the state and as well as also the state, because we don't want both of them has a kind of, because of broken-hearted because of this situation. Of course, in the future, we do expect mediation be applied, even though until now we don't have that kind of thing. But we do envision this, and we will always introduce that in our negotiation. But of course, it depends on the partner of negotiation, whether they have the same vision as us. Thank you.
Thank you. So Lisa, if I can just ask you to also briefly comment on that question, and maybe if you have any, do you have any ideas or thoughts on what could remove some of that pressure that you described at the beginning of your remarks? Again, going back to the numbers and the large awards that we have seen in recent years and so forth. Could there be a way around that? And yeah, how would one go about that?
Yeah, no, I mean, I think it's a great question. I mean, I do see that there, as we see from the past 2 days, there is increasing interest in mediation of investor-state disputes. But I think a lot of that interest is because of a fear and concern around ISDS. So it isn't so much maybe necessarily the interest in mediation as such for these types of cases, but that people just want something different than ISDS. I mean, I gave the numbers on damage awards, but then the cost of litigating, arbitrating the cases on average, and this is numbers from a couple of years ago, is $8 million. But I think, you have individual cases. There was one case recently involving Colombia where the claimant spent $33 million. I mean, and that is just one dispute. It didn't even go through a next phase. So the numbers are staggering. So you're looking for something else. But I think in this sense, exactly what you said, you might want to do a holistic review of your investment treaty and see what types of disputes are actually actionable, and take a broader approach. And I think that is an important thing to do. And then as part of that, you can consider what types of dispute resolution mechanisms are appropriate. And it might be exhaustion of local remedies in some contexts. It might be mediation, but looking more holistically at the different ways of designing dispute resolution to fit the circumstances. So there's the why, do you want to mediate as an alternative to ISDS, or do you want to mediate because you think that's the right approach? And then there's also these how questions. And I think when you have government settlement of disputes at the domestic level, often you'll have statutory or regulatory or practice guidelines on when and how a government can settle. And these might be, you have to make sure that your settlement agreement is confidential. In some cases, it might need to be approved by a court. You might need to make sure that all interested and affected third parties are party to the settlement agreement. So you can look around at different countries and the experiences of best practices in terms of settlement. And I think that might be something to consider in terms of how actually to do it, if you are going to.
Looping back then to actually doing it. Frauke, you have done some research on sort of the universe of mediations in investor-state disputes. And do I understand you correctly, this is sort of wider than the ICSID footprint of this world? Okay.
So I have looked into mediation because you always hear mediation is a good idea for the future, and in theory it would be good. And certainly that is an overcoming understanding in the arbitration community. And then I have looked further. And once you talk to the experienced mediators in the world who do all kinds of mediation, you actually find out, if this works, that there are a number of what I would call real investment mediations, not conciliations, but with a mediator who is experienced, where the process was a real mediation. And just to keep that in mind, facilitated negotiation, when you enter mediation, you don't have to settle. You can leave if you consider that that is not in your interest. And so when we look at the data, what does it show? There have been over 30. The number is now close to 40. I just have not had the time to fully update it with all points. Who are the investors? It's not only natural persons, but it's juridical. It's from all major regions of the world. I was surprised, right? We've heard earlier about whether it's more in Asia because the legal tradition is more on settlement, or maybe sometimes you hear it's Africa or maybe North America, but it is really all major regions of the world. Involved on the state side and on the investor side. Industry sectors. Are there certain industry sectors that are more prone to mediation than others? And from the data that we have so far, you cannot discern that. It's more about a question of suitability. When do you decide you want to negotiate? And I hope that you negotiate because you consider that's in your best interest, and perhaps you haven't heard about the dispute before, and whether it happens from a space of fear is something maybe we look into a bit more. What is the basis of consent for investment mediation? And that is an interesting aspect. I have not found so far a mediation based on a treaty provision, but a lot on ad hoc agreement between the parties or on a contractual provision. And at what point in time, I found this most interesting because this data came after the conceptual analysis of mediation. It's actually confirmed with empirical data. You have investment mediation, pre-arbitration in parallel, or the example that Lisa mentioned, post-arbitration. And this is here where it's interesting, right? The empirical data between 1 month and 2 years from the appointment of the mediator. And if you compare that to investment arbitration, that takes significantly longer overall. And what's interesting from the empirical data is that in this duration, it's not an active mediation over 8 months or 1 month. But you have different meetings with different people from each side, jointly or separately. You have it over Zoom or in person. And in the investment context, a lot of time is devoted to the implementation of the agreement. And the nature of a settlement in investment disputes is not necessarily a contract. It may require a law to be implemented, which is where the confidentiality discussion it's different in practice, because once you need a law, the parliament will know and it will get published in the official gazette. So you have aspects very transparent on that. Maybe we pick that up separately again. And when you look at the cost of the investment mediation, it is also significantly lower from the arbitration. Under $25,000 or 200,000 was the max that I found. This process cost involves the mediator's fee, venues, it excludes legal fees. But you don't have, it's easily explainable. You don't have a tribunal, a 3-member body writing a 300-page award. You don't have a 2-week hearing with witnesses and experts. And so that brings the cost down. One aspect for settlement in that discussion, which might fit here in the duration aspect, is that in some countries, they have set provision, they have mediation centers at their attorney general's offices. Ecuador is an example. And in some countries, settlement agreements are run by the Government Accountability Office before they are signed. And this is something that I think we should keep in mind when we have concerns about certain aspects, and you encourage us to think that way, is what process can you build around it? And if you have a concern about a settlement, to me, it seems a good idea to get your accountability office in or another body to spread not only political responsibility, but to ensure that public funds are used well.
So what was the number you said, Lisa? Was it 33 million? You said in illegal fees, right? And now we have 200,000 maximum, right? So that's a contrast that's sort of worth taking note of. So thank you, Frauke. This is super interesting. And I think this is the kind of research that is really, really welcome in a conversation like this. So now I want to turn to the audience and see if we have any questions. And I happen to know we have experience from investor-state mediation in the room. So if someone wants to share that, that will be welcome too, to add to the complete picture. So we have one question down here, Justice Knowles.
Just given how consequential the numbers are, they can alter the entire dynamic. Do we need more research into why the numbers have been moving up so rapidly? Thank you. Whoever you like.
Let's see. Many questions online, so I'll give Lisa a minute to think about that. Did we have one over here? Thank you.
Hi. So I'd like to play the devil's advocate and ask, what are the negative considerations for states in looking into mediation? I've heard very good things of mediation. I love it. But as a person that is from the States, I'd also like to know the negative considerations. Thanks.
Very good question. We should always look at both sides. We have heard about the glass being half full and half empty earlier today, so this is a good example of that. And I will have, do we have any questions online that we should add to the list of this bouquet of questions we're sending to the panel? Okay, well, we get help to digging out the questions. So do we have any responses here now to first the state perspective, the negative sides, but also the research? Who wants to go first? Lisa, you want to go, the researcher?
Is my former life as a researcher. But I mean, it's a great question and it's hard to pin it down, but I think there are some factors, and we were discussing this last night at dinner as well. I mean, I think one issue is that the standards are so vague. There are no pleading standards either. So the kind of the initial statement of the claim, you don't really have to put forth much evidence in order to substantiate your claim. And it's very difficult to get a claim kicked out for being frivolous. So there's an incentive in a way to anchor your claim in a very high amount with the hope that you get even a fraction of that, because that will still be significant. There are also indications, though it's hard to get with the data and more research needs to be done, that third-party funding is driving the increase, that we have a rise in third-party funding claimants to bring claims. They want a share of that award, so the awards are inflated and the third-party funders get a portion of that. But I think it is increasingly, we've also seen the use of discounted cash flow methodology to award large sums of damages, including in the case that you reviewed, for projects that never even got off the ground. And there are some concerns that because of the system of party appointed experts, that there's also an incentive to inflate the numbers and get reappointments. So, I mean, I think there are a number of factors involved. And just quickly on the risks, I think the risks are significant, but it also depends. Some of the conversations that we've had over the past couple of days relating to the way a mediation can be written also has implications for the riskiness for a state. So for instance, if you just did a mediated settlement agreement as part of a contract, then you can challenge that contract, try and enforce that contract under the relevant domestic law before the court or before other dispute settlement mechanisms. If you say that contract, that settlement agreement then becomes a consent award, then it's enforceable under international law, under the ICSID Convention or New York Convention, and your ability to contest enforcement of that, if, for instance, it was illegal, are significantly limited. If you have, so I think we discussed, there was the example of the AMA, the arbitration approach. I think that can raise risks for states. And with the Singapore Convention, you have certain types of protections for agreements that might be contrary to domestic law, but it just, it depends then what the applicable domestic law is and whether or not that has adequate guarantees for the legality of the contract. So, I mean, I think there are so many different considerations, but I agree, it is risky.
Lisa, and I think the list of issues you just gave in terms of in response to the question on if there's any research, I think that's an agenda for a full day in and of itself, right? So I'm just picking up on one, the frivolous claims, and then we have seen more and more institutions now, including rules, to actually mitigate that risk. But again, I think a whole discussion could be held about that, but it's important to bring it to the table. Frauke.
Yeah. There is research actually done from Singapore. It's from 2017 by now, but what are obstacles to settlement in investment disputes? And what are obstacles to settlement are also obstacles to engaging in a process that has as its goal settlement. And so it's from the National University of Singapore. They did a survey and asked participants, what do you think are the primary obstacles? And the number one was avoiding political responsibility. Even if you knew settlement was in your interest in some way, you did not, as the government, want to take the responsibility for that settlement, right? And here I come back to process requirements, like can you build a process around it for this political dimension aspect, which every investment dispute has inherently in. So, and there are other aspects that are similarly rated, but that was the number one.
So I've been looking at the questions from the online viewers. Thank you for those. So one of them relates to what you just commented on, Lisa, sort of the practice of having a settlement, an agreed settlement, and then turned into an award, and then you have the enforcement of this award under the New York Convention. And this is sort of not unique for investor-state mediation. This is something that could happen in a business-to-business context as well. And Lisa, you outlined some of the issues that could be problematic from your perspective in a scenario like that. Does anyone else on the panel have anything to add on that, or any comments on sort of this practice, or whether this is a practice that should be used or not? And I'd like to include you, Florian,
Yes,
also, if you have any comments
of course.
on that.
Yeah, just nothing really deep, but I have encountered this practice of incorporating settlement agreements in awards, thus making them consent awards. Interestingly, in those cases, and the scenario mentioned by Liz was what just happened, which is new claims arose out of the settlement agreement, and these claims went to arbitration. So you had a settlement agreement generating more claims, generating more arbitration cases, and whether they were incorporated in a consent award or not. So of course, the mechanism of a consent award is very effective in ensuring the enforcement of the settlement agreement. It might not prevent claims from reappearing at a later stage. I mean, there is an inherent ambiguity in this consent award type of figure, whether it's a contract or an award, and whether it can be arbitrated again or not. So it is a good practice, but it doesn't solve, the problem that was highlighted earlier. Yeah.
I think that's a very good illustration, Florian, that you just gave of the importance of diligence, right? To when we talk about different dispute resolution options and solutions, I think everyone in this room would agree there is not one size fits all, and you always have to be very diligent in the precise situation that you are in and the precise dispute that you are in. And how you are sort of taking care of that dispute and what you are opting for and what kind of strategy you are applying. So thank you for that. Frauke, you had something to add as well.
Yeah, because I did also empirical research on settlements and exit arbitration, and I looked at 14 years of arbitrations that discontinued, and how many of these are actual settlement, and how many of these are actually publicly available, and the vast majority is publicly available. And then I looked at how many of these actually came back. Right, the question of what is compliance, and we have a settlement agreement, and does that work? And what the data shows, assuming that you have a diligent lawyer who puts in a dispute resolution clause that would provide for exit, because it started with an exit arbitration, Out of about 160, we have only 3 cases that came back where it was specific. There are companies or investors that have multiple disputes, but they arise out of different measures. But the dispute came back on the basis of non-compliance with the settlement. And what I think what that tells us is that it is not easy to get a settlement. Argentinian cases show that to us, right? For many years, there was hard-fought arbitrations, and then there was settlement maybe 8, 9 years, 10 years later. But once you have the settlement, it usually holds, at least from the empirical data, that is what we can.
Thank you for that examples from statistics. That's very interesting. So we have time for one more question. Please.
Thank you. My question is, how can mediation be integrated with other dispute mechanisms to form effective hybrid models? And what examples from the commercial sphere can be informed this process? Maybe my question is for information and confirmation. My question is addressed to Lisa. Okay, thank you so much.
I mean, if there are others who also want to chime in, I can be quick. I mean, I think your question, I think, is also related to the question on the screen, which I think is a great one. What motivation do investors have to submit their disputes to mediation, since their interest to extract maximum compensation for states? I think under the current system of treaties, investors have the option, right? They get to decide whether you go to arbitration or whether they want to offer to mediate. And so it'd be very tricky if you want to mediate, like in your experience, you'd have to have a treaty insisting on mediation in order to guarantee that that would happen. Because if it's in the investor's best interest, if they think it is, to go ahead and try and sue, then that's what they'll do. So, I mean, it's hard to think of the way you can make sure to integrate mediation without an approach like you have been pursuing, right?
Like you want to add something to that?
That's a very interesting question, especially the fourth question, whether since about the one motivation investor have to submit their dispute in mediation. I'm not really sure whether the interest of investor actually really want to have the have maximum compensation from the state, because usually the result of the compensation is monetary, right? But there is a long-term. Of course, it should be a long-term, let's say, a long-term goal by the investor. They want to have a business in the country, right? If they just want to extract maximum compensation, which is monetary, meaning that, let's say, the state is defeated in the arbitration, in the next step, they just want to go away from that state. But if the investor actually want really to have a business within the state, the maximum compensation must not be, possibility is not really related to monetary, but maybe more incentive, more concession, and so on. This is what happened in let's say in our cases. From the 8 cases, if we relate to the previous questions, from the 8 cases, we only defeated 1, meaning that even though there is a perception that the investor always succeed in the ISDS cases, maybe between one and another country, it has a different experiences, and in our case, some of them actually in favor to the state, and some of them actually be settled outside of the process. So lesson learned from this, we can always find a way in order not only to follow the staging of the process in dispute resolution, but we can always have other utilizing other procedures which might available under the treaty itself. For example, consultation itself, and maybe mediation if it is so provided it can be invoked within the process of arbitration, for example. Thank you.
Thank you. You're outlining sort of the short-term and long-term perspective, and I think that is very, very important and very, very valuable. One could have different ways of reading statistics and numbers. So I think saying that investors win most of the cases, some would say that's not the case, and they would read the statistics differently. So I think that's also a conversation we have to save for the next conference, and also the sort of the incentives or the goals for investors. To have as high claims as possible, or to have a long-term business operation in the country, and they may not be able to combine. So what is most likely? Again, a conversation, very interesting conversation to be had. I'm so sorry, but we have to stop. So thank you so much, everyone on the panel, for engaging in this conversation. I had really fun moderating. And thank you everyone who contributed from the floor. And now we will have a break for 10 minutes and we will come back at 5. No, wrong?
Sorry, we can give another coffee break.
Oh, no break. All right. So we go straight into the next panel. So then apologies to the panel afterwards. We stole 5 minutes from you. Thank you, everyone.
Thank you very much.
Dr. Florian, can you stay for the photo shoot, please? He left. Okay.
Thank you for leading the rich and insightful discussion, Ms. Magnussen. And dear moderator and panelists for session 8, please come to the stage and take your seats. Yeah. Dear panelists, please give us a moment. We will arranging the stage soon. We are waiting for one more panelist. Yes, ladies and gentlemen, thank you for joining this long journey throughout so many insightful sessions. And finally, we are starting the concluding session. And the theme of a concluding session is cooperation, which ties back to the collective effort we've emphasized since the very first keynote speech, right? And without further delay, I would invite Deputy Dean Jung as a moderator. The floor is yours.
Oh, this is the last session, conclude session. It's risky, huh? It's risky. You must be very tired. So let's stretch. Let's stretch. This is the final pitch, okay? Just spend 1 more hour and then we can go home, okay? Okay. Yesterday we talked about the merits of ADR and also we checked the challenges. What's the potential solutions? And then today we explore in detail the Singapore mediation and also the mediation ecosystem. And finally, ahead of this session, we talked about the mediation in the investor states. We learned all issues. And finally, this session is for the ideas to collaborate together, how to push forward to facilitate ADR in the Pacific region. Let's get some wisdom through our discussion. This is really important. If you missed the previous session, if you awake for this session, you can get something, okay? Let's start. Okay. We have distinguished guest, the #1 guest from each organization. We have Winstra, Achita, I'm going to introduce her later, and also Christina. She's really practically charged of this very important issue in the ADB. And also Shitram, Dr. Shitram is in charge of these discussions in our ADBI. They are representative of each organization. Let's invite the real player from each organization, what kind of a plan they have to facilitate ADR in the Asia Pacific region. Let's invite Achita first. She's the first attending online. Therefore, let me introduce her a bit more. Achita is head of the Austral Regional Center for Asia and the Pacific, managing technical assistance and capacity building programs available to over 50 states in Asia and the Pacific. Achita, you have the floor.
Thank you very much. So please, I hope everyone can hear me well. And also see my
screen. We can hear you clearly.
Yes. And can you also see my screen?
Yes, we can see.
Okay, that's great. So thank you very much for the introduction, Deputy D. Jung, and distinguished speakers and participants at the end of a very fruitful and long 2 days. Greetings from Uncitral RCAP, located in Incheon Republic of Korea, with special thanks to ADBI, ADB, the Ministry of Justice of Japan, and other supporters for this great opportunity. In my 7 minutes, I will discuss UNCITRAL activities in the Asia Pacific to support the adoption and uniform interpretation and application of the UNCITRAL frameworks on mediation that you've been hearing about, also on arbitration and other UNCITRAL legal texts, which would then inform perspectives on future activities and international cooperation to promote ADR in the region from our perspective. So UNCITRAL's mandate is to further the progressive modernization and harmonization of international trade and commercial law. To this end, UNCITRAL texts are developed and endorsed through an international process to ensure that they are widely accepted as offering solutions responsive to the contemporary commercial landscape and reflecting worldwide consensus of the different legal and economic systems. To promote the use and adoption of UNCITRAL texts by states and other stakeholders, the Secretariat also undertakes the provision of technical assistance and capacity building. And the core of my office of UNCITRAL RCAP's work lies here, servicing approximately 60 jurisdictions in the region. RCAP is UNCITRAL's only regional center, opening its doors since 2012 in Incheon and operating with the generous support of the Korean government, also Hong Kong, China, and the government of Japan recently became a contributor for which UNCITRAL is most grateful. So UNCITRAL works with a wide range of partners to promote the adoption and uniform interpretation and application of the UNCITRAL legal text. The mediation framework is highlighted here, which Professor Park and many others mentioned today. And we also have the UNCITRAL arbitration framework and other related texts, such as the CISG, which Professor Sharma mentioned yesterday. It should be noted that while UNCITRAL develops dispute settlement texts, including arbitration and mediation rules that can be adopted and used by parties and ADR institutions, many of whom are represented here, UNCITRAL doesn't administer proceedings, nor does it keep any list of potential arbitrators or mediators, nor act as an appointing authority under the UNCITRAL rules. Because the stakeholders involved in adopting and utilizing the UNCITRAL texts are multifaceted, UNCITRAL's technical assistance and capacity building activities cater to these different stakeholders. Activities are frequently held in collaboration with partners, and assistance is provided without charge. For example, for governments interested in adopting UNCITRAL text, whether they be treaties or model laws, the UNCITRAL Secretariat stands ready to review current or draft legislation if the relevant entity so requests. And a successful example of this exercise is the collaboration between UNCITRAL and ADB, with Christina actually, who's there on stage, to advance arbitration reform in the South Pacific, which is also highlighted by the General Counsel in yesterday's opening. Yes, so UNCITRAL RCAP also hosts capacity building sessions for government officials to learn from each other, especially regarding challenges faced in adopting UNCITRAL texts, and to hear from the Secretariat on these issues and the latest developments. For example, the UNCITRAL Academy during Singapore Convention Week is co-hosted with the government of Singapore, and the ADR special session during Seoul ADR Week in conjunction with the Korean Ministry of Justice and KCAB International. In addition, RCAP organizes dedicated capacity building sessions for the judiciary, which focus on the uniform interpretation of UNCITRAL texts, including discussions of case law on these texts. For example, the UNCITRAL Asia Pacific Judicial Summit held during Hong Kong Legal Week in conjunction with the Department of Justice of Hong Kong, China, also with special support from ADB. To reach a wide range of stakeholders, the UNCITRAL Secretariat also participates in awareness-raising conferences and other activities to the extent possible as our resources allow, and we look forward to continuing these collaborations and to working with new partners to further expand our reach. UNCITRAL also collaborates with institutions of higher learning to educate future generations, and I think I saw some questions on this yesterday. So the UNCITRAL Days is a global academic series that aims to increase awareness of how legal harmonization facilitates international trade and investment amongst law students, academics, and other stakeholders. UNCITRAL RCAP spearheaded this initiative in 2014 by launching the UNCITRAL Asia Pacific Days, which have annual themes on a range of UNCITRAL topics. For example, the 2024 AP Days celebrated the 10th anniversary of the UNCITRAL transparency standards in treaty-based investor-state arbitration, and totaled 21 events in 14 jurisdictions across the Asia Pacific. We delivered in person, virtual and hybrid modalities, and also in Chinese, English, Russian, and Korean with our partners. And if any academic institutions present here are interested, please reach out to uncitral.rcap@un.org anytime. So enactments of UNCITRAL texts help advance legal harmonization. We all know this is true, But in practice, as all us lawyers know, harmonization, including on arbitration and mediation, also requires that the laws concerned are interpreted and applied in a uniform manner. Many UNCITRAL texts, including the conventions and model laws, reflect that understanding by providing that in the interpretation of the text, regard is to be had to its international origin and to the need to promote uniformity in its application. To this end, UNCITRAL established in 1988 the Case Law on UNCITRAL Text Database, or CLOUT, to collect and disseminate information on judgments and arbitral awards related to UNCITRAL texts. Abstracts of these case law included in CLOUT are freely accessible on the UNCITRAL website in the 6 official United Nations languages, together with their respective judgments and awards in their original language. And the CLOUT database is searchable by jurisdiction and by UNCITRAL instrument. For example, we have recent cases with tangential relevance to the Singapore Convention on Mediation, so you can look those up in case you're interested. And we have almost 600 cases that interpret in a uniform way the UNCITRAL model law on international commercial arbitration. So CLOUT is also updated
Achita,
regularly.
would you wrap up? Would you wrap up, please?
Yeah, I'm almost done.
Would you wrap up?
CLOUT is updated regularly with new case law. So if you're interested, you can subscribe to the newsletter on the website shown on your screen. And we're also interested in receiving cases from underrepresented jurisdictions in the database. And I know many of them are present today. So finally, if you'd like to learn more about our instruments with individual capacity building on your own, you can take the UNCITRAL online learning modules that also include arbitration and mediation instruments. So you can do that on the UNCITRAL website. And you can also subscribe to the RCAP mailing list via the QR code shown there on your screen. Thank you very much.
Thank you so much, Achita. You can know how the UNCITRAL to provide the support to the Asia Pacific region for the promotion this area. Now let me invite Krishna. Krishna is already introduced to you, so I don't have to introduce her again. Krishna, please introduce your plan.
Thank you so much. Well, first of all, it's been extremely helpful for ADB to partner with international standard setters such as UNCITRAL. Just to give you some context of where we are coming from. So within broader frame of ADB, there's different modalities and interventions to promote upstream reforms such as ADRs. We have policy-based programs, which are budget support programs and other types of modality. But within the Office of the General Counsel, we have our Law and Policy Reform Program, and that is the perspective that I'm sharing, I guess, our proposal to you. So next, just a little bit about our LPR program. So Tom talked about our LPR program. It's basically sits within our legal department, and it's really a program to provide the upstream enabling environment reforms. And you can see the 4 different buckets of reform, but dispute resolution is cross-cutting across, especially in PPP, private sector development, but also climate change, digital economy, and gender equality. Next, please. So basically, we provide assistance to governments in policy advice, in the design, formulation of laws. We also assist with drafting. We obviously work very closely with government lawyers, but then we also work with standard setters and model texts from UNCITRAL. And then we also try to take a more comprehensive approach and also provide the implementing capacity building assistance for implementation of whatever the law that they're enacting. And then we also do lots of knowledge sharing events, tailor-made capacity building programs, and we also generate a lot of knowledge resources. Next. Basically, these are the key stakeholders we work with, being that we're a legal office. We work a lot with attorney generals, policymakers, parliamentarians, but depending on the sector type, we also interface with Ministry of Investment, whatever's energy. So it depends on the reform, but we do interact with all the relevant ministries and also help promote sort of like intra-governmental, I guess, knowledge sharing and collaboration. Next. So in the ADR space, we've been doing a lot of work in the international commercial arbitration space. Really, there aren't that many countries left anymore that haven't signed on to the New York Convention, but a lot of the countries are now in the process of like updating, modernizing, and of course, capacity building. Next. International commercial mediation, because it's a new convention, we haven't, so this is where I think ADB can also benefit with partnerships from all of you, because this would be sort of a new area, but it is very much in demand, and we get a lot of requests to assist in international commercial mediation reform and capacity building. Next. So of course, you know, it's been highlighted that the role of the judges are critical. So we have a pretty big judicial capacity building program, and that includes ADR. We have partnerships with over 30 Supreme Courts in the Asia Pacific region. Of course, we have partnerships with CIFOC and other international judicial bodies and academies. Next. So these are examples of some of the, you know, capacity building and knowledge sharing resources that we develop in partnership with Supreme Courts, with, for example, ASEAN Council of Asian Chief Justices. We built out their e-platform and did an e-learning module. We also do case-based, we apply a lot of like a practical case-based capacity building. Next. And then I think a lot of people mentioned, you know, it's important to build awareness with the users. So this is a recent training in Uzbekistan with entrepreneurs. So we have a partnership with different academic and I guess Chamber of Commerce, Foreign Investors Council in doing user awareness seminars on ADR. Next. And then we launched a technical assistance in 2023 on I guess, strengthening capacity in investor-state disputes. And Annette is one of our key experts. So this is another area of cooperation. Next. So I think this is my last slide, and this is really the core of, I guess, the point of this session. So I think just learning from everyone the past 2 days, learning from your suggestions. I attempted to pull together what sort of everyone says in terms of cooperation. It's clear that the ecosystem is here to cooperate. And I guess one of the, well, so what's next? I think that's the question. So I think our proposal is to establish a joint network to coordinate and collaborate on ADR reforms, capacity building, knowledge sharing. And I guess from the state's government's perspective, when we go on the ground, there's a lot of different people working in this space. So sometimes we get the feedback, not just here, but also law reform generally. So they would say, you know, what's really helpful is that, you know, you get together and come to us because they're also overcapacitated. And then frankly, all of us are very, you know, it's very tight on resources, also staff time, expertise. So I think this has been a wonderful platform, wonderful knowledge sharing to create something like this. So this is just a proposal to sort of create this network to come together and then have a systematic way of working together. So perhaps we could have sort of like a really easy, like short governance document, how we will work, maybe convene quarterly, and then maybe have something like this annually. So these are just some suggestions that I got from all of you. So many thanks.
Thank you so much. Thank you so much, Krishna. The last part is a really very important thing. Please consider this one very seriously. You know, network, joint network, for collaboration on ADR is kind of a very powerful institutionalization method. If we get together periodically and share the knowledge and have some wisdom to push government officers to take this Singapore Convention, it's a really amazing way. Let's talk about it later further. Okay, and then let me invite Sitaram. She is the first time to appear on the stage. Let me introduce him shortly. Sitaram, Dr. Sitaram is a currently a senior consulting specialist for capacity building training project at Development Bank Institute. Dr. Shitaram is currently visiting professor at the Center for Spatial Information Science, University of Tokyo, Japan. Shitaram, please.
Thank you very much.
What kind of a plan do you have?
First of all, before going into the plan, let me take this chance because as part of the team organizing this, a big congrats to Deputy Dean Jung for really spearheading this and shaping this, and my colleagues Nohyoung and others. We brought all of you. Today is the last session, so we want to celebrate that what we planned only a few months ago, and it was the year end. All of you were able to come. Thank you all for really making it to Japan. Our dean was saying it's normal weather you brought, but I know for some of you it would have been very cold these few days, but we are very happy that you stayed with us. So let me bring what we have thought at ADB Institute. We kind of sowed the seeds for this 2 years ago when we started online programs with the help of Florian Grisel, who was there in the last session on learning about alternate dispute resolution. And with his help, after delivering the program, next slide, please, we published a policy brief which captured the key messages, and I think that set the tone. So when Deputy Dean Jung joined us, he was asking, oh, you already started doing ADR and let's do it full blown. So then we reached out to the Office of General Counsel, and Christina Pak is here, and also the General Counsel Thomas himself, and we are now here, and we've got a roadmap actually what to do. So what we learned from this is, this brings back to some messages that I've learned when I was young. There are some sayings in India that there are 3 professions in society that should be there if society is doing well, but you have to pay them very well. So we need to prepare and invest in them. They look very obvious, but we can know that we are doing it. The first profession is medicine. You know, doctors are needed, but we don't want to go to the doctor always because we want to be healthy. But we will buy insurance, medical insurance, to make sure that when we go to the doctor, we can afford to pay them and get treated, right? The second profession that society needs is national security, the military and the police and so on. We don't pay them individually, but we pay them through our taxes, right? The country should be able to afford it so that we don't feel vulnerable, and nobody wants such situations to happen. But the third profession, which is very relevant to today's discussion, is they say that if society is very happy and is harmonious, they will have minimal disputes. But when they have disputes, we need to go to lawyers. And that can be quite expensive, again, as was discussed in the previous session. So the insurance for that is maybe what the topic of our conference here is, the alternate dispute resolution, right? It's less expensive and more amicable. And if we can do that, all the more better. So I think we sowed the seeds to really build a way that how we can mainstream or improve the knowledge for practitioners, and how as multilateral development banks, we can play a more proactive role. And this is where Asian Development Bank Institute plays a role. Of course, my colleague Christina talked about what ADB is doing in a formal way. We can bring knowledge, and we can also bring many players. As Dean mentions, we have the convening capacity to bring together, and we're very happy the General Counsel's office convened together with us, and many other parties have come together. So we can be very agile, nimble, and we can share new knowledge which will be relevant to various stakeholders. Next slide, please. So in that sense, what we have found out is the challenges that we are looking at is the institutional gaps, particularly, because many governments and countries want to do something, but they haven't got the legal provisions, or they haven't got the political mandates or the approvals, and they need a gradual step forward. And for that, these kind of meetings where there's a peer learning or peer influence really help a lot, rather than country by country or individually doing. So I hope that today's conference kind of set a new tone, where it was mentioned about how many countries have signed up for the Singapore Convention. So some others who have not yet signed up may now want to go back and report to their countries and so on. Next slide, please. Then comes to the learning. Learning can be in many parts. My father was a teacher, and he always said, if you want to score up to 80 marks out of 100, you can just study the textbooks. But if you want to score more than 80 marks, it's something else. What is that? It is learning to avoid mistakes. And that teacher can teach you. So you need to, because the teacher gives exam questions where he's looking for how you can make a silly mistake or how he can give you a tricky question where you can still make mistakes after having read the textbook. So learning from a teacher and course-based learning is very important. But many government officials don't have the luxury or the time to go to a university again and take a 2-year master degree program or so. So here is where ADB Institute can come in. We can offer the same course that a university student would get in a compressed way for government officials who can learn and actually learn to solve problems and learn to avoid problems in their actual projects. So I'm very happy that Christina shared case-based learning. We also have featured case-based learning with a professor called Francis Fukuyama from the Stanford University. And we learned that it had a lot of impact on the students as well as the participants. And being in Tokyo, we are able to mingle the learning together with actual graduate students. At the back, you're seeing today with us many graduate students from the public policy school who are also attending this course. So these kind of learning is even more impactful because officials can learn with the next generation, future leaders who want to learn these practices. So let me stop here and hand it back to Deputy Dean.
Is it on? Yeah. Okay. Thank you, Sitram. Thank you, consider the time constraint. Thank you so much. Okay, we invited again the representative of the arbitration institutions. Let me introduce them extremely shortly. Mr. Yoshiro Takatori, a special advisor of Nakajima Uno, Tsunematsu, JIMC. The next.
Okay. Yeah.
Just I'll hold a second. Hyunsuk, again, Hyunsuk is a KIMC, Korea International Mediation Center, and David is missing, and Fei is a director at the CTEC, right? And Wiming, the Singapore International Mediation Center, and the J, the Singapore International Arbitration Center. Okay, because you appeared already. Okay, let's talk about this one. Let me ask this question. Actually, Ustral, ADB, and ADBI introduced their plan and their activities. My question is that, what are your views on the plans of or activities Ustral, ADB, and ADBI, and which plans or activities are you interested in collaborating on? Additionally, could you share your institution's plan to promote ADR in the Asia Pacific or in your jurisdiction? That's first question. Please. From this order. Okay.
Maybe 3 minutes or something. Listen.
I'm going to give you 2 minutes.
2 minutes. Okay. Yes. So cannot go through. So first page, please. Just briefly introduce the Kyoto or Japan International Mediation Center. First, I would like to emphasize the why Kyoto. Kyoto is the place for meditation. So-called mediation and meditation kind of things. So Kyoto is an important city. And then autonomous sphere of the Kyoto, gardens, temple, shrines, and famous international mediator favors Hawaii as a place of mediation for similar reasons. And then JMC Kyoto has an option of the Kodaiji Temple Shrine as the meditation facility. So next page, please. So just a comparison between the traditional historical mediation and the Japanese practice versus the kind of a global facilitative mediation. So we need to really do have a kind of training for kind of even for the hybrid. So next page, please. So equipped with the good standard hardware and software. So mediator panel with diversity, a global standard mediation rules, and speedy procedure with the global standard something. So next page, please. So I should, the joint protocol, I should skip because I've already shown with the J. Then next page, please. Again, please visit this link if you're interested. Then final 2-page, nice photos, please show it. Kyoto Doshisha University's nice facilities and perfectly equipped. Then simultaneous interpretation booth. So simultaneous booth is not suitable for arbitration, my sense, but mediation, that's good. So it's a final page. The nice temples, shrines. So my suggestion is getting back to your questions and answers, how to collaborate. For example, like we can do like a mock made up in temples facilities, inviting ADBI people and SCMC people, SIMC people, and Hong Kong people or something. So we can show actual mock mediation to the public within the facility of the temple or something. So that's a kind of one kind of a training. And so you should show how concretely the proceeding is going. So that's my idea. Thank you.
Thank you so much. Thank you so much. Thanks to the absence of David, I can give over time, 30 seconds, something like that. Okay, Hyun-sung.
The moderator gave us 3 questions. And the first, what are your views on the plans of Austral and ADB and ADBI? First of all, I think the mediation training program designed by the ADBI is very useful and beneficial. If public official become mediation friendly through the training program, mediation will spread rapidly in their country. As a result, they will enact laws that promote mediation, and they may mandate mediation in the contract used by the government. Additionally, I would like to recommend one issue with the training program. How about introducing a certification system? It would be an important motivation to increase the efficiency of mediation education program. And the second, which plan are you interested in collaborate on? Of course, KIMC will also actively participation in ADB and ADBI as mediation promotion project. First of all, there will be way to utilize promote ADBI program for mediating program in Korea, and we can include a mediator who took ADBI mediation training in KIMC mediator, and so on. We will continue to keep in touch and explore ways to further collaborate with the ADB and ADBI. And the last question, can you share your organization's plan to promote ADBI in Asia Pacific region? Yeah. In the morning, I talk about the supply chain mediation. So our KIMC have a plan to establish the supply chain mediation center in Hanoi, Vietnam, because there is so many Korean companies such as Samsung Electronics and LG Electronics, and also there are local suppliers in Vietnam. So we would like to cooperate with Samsung and other Korean company to establish the disputes mediation institution. And they also think that is the management of the ESG management. Okay, next time I will explain more detail. Thank you.
Thank you so much. Hyun-sung is a really great professor because he kept the question that I raised, answered it exactly. I love that. Okay, Faye, would you show me?
Hello, can you hear me? Yeah. Thank you, moderator. I would like to answer your second question first. How do we plan to promote ADR? Well, actually, there are several approaches. One is, of course, to do a lot of research work based on the demand of the users and also the trend of the industry to optimize our rules and the practices. That's the infrastructure work, I would say. If you look at the rules of different institutions, you will find them very similar to each other. However, the practices are very different. So what we are trying to do is to integrate the different practices. For example, the way we deal with evidences are different from the common law system. And so we encourage limited discovery, limited course examination, so that we encompass different needs of different parties from backgrounds, from various backgrounds. And that will increase I would say, attraction of arbitration or mediation, whatever ADR, to the users. That's the first approach. And second, of course, is like a lot of promotional activities. You probably have heard about the different ADR arbitration weeks going on in the world. It's like not a week that we do not have an arbitration or ADR week. So we have that as well. A lot of promotional activities. The China Arbitration Week have gone through like 13 to 14 years already. And this year, it is going to be from like 15 September to 21st. If you are available, then you're all welcome to visit Beijing. And also the third approach is, of course, capacity building. But here I would like to emphasize, the training of the next generation, which is the university, law school students. We have done a lot of cooperation with law schools. And also we have done the pre-mood, office mood for already 23 years. So that is influence, I would say, far-reaching, and will sort of help the future deciders of this industry to realize the merits of this ADR mechanism. But all in all, based on, all those measures cannot be achieved without international cooperation, of course. So I totally agree with what Christina put it. The network building is very important, so that every year we do a lot of international cooperation. We have built a lot of platform, which I think I do not have time to illustrate or to elaborate. But anyone who is interested may find the time that we can talk on that. And I think we have done a lot of interaction with UNCITRAL. We support almost all the initiatives of UNCITRAL. And also this, I think, is the first time that we are involved in a ADB and ADBI activity. And I regard it as a good beginning, and I hope there will be many more continue. Thank you.
Thank you so much. Okay, Wimin.
Hi, thank you. So maybe I'll just first of all answer what SIMC has been doing. Obviously, Asia is home, and we are very focused on 4 key countries: China, India, South Korea, as well as Japan. But of course, the other countries around ASEAN is also critical. So we have a lot of collaborations with different centers to promote mediation. I think it's very important to identify who the stakeholders are, first of all. So whether it's the government, whether it is the courts, whether it is the businesses, or whether it's the lawyers, because the different stakeholders have different interests. And unless you address the interests, it's hard to be sustainable. So perhaps what we can do together as a team is ADB and ADBI will be very effective as a convener. And we can bring different groups together, and certainly you will be able to identify who the critical stakeholders are who can make a change in either the laws or introducing it in courts, or who the business federations are who are effective in helping to introduce it to the businesses. So I do see a lot of opportunities that we have. One thing that I will just point out is that in the mediation trainings that we do, we normally do it in person as opposed to online, because it's just much harder to be effective online for certain types of training. So it's just something that we have to bear in mind. I mentioned during my presentation, we've done mediation trainings for more than 600 practitioners. All of them are in person as opposed to online. So it's a big investment, but we find that those are the ones that really make a difference in the individual's lives. Thank you.
Thank you so much. To some extent, I agree with you, because the appearance on the online and the in-person speaking is a bit different in terms of influence. I totally agree with you. And then Jay.
Thank you. Do I have 2 minutes or 2.5?
Plus 30 seconds.
Okay, thank you. So I have a stopwatch now. I just wanted to first address the second question. SIC's approach to the market is, it depends on the maturity of the jurisdiction. So if there's a more sophisticated jurisdiction, we try to tell them the details of the differences between arbitration institutions and the rules and our rules and everything. And if it's not well-established market yet, then we have to start from the very beginning, like what is arbitration, and maybe start doing events first. This is related to the first question that I wanted to answer. I was a little worried of the 2 days discussion overall, that it sounded too much like arbitration and mediation is separate, and we have to compete with each other, not just the institutions, but also the 2 different type of dispute resolution itself. And I think we will only fail together if we separately approach this matter, because we've been discussing about the issues mediation has, arbitration has, and litigation is not perfect either. So I think the only way we can, and we also heard a lot of success stories from different institutions working together, like JIMC, SIMC, SIAC, SIMC, and TIAC, and the HKIC. And I think it only shows that we will get stronger together only. And if we try to deal with this separately, we will only fail. And because of that, it's very important that I think the ADBI and ADB and UNCITRAL and these international organizations give us the platform to work together with different training programs and inviting government officials and giving a chance to explain in detail what the differences are and the risks are, and why it can be a wiser solution not to just choose maybe consider one type of dispute resolution, but as a whole, ADR and litigation.
Thank you. Thank you so much. Now let's move to the second round of discussions. I have two specific questions. Please answer to the discussions within 2 minutes. The first question, what do you think about making common or standardized education course on ADR, including an introductory e-learning course targeting government officers in Asia Pacific region? That's the first question. Second question, what's your opinion on making guidelines or manuals to prevent and manage investor-state disputes? That's the second question. Okay, in opposite order, please, Jay.
Of course, not of course, but I mentioned yesterday that it is a great idea, I think. I shared my experience before working for the Korean government that there were many cases when they would make a certain policy or take a certain action that might trigger a future dispute. And when I tried to explain why these could be risky, it was very difficult to convince everybody because they don't have any background knowledge. For those people who are working on different international trade or even like cultural exchange or in the education industry, because I worked at the Ministry of Education, I think it'll be very handy to have such a manual where they can refer to, or if there's a person who's trying to explain these, that they can refer to, coming from a reputable international organization like ADBI or ADB. Thank you.
Okay, you may cover two questions or you may cover just one question. It's okay for you.
I've talked about online as well as training in person. I think training in person probably is more effective. However, I think there are certain things that can be done online. One of the things that in SIMC we are doing this year will be short videos. We're in the TikTok generation, so anything beyond 3 minutes is considered long. So we thought that some of these things could be reduced down to bite sizes and in series. So certainly some of these learnings can be done, and it'll be an investment, but we think it'll be effective in explaining some of the more basic points, and that certainly can be a resource that we could come back to again and again. The other thing I want to talk about is really in terms of standards and process. I'm very encouraged by what Indonesia Guru shared earlier about how you are putting into a process of pre-mediation dispute management. I think that's really important. And a lot of the tools that we learn as part of mediation, you don't have a court mediation, but these are mediation tools that you can introduce at an early stage to minimize the risks of the matter escalating. It's like dispute boards in construction disputes. It's similar. So the question will be, where do you find the expertise and how do you introduce it as a good process, and how do you have the right people to run those management process? So rather dispute management process. So that's all I have. Thanks.
Thank you. I want to echo your intervention because the setting up joint committees are part of the way to prevent that dispute. Is a brilliant idea. Okay, Faye.
Well, my reflection as to this question actually is sort of paradox because I'm both optimistic and pessimistic. First, of course, I was very hands-on for this kind of guideline or manual because it's the existence of itself is a position showing the encouragement of our prevention and attitude towards prevention of the disputes. However, taking into consideration of difference among different cultures and ecosystems, well, it's very difficult to really find a standardized criteria or a textbook for each jurisdiction. For example, for the past 2 days, we have talked a lot about the double hatting of one person as mediator and arbitrator. It is very well received in China because in our doctrine, there is old things like be it white cat or black cat, it is a good cat if it catches mice. So yeah, so it doesn't really matter whether it's a mediator or arbitrator, as long as the dispute is successfully resolved. It's okay, it's acceptable to the users. So such practice, could it be standardized in this manual or not? Will remain a very big question, but it's very popular in certain jurisdictions, for example, in Japan as well, I think. So, but I think maybe just like Mr. Chen pointed out, we can make some basic elements and we can standardize the syllabus of the program instead of, a uniform content of the courses. Yeah, that's what I can think of.
Thank you so much. We have to bear in mind your comments. Okay, Hansel.
I will give an answer to the second question. There are many ways to prevent and manage investor-state dispute. I think the most common and general way is to resolving the dispute between the investor and the host country through the negotiation and mediation. So, therefore, before the investor take the dispute to the expensive international arbitration. So if such guideline or manuals contain skill and techniques to resolve investment disputes through mediation or negotiation, it will be great help to the ASEAN country. And in addition, when ASEAN country draw up investment agreement such as bilateral investment treaty or FTA, it would be good to make it mandatory. So it could, in other words, the investor have to proceed the mediation process of people they take the dispute to the arbitration.
Yeah, in that sense, the Indonesian government officer really emphasized the importance of mandatory mediation prior to the arbitration. Good. Okay, Yoshi.
Yeah. First, the first question: how to standardize? I'm the co-head of the Japan chapter of the Chartered Institute of Arbitrators, which had been doing a very efficient arbitrators training, and then we have membership, associate course membership, and then a fellow or something. It's a very successful, almost all over the world. You can be trained, and you can have a kind of assessment on your business card. So such kind of training and assessment could be utilized for the mediation side. And we have been doing like mediators training as well. It's not yet mature so much. So we should standardize although the mediation has more like a flexible options, but still you have a, kind of a standard basic concepts or something. And just second, a little bit, not only for the invested treaty type of the resolution, but I think the, in addition to the how to prevent the dispute, but also for the how to resolve comprehensively, that's a key. And then, for example, like a standard essential patent issues or something, in a multiple jurisdictions, kind of forever going on the litigations, to make it more comprehensively, the resolution, the mediation should be the key, including the investment treaty type of mediation. So for that purpose, we should be more like familiarized with the such system, I think.
Thank you so much. Actually, let's move to the next Q&A session. This question is prepared for the panelists, but I thought that this question is like this. What type of international cooperation do you believe is the most effective in promoting ADR in the Asia Pacific or in your jurisdiction? That's the questions. But this question not go to the panelists, but to the government officer. Let's listen their opinion, okay? So would you pass around the microphone? Would you raise a hand? But if you do not raise a hand, I'm going to mandatory everybody, government officer should speak something. One sentence is enough, or one word is enough. Okay, you always first. Okay, Cambodia, you got a pass.
Yeah.
You got a floor
Thank you,
first.
the moderator. Well, I listened to the speaker for about 2 days, and I see the benefit of adopting having the mediation a strong legal system in the country. Well, as LDCs, not developing country, we are doing our homework, but as you know, national authority for ADR is too young. It's about 1 year and 2 months old, and we don't have any legal law yet. So normally, Cambodia, the government asked the Ministry of Justice to give a comment on the Singapore Mediation Treaty, whether Cambodia could access to that treaty. And in this case, Cambodia, as LDCs, normally need a capacity building nationally, internationally to catch up with ASEAN and Asia Pacific. Secondly, for legal, we need a legal framework, a stronger legal framework. And thirdly, we normally need a stronger mediation institution. So that is what Cambodia needs from our guest speakers, especially for ADB and ADBI and the Singapore International Mediation Center, because we are very close in ASEAN country. Thank you.
Okay, thank you. Who will be next? Okay, Japan. You don't need it. But okay, Japan.
As I mentioned before, it might be overlapping with my previous intervention, but I really think it's a very important issue. How do we cooperate each other? And so I think there are some three key areas in terms of international cooperation. The first one is the cooperation between government and private sector. And the second one is the cooperation between government and other countries' government. And the third one is practitioners and business sectors. So we have to do everything what we can do. That's my.
Thank you so much. And then?
Thank you very much. For me, I would like to say that the most important thing is the trainings and capacity buildings, because these are the actions which are creating the specialists. But in this context, also one thing that I would like to mention is that we need to give more attention to the students, because the students are the ones who are carrying the fire, the passion to the profession, and including the mediation. And in this case, what I can see from my own practice is that the Bismuth on international arbitration is very much helping students to start loving arbitration and ADR, and maybe something in regard to the mediation mood could help to also improve the mediation. Singapore mood court would be great.
Okay, thank you so much. Due to the time constraint, just one word, one sentence. Otherwise, I'm going to stop here. Okay, just one sentence.
Okay. If you ask about collaboration in the field of the ADR, it will be definitely training in the field of mediation.
Thank you.
Just one sentence.
And then next. Okay, pass. You may pass. Okay. Indonesia? Okay, go ahead.
Yeah, we're together.
Okay. Just one most effective collaboration. What is that?
So for the Philippines, we are going to continue collaborate and push for the ratification of the Singapore Mediation, since the Philippines has been not ratified for that treaty.
Okay, ratification.
Okay, I guess training in person and training to build local capacity for ADR in Asia and the Pacific is absolutely needed. Thank you.
Capacity building. Okay, we got a full capacity building.
Okay, I already mentioned this morning, but training and awareness is vital. But I will add to that in terms of Papua New Guinea's example, we hosted an IMAC conference in 2019, and last year that was on mediation and other forms of ADR. And last year in August, we conducted a conference on climate change with emphasis on ADR. So certainly training and awareness, but also the occasional conference, although they take a lot of planning.
Okay, thank you so much. Okay, let me now turn to this floor to today's presenter, Austral, ADB, ADBI. What's your takeaways from this session? Okay, Achita, if you're there, you have the floor. Otherwise, let me give the floor first to Christina.
Sure, thank you. In terms of, I guess, advocacy, on the reform side, the data is extremely important. So it's great that the CEDRA has the study and other academic studies. I think the awareness raising of government officials who are non-technical people is critical. So I think that, the course on just the basic course, but also interlaid with practical real life examples, because unless you provide like what ADR can do for your economy, it's hard to convince, especially the Ministry of Finance or other government officials. So we say, when one country acceded to the New York Convention, it, mitigated the dispute, and actually the foreign lender went in and actually loaned the money for this project. And then when you start talking about those real life examples, then I think you get the buy-in to get the reform going. I guess on the capacity building, the implementation side, the practical aspects is so critical. That's where I think all of us, the expertise comes in, and the case base, like the role playing, is so critical. And they would love to come to your Kyoto office to do the mock, arbitration or mediation. And I remember in 2019 at the PNG conference that Justice Wood mentioned, we attempted the journey of arbitration, just to show, but we're not like practitioners. So it would be great to get help in that regard to make, I guess, capacity building like real, practical, and relevant, but also updated. So there is this continuous need, like with any education, you have to keep the curriculum updated. What is the best practice in that regard? Conferences like this, you do have to have it once in a while, just to keep updated, because things are always evolving with the times. Thanks.
Very good, thank you. And then Achita, you have the floor. Do you share your takeaways?
Thank you so much. So I totally agree with what Christina said, and to highlight that it's very important to cater to different groups of stakeholders, government officials, the judiciary, the end users, and future generations, and also at different stages of where they might be with regards to adopting, or using a particular instrument. So I think that's always important to keep in mind. So as Christina said, awareness raising is very important also at the beginning, so that government officials know that these legal instruments exist and they might be interested in adopting. And then we can help them with looking at the legislation. And then we can help with the capacity building of the judges, to understand, because they would be the champions and the safeguards of particular instruments, for example, the New York Convention, also Singapore Convention on Mediation later on. Yeah, and then the implementation, like Christina said, is where the end users come in and the practitioners, and which is where we also get to learn the new developments from what's going on. So thank you.
Okay, Chitra.
I don't want to have the last word, but I'm kind of the last person to speak. Two important messages I got is there's a lot of enthusiasm to collaborate and support. Thank you for all the partners and stakeholders. And more importantly, there's increased awareness for building capacity and also learning in person with real life examples. So we will take these on board. As I mentioned, we just sowed the seeds 2 years ago. Now we are kind of nurturing the plant. So 2027 is an important milestone year for the Asian Development Bank. It's the 60th anniversary of Asian Development Bank. It also happens to be the 30th anniversary for the Asian Development Bank Institute. So we hope by 2027 we can celebrate some success with our activity. Thank you.
Okay, thank you so much. As a wrap up, do you remember yesterday what's the purpose of this event? We really want to know whether ADR contribute economic regional integration, regional economic integration, or economic developments. Dr. Hyun-Suk Professor clearly mentioned that if we, many the Asian countries, Asia Pacific countries ratify Singapore Convention, then we can save our money. With the mediation, we can solve our disputes. And then our trade increase, investment increase. It means our economic growth, we can show that. So we can see that. So that's the reason I think it's very important. Then how to achieve that goal to persuade the Asia Pacific member country ratify Singapore Convention? Keep trying. How? We set up this platform, and then you get together and get wisdom and get energy and return to your country, push your Congress and politicians and your ministers to adopt this one. This is a very important one. That's the thing, how we can change the world. In that sense, I think this concludes the session. You did a great job. Thank you so much.
Thank you. Thank you very much, Ms. Yu. Wow. I mean, these 2 days have really been exciting. And one of the things that really just caught my attention was so many times I heard the phrase, wow, this is the first time that I've come to an event that ADB and ADBI have done together, and how appropriate that it be on this critical topic of ADR. This is something that I think maybe is a first, but I want to assure you will not be the last. And I think the last session really wrapped it up so well. I mean, if you think back over it, and I've been taking notes, through this time, I just want to first of all express thanks to all of you for a very valuable, a very, I think, probative, a very deep discussion, and fundamentally a very optimistic discussion. I'm glad someone used my metaphor of the glass half full, because at the end of 2 days, I feel that we're very much in a glass half full paradigm now. We had a lot of discussions about the room for growth in ADR, and particularly in mediation, and it's really highlighted the critical importance of ADR for the Asia Pacific region particularly, and how Asia Pacific can become a leader globally for ADR uptake. Now, one of the things that I think just jumped out, I mean, really fundamentally, was how Asia Pacific countries consider ADR to be a central part of sustainable economic growth for them. That's not to be mysterious here. Why is ADB involved in this? Why is ADB interested? Because we are an organization fundamentally committed to economic development and growth in the Asia Pacific region for our DMC countries. So happy that we have a dozen or more of our developing member countries here. And I think that's the link that has us so excited about this, because there is a direct connection between promulgating and getting uptake from these ADR initiatives and more economic growth, more mobilization of private sector capital, more FDI coming in, being allocated to the critical climate finance and other economic development needs that you have. So that's going to be really important. Second, I think we had a lot of discussion around the importance of an ecosystem approach, which is really required to effectively support all of these ADR systems, and particularly with mediation. It was great to see so many representatives of cutting-edge mediation organizations around the region. And third, it's the recognition that mediation is another powerful tool to really mitigate dispute risk. Again, if you're a private sector company looking at an investment decision, the thing that's going to make an environment unfriendly for investment is risk of prolonged dispute resolution, prolonged and costly litigation with uncertain results. So for that fundamental point, it's really critical, I think, to have ADR. You can see why it fits into development strategies so well. So big question. Where do we go from here? Nice conference, 2 days. Are we going to go home and forget about this? I really hope not, and I think not. And I'm particularly excited by the last presentation about the potential to launch the Asia Pacific Joint Network on Coordination and Collaboration on ADR Reforms, Capacity Building, and Knowledge Sharing. Wow, that's a mouthful. Someone needs to find a really good acronym. We might even need an acronym for the acronym because it's pretty long. But there's a lot of rich content in that. That's why it's long. And I think this common platform to consolidate and coordinate all of our collective responses and expertise is going to be critical to success. And based on the last 2 days of discussion and the energy around moving this forward, I'm very confident we can do that. And I want to assure you that you'll have the support of ADB. I'm sure you'll talk about ADBI, Deputy Dean, and of our Office of General Counsel, which will provide the support. I heard you talking about going back and mobilizing your countries and your ministries, and we can support too with technical assistance, with policy-based lending, with other things that can help support you so much. We need to avoid double work. We need to avoid reinventing the wheel. And the good news here is that there are so many great practices. Part of what we're doing is to disseminate those and make sure that we all benefit from each other. So again, let me thank all of you for being here and making this a great success, and more importantly, a great start to a road that we can drive along together. Thank you very much.
Thank you, Mr. Clark. And the next and final closing remark will be yours, Deputy Dean Jung.
As we conclude today's discussions, I want to express my sincere gratitude to all of you for taking the time to join us and share valuable insights. This has been a truly great opportunity to witness strong commitment from governments, international organizations, ADR institutions, and experts from across Asia Pacific region towards expanding ADR. Your collective efforts are vital for advancing this cause, and we deeply appreciate the time and thoughts you contributed to this event. To ensure that our conversation over the past 2 days lead to real, measurable progress, I propose that we collaborate with the ADB, ADBI, UNSTRA, and all attending institutions to make education course aimed at enhancing capacities of government officers. While some international organizations and ADR institutions offer education course, a common and standardized education course tailored to government officers in Asia Pacific countries, including e-learning program adopting AI function, will greatly facilitate ADR in this region. Furthermore, I suggest that we develop a practical manual or guidelines for the prevention and management of investor-state disputes. Educating government officers based on these guidelines would enable each country to develop their own manuals tailored to their specific circumstance. Looking ahead, concurring ADB's proposal for the Asia Pacific Joint Network for Collaboration on ADR, we hope to hold another international conference next year to track our progress and implement ADR promotion plans presented today and share the result of our collective works. I really looking forward to continue your strong interest and support in these efforts. Finally, I want to acknowledge that today marks ADBI's first grand-scale ADR event, made possible thanks to the dedication and influence of many institutions and individuals. A heartfelt thank you to co-hosting organizations, ADB, UNSTRA, the Ministry of Justice of Japan, and speakers who utilize your networks, bring together such esteemed panels. Finally, I really want to express my special thanks to the staff who worked tirelessly behind the scene to ensure the success of this event. Please give them one round of applause. Thank you once again. I look forward to continuing this very important journey with all of you. Thank you so much.